Chairman, you ready? I am indeed. Good. Rules Committee will come to order, and thank you very much for joining us this afternoon. As the Rules Committee gets back to work, today the committee will consider House Joint Resolution 111 as well as H.R. 3219, the Make America Secure Appropriations Act of 2018. H.J. Res. 111 utilizes the Congressional Review Act to overturn a Bureau of Consumer Financial Protection rule related to arbitration agreements. This anti-arbitration rule requires companies that choose arbitration to absorb additional costs associated with arbitration along with class action litigation costs that are forcing companies to regulate disputes within the judicial system. Making consumers pay more for less is the exact opposite, I believe, of what consumer protection is about, and contradicts the CFPB's mission statement of protecting consumers in the financial marketplace. The committee will also consider H.R. 3219, the Make America Secure Appropriations Act of 2018. This legislation contains fiscal year 2018 legislative branch appropriations bills, the fiscal year 2018 Defense Appropriations Bill, the Milcon VA Appropriations Bill, and the Energy and Water Appropriations Bill. H.R. 3219, I believe, demonstrates a strong commitment to national security, boosted by the funding for the Defense Department by $68.1 billion over last year's enacted level. And I see nothing more important than ensuring the men and women of our armed services have the necessary resources, the tools, the funding, and most in particular, the support of the American people at a time when the world has become not only more dangerous, but more complex. The legislation also provides necessary funding for the medical care of over 7 million VA patients and continues to address the VA disability backlog that we have known and been working on for years. It also boosts funding by 25% for construction of critical military infrastructure that keeps our troops prepared and healthy. The Energy and Water section of the bill increases funding for the Department of Energy's nuclear weapons security program to a total of $13.9 billion, fostering a strong nuclear deterrence posture as threats continue to rise from rogue nations around the world. Legislation also addresses concerns related to the safety of the Capitol complex, local district offices, and staff from recent events that have impacted our lives. $7.5 million in new funding is provided for Capitol Police, and $5 million in new funding included to support projects related to district security. I'd like to welcome the gentleman from Texas, the gentleman, Mr. Henschling from Dallas, Texas, as well as the gentlewoman from California, who I'm delighted to see once again, not only to come up to the Rules Committee, but also to hear from Maxine Waters on our first panel. Please note that we will conclude consideration and vote on the rule for H.J. Res. 111 before we proceed to the testimony on H.R. 3219 with our witnesses from the Appropriations Committee. We have notified the general membership that if they wish to testify on their amendments to H.R. 3219, they should be available and be prepared to testify before the Rules Committee this evening on our fourth and subsequent panels. I would anticipate that the Rules Committee will be in till approximately 11 o'clock this evening, making ourselves available for members who would wish to come and give presentations about their amendments. So that is the way it looks as of now at about 5:15. I'm delighted to welcome each of our visitors to the first panel, but without objection, anything that they have in writing, that will be entered into the record.
Chairman,
without objection. And the gentlewoman
I have an opening statement.
The gentlewoman is recognized for.
Thank you, Mr. Chairman. Representative Barbara Lee had an amendment in this DOD appropriations bill on the fact that we are still using a 2001 AUMF authorization to use military force which every president since 2001 has used it with abandon. We understand later that the fact that everybody adopted that bill in bipartisan vote, I think it was unanimous almost, that it was somewhat of a hoax and was really replaced with another bill totally overnight. Now, we're here considering the same bill with one important difference. It no longer has her amendment. And even though I'm not really sure what the idea was to replace it with another one, but no member voted to take the amendment out. It wasn't debated, and it happened behind closed doors. We're very concerned about process, and we talk about it a lot. But again, you're also apparently going to self-execute an amendment that funds the president's offensive, expensive, and ill-conceived border wall, which I don't believe is even germane. And I say apparently because we've not been a part of this process. Once again, there won't be a separate vote on one of the most controversial items we will be considering this year. This decidedly undemocratic process is becoming a theme. When we considered your health care bill, and I can hardly think of anything more significant or controversial, the biggest decisions were made in the back rooms. They were made without open debate or committee action or opportunity for Democrat input. In fact, the entire bill was passed without a single Democrat being able to be involved in it. Now, I'd like to compare that with the passage of the ACA. The New York Times yesterday on page A19 did a remarkable chart, published an article, quote, Obamacare included Republican ideas, but the GOP health plan has left Democrats out, end quote. The article starkly contrasts the process for the ACA, in which 188 Republican amendments were adopted, with the Republican repeal process, which has indicated 0 Democrat amendments. And that's 0, none. I'd like unanimous consent to insert the article into the record.
Without
objection.
And
I thank
that
you.
New York Times article will be presented to
Very
the
good.
record.
Thank you. I think we have the article here someplace, somewhere. All right, good. Thank you, Mr. Chairman.
Yes, ma'am.
I want to welcome these two as well to the Rules Committee.
Thank you very much, and I appreciate the gentlewoman's feedback about the what is called the wall, about the AUMF, and about health care. And I know the gentlewoman has ideas about those, and we will be very pleased as we move on. If people have, as members have questions about that, I'll be glad to engage them, and I'm sure we will have time today to do that. Before we go too far, I want to announce that we have several police officers and their families who are here who happen to be from Wiley, Texas, which is within the 32nd Congressional District. That is myself. And they've come up to visit not only Washington, but to the Rules Committee. We have Michael Stewart, who's a Wiley, Texas police officer, Alyssa Stewart, who is his beautiful young wife. We have Madison Stewart and their 7-month-old child, and she was in my office as I walked in. Big old smile from that 7-month-old child, Madison. Jeremy Stone, who's a Wiley police officer. Savannah Fortner, who's his fiancée. Michael Hareshmanto, who is a police officer from Wiley. Natalie Freeman, who is a Wiley police officer. Alania Nelson, who is a family member, and Hannah Nelson, who's also a family member. And we want to welcome them not only to the Rules Committee, but thank them for their service not only to Wiley, Texas, but really as part of the police family, law enforcement family of this country, to thank them for their service, not only for the officers, but their families who are here. And I want to thank them myself.
I do too. A welcome to you. It's nice to have you here. We always appreciate our first responders and the fact that you put yourselves on the line for us. Thank you for that.
Thank you very much, Louise. Mr. Chairman, I'm delighted that you're here. I would encourage, as you know, to make sure that green light's on when you speak. And the young chairman from Dallas is recognized.
Thank you, Chairman Sessions, Ranking Member Slaughter, all members of the Rules Committee. Thank you for the opportunity to testify before you on House Joint Resolution 111, a measure to overturn the CFPB's anti-arbitration rule pursuant to the Congressional Review Act. I will attempt to be brief in my remarks today. Simply as a matter of principle, policy, and process, Congress should and must reject this rule. First, as a matter of principle, something of this importance and magnitude should only be enacted by the people's duly elected representatives, in other words, us. In a representative democracy, no one unelected, unaccountable individual should, with a stroke of a pen, be allowed to abrogate our fundamental contractual rights, which is exactly what has been done by the CFPB. In the CFPB, we have an agency that by design and by practice operates outside of checks and balances, outside of the control of the president and the people's elected representatives in Congress. Until it is reformed, it can make no moral claim to the legitimacy of its actions, and Congress should reject its owner's rules as a matter of course. Second, as a matter of policy, the Dodd-Frank Act requires that this rule be consistent with the findings of a study mandated by Congress. In this rule, the CFPB seeks to eliminate class action waivers in financial services contracts, which will have the effect of forcing consumers to litigate their claims, no matter how small, in court rather than through alternative means. One of the problems with this rule is that the policy it embodies, preferring class action over arbitration, is contrary to the empirical evidence in its own required study, which found that arbitration is more likely to reach a decision on the merits, provide swifter resolution at a lower cost, and result in a higher average monetary recovery for an individual consumer by 2 orders of magnitude. Specifically, the CFPB's own study concluded that arbitration is up to 12 times faster than litigation, and in their own study, the CFPB concluded that consumers who obtained relief in arbitration recover on average $5,389, contrasted to the $32.35 for the average class member recovery. Simply put, this rule is bad for consumers. Third, as a matter of process, the Financial Services Committee has sought information regarding this rule from the CFPB for well over a year and has had even to subpoena the information when the CFPB refused to voluntarily comply. The CFPB is in default of the committee's subpoena and yet still finalized the rule in spite of Congress. I would also note that in the Unified Regulatory Agenda just released by OMB, the Bureau indicated this rule would be finalized later. Instead, the CFPB has rushed out the rule here in early July as a surprise for reasons that unfortunately appear to be motivated not by sound public policy, but instead to help the very powerful trial attorneys lobby. For all the foregoing reasons, I urge my colleagues to reject the CFPB's rule by supporting the resolution offered by Representative Rothfuss, and I look forward to answering the committee's questions, and I also would like to add, Mr. Chairman, hot off the press, we have a statement of administration policy on HJ Res 111 that says, quote, the administration strongly supports House passage of HJ Res 111, and I would ask that be included in the record.
Without objection, that would be included with the gentleman's addition. Whatever he would wish to submit would be included. Thank you very much. Mr. Chairman, thank you very much for taking time for your succinct and professional presentation. Ms. Waters, I'm delighted that you're here and the gentlewoman's recognized.
Thank you very much, Chairman Sessions and Ranking Member Slaughter. I thank you for having us here today. This is a very important issue, and I strongly oppose this resolution. HJ Res 111, which invokes the Congressional Review Act, or CRA, to repeal the Consumer Financial Protection Bureau's rule banning the harmful practice of forced arbitration. Forced arbitration refers to the practice of inserting restrictions into contracts for products like deposit accounts and credit cards that prevent the consumer from being able to sue a company or join other consumers to sue a company in court before a jury when the company wrongs them. Instead, consumers are forced to go before an arbiter. Arbitration proceedings happen behind closed doors, Often consumers do not even receive the terms or conditions of the rulings. There is no judge, no jury, and no right to appeal. And the hearings heavily favor the big banks and their hired attorneys. Major companies like Wells Fargo have buried forced arbitration clauses deep into their contracts. In fact, Wells Fargo continues to assert forced arbitration to block consumer attempts to fight back against its egregious fake account scandal, where the company victimized its consumers and fraudulently opened millions of fake accounts with their personal information. The damage caused by forced arbitration contracts is well known. The Department of Defense concluded in a 2006 report that, quote, loan contracts to service members should not include mandatory arbitration clauses or onerous notice provisions and should not require the service member to waive his or her right of recourse, such as the right to participate in a plaintiff class. Waiver isn't a matter of choice in take-it-or-leave-it contracts of adhesion, quote unquote. When Congress passed the Dodd-Frank Wall Street Reform and Consumer Protection Act and created the Consumer Bureau, we directed it to engage in a deliberative process before it could ban forced arbitration. The Consumer Bureau's lengthy review stands in sharp contrast to Chairman Henselin's own review of this issue. The Consumer Bureau conducted a thorough study and publicly released its findings in March of 2015. Later that year, in October 2015, the Bureau published an outline of the proposals under consideration and convened a small business review panel to gather feedback from small companies. The Consumer Bureau also sought comments from the public, consumer groups, industry, and others, all before even issuing a proposed rule. In May 2016, the Consumer Bureau issued its proposed forced arbitration rule and received more than 110,000 comments. Mr. Chairman, I would ask you to compare this process to the one my committee has undertaken. Our committee has not convened a single hearing on forced arbitration and received no witnesses to testify on the matter. Our committee has not convened a single hearing. Yes. Our committee has not convened a single hearing on the Consumer Bureau's rule either, and our committee certainly didn't consider this measure before you today. To my knowledge, the only action my chairman took with regard to the Consumer Bureau's rule was to write a letter threatening its director with contempt charges if the Consumer Bureau complied with the law and finalized this consumer protection rule. If my colleagues on the other side of the aisle did take the time to look at the Consumer Bureau's rule, I think they would find a lot to like. The rule is not only about consumers, but also about a fundamental principle of our democracy, that each of us has a right to trial by jury, if we so choose. Accordingly, the Bureau's rule restores this right to American consumers by giving them a choice between arbitration and the free exercise of their Seventh Amendment right to a trial by jury. The Consumer Bureau's rule also follows a clear precedent set by Congress. We have already prohibited arbitration agreements in residential mortgages, our nation's largest credit market, as well as in many products for service members and their families. Consumers themselves are overwhelmingly supporting this effort to give them the ability to have their day in court. 310 organizations, including consumer advocacy, civil rights, and faith-based groups, 256 law professors, and the Military Coalition, an organization that represents 5.5 million service members, all stand behind the rule and oppose this resolution. The main groups supporting H.J. Res. 111 are the very groups that want to peddle credit products to consumers but be able to hide when they cause harm. We should not be helping bad actors on Wall Street and elsewhere to avoid accountability by never stepping foot inside a courtroom. So I thank you for yielding time, and I would be happy to answer any of your questions. I yield back.
Ms. Waters, thank you very much. Mr. Chairman, the opportunity that you have presented to Congress today essentially does not in any way deal with anything, or it would deal with consumer issues, not the law. If a company violated the law, they would still be subject to FEC, SEC, any number of federal agencies that could bring action against them. Would that be correct?
It absolutely would be correct, Mr. Chairman. There's approximately 24 major consumer financial protection laws on the books. It's one of the things that the CFPB is supposed to do. And so it kind of begs the question, if they're doing their job, why did they need to pass this rule on class action lawsuits in the first place? But nothing in this Congressional Review Act resolution would have anything to do with amending the consumer protection laws that are on the books.
So, in other words, this might be a complaint of one consumer or a process that one consumer, perhaps many would have, but where there was a mistake but not actual violation of the law.
Well, potentially, I suppose it could be a violation of the law, but again, that's why we have law enforcement agencies. It's why we have a Justice Department. It's also why we have an SEC. It's why we have prudential regulators of our financial institutions as well to enforce these particular laws. Sometimes they could be subject to criminal sanctions, sometimes civil sanctions, but people have an opportunity, and they should. They should be protected. Again, we have laws on the books to do this, but what the CFPB has done is unilaterally, again, without Congress acting, has decided that it knows better than other people on essentially abrogating their right to contract. And in doing so in such a way that ultimately we believe can hurt consumers, because typically they receive swifter justice, if you will, through, for example, an arbitration proceeding. They are more likely to have their controversy judged on the merits, and they are more likely to end up with greater compensation, as opposed to what unfortunately can frequently happen is when plaintiffs' lawyers make 31,000 times the amount of the average compensation in a class action lawsuit. So we know that people end up with a couple of coupons or $20, and the trial attorneys end up walking away with millions. That's hardly fair, and ultimately it makes credit more expensive and less available to people who need it.
Thank you very much. Chairman Cole?
No, I don't really have any questions. I certainly appreciate the gentleman bringing the legislation now. I think this is a remarkable agency, ran amok, and it needs constant reining in, and I'm glad you're doing that. But we're going to have a long night tonight, so I'm not going to waste a lot of time here on something I support and look forward to seeing on the floor.
Thank you very much, Chairman. Yield specs time, gentleman from New York.
Thank you, Mr. Chair. I'm not supportive of this at all. And I would like to insert in the record statements from 310 undersigned consumers, civil rights, labor, and nonprofit organizations.
Without objection, be entered in the record.
And Attorney General. Actually, Ms. Waters, you probably know the actual figure here. I don't want to be wrong about it. Was it something like $12 million has been returned to persons?
Billion.
Yeah,
Yes.
12 billion?
Yes.
Billion?
Yes.
Okay, then I think that's a thing that works, frankly, and for those consumers, because I think all of us know, and we're pretty sure of it, that arbitration really favors the people with the big guns and all the lawyers, and that we don't want to do anything to go backward on this issue. This poor little organization gets beat up almost all the time, but it is the only thing we have left, basically, for consumers except arbitration. So and they talk about, I think in the list that I mentioned, I believe that's almost every state in the country. Texas has 4, 8, 12. New York a few more. But it's you know, this again is a part of CRA, right? Isn't that one of those actions? Yeah? Well, I know none of us came out very well in that. I'm sorry the American public doesn't understand what happened to environmental laws and all the things when those regulations were taken away. But I do want to put this in the record and not have anybody think that everybody believes that going to arbitrate with 15 lawyers in a room when you may not have one is fair. Okay, thank you. I yield back.
Thank you very much. Chairwoman yields back his time. And we've moved to the gentleman from Louisville, Texas, Dr. Michael Burgess.
Thank you, Mr. Chairman. I want to thank our witnesses for being here. I'm going to follow Chairman Cole's sterling lead and recognize we have a long day ahead of us, and I have no questions for the panel.
Thank you very much, gentleman from Massachusetts.
Well, I'll recognize everybody's lead because the process, quite frankly, is a little rigged here. And I just want to point out for the record that this bill that we're dealing with here today was introduced on July 20th, 2017, just a few days ago. No hearings, no markup. And this rule that you're seeking to overturn, from what I understand, the CFPB began an inquiry back in 2012. The reports were issued in 2015. The draft, the proposed rule was issued on 2016. I mean, there was a long process. We can argue over whether you like it or not, but I mean, at least was a thoughtful process as opposed to this. And my understanding is that this will be a closed rule, as they all have been. So it is what it is, but this is a lousy way to legislate. It really is. And I think this whole process is mindless. And I yield back my time.
Thank you very much, gentleman yields back his time. I would note for the record that on July 10th, 2017, July 10th, in a 776-page release, the CFPB issued the final arbitration rule pertaining to this issue. The Congress of the United States is given 60 days within the act. I think that if you look at a review of that from July 10th until today to prepare this, the committee, in my opinion, Mr. Chairman, has done a very good job to bring this to the Rules Committee.
Mr. Chairman?
Yes, sir.
Yeah, but the proposed rule was issued in 2015, and a call for comments was made. I mean, there was a process in place.
There is.
Yeah, I know, and I'm saying, you know, so I mean, I just want the record to reflect that the CFPB actually followed a thoughtful process. We are not. I yield back my time.
Thank you very much, and gentlemen, continuing his opportunity to disagree with me, the committee, meaning the Financial Services Committee, waited some 2 years then for the final answer that came out July 10th. That's the date at which the 60-day clock begins, and that the House and the Senate have to act by then. So I think it was a pretty darn good thing, and I appreciate the gentleman's comments of where he thinks is right, but I want to make sure that we recognize the facts of July the 10th. A gentleman from Georgia. Gentleman does not seek time. Gentleman from Colorado. Gentleman does not seek time. Is there any, the gentleman from Alabama?
Yes, sir. I just wanted to go over one thing we haven't talked about, and that is that, as I recall, Mr. Chairman, Congress enacted the Federal Arbitration Act in 1925. The Supreme Court has upheld arbitration provisions in contractual agreements a dozen times, I guess. It seems to me it's a lousy way to legislate when Congress, through the Dodd-Frank law, says we're not going to repeal or change a law that was passed in 1925. We're going to delegate that power to an executive agency. I got constitutional questions about that. I wonder if you care to comment on that.
Well, thank you. You have your facts correct. So it has been well-settled law for almost a century as far as the arbitration process goes. The original enacting legislation, as you pointed out, dates back to the mid-20s. It has been upheld by numerous Supreme Court precedents. And so, again, in many respects, Dodd-Frank, yet again, is not a law. It is a license to the unaccountable, unelected to create their law. And yes, we should be offended, regardless of whether you're Republican or Democrat, conservative or liberal, that so much of Article I constitutional powers have now been yielded to these unaccountable agencies. It is a front to checks and balances. So regardless of what you think of the underlying policy, I would hope that members of Congress would feel obligated to do their jobs and make sure that this is something that ought to be a matter of legislation. And so for that reason alone, we ought to make sure that this Congressional Review Act goes forward and that this rule is overturned on no other reason than process alone is sufficient to overturn this rule.
Mr. Chairman, I guess when I look at this, I think about the conversations we've had on this committee about things that we would like to do to bring Article I powers back to Congress. And so when I see that in the Dodd-Frank law, Congress tried to give away its power to amend or repeal a law, which I'm not sure Congress can do that, but at least tried to, seems to me that was not a very good decision in that law. And so what this agency's tried to do is to take advantage of a questionable power delegated to it in derogation of the authority of Congress. So for that reason alone, I think that we should adopt this bill, and I certainly support making bringing this bill before Congress so we can say what we need to say and reassert our authority under Article I. I yield back.
Thank you very much, Mr. Newhouse. Gentleman does not seek time. Mr. Buck does not seek time. Is there any other member of the committee? Seeing none.
Chairman?
Yes, ma'am.
Would you yield time to me, please?
Yes, ma'am. Gentlewoman is recognized.
Thank you very much. Mr. Chairman, I came to the Rules Committee today basically to talk about the process, which Mr. McGovern just questioned, our chairman and the committee about, and to let you know that the Consumer Financial Protection Bureau had gone through a painstaking process and gathered comments and worked with organizations to get their input on this. And we've not had one hearing in our committee on this issue. But for me, it seems that when we consider the Constitution, as Mr. Byrne has interjected into this discussion, we must know that basic to the Constitution is the right for people to have their day in court. And forced arbitration denies that. That is as un-American as anything could be, to deny a consumer the ability to go into court and to have their day and to make their argument. And so I am very pleased and proud to be a progressive Democrat here today advocating for consumers. I cannot understand how any member of Congress could take the side of an organization like Wells Fargo, who broke the law and who created fake accounts, used people's private information, and it not be considered in terms of how they are using forced arbitration to continue to deal with these issues. And so I know that I would not be able to prevail here today, unfortunately, but I would just like to at least say to the members of the committee, this is an extremely important consumer issue. And I've heard you loud and clear as you have made your arguments against the consumers and for the companies and the banks and others who would be pleased with what you're saying today because of their support for forced arbitration that does not allow the consumers to have their say. And so I know, again, that I would not prevail here today, but I wanted to be here just to make the argument for the consumers, for those people who are taken advantage of in back rooms without attorneys, many of whom cannot afford an attorney to even represent them in forced arbitration. So with that, I yield back the balance of my time.
Thank you very much. We appreciate the gentlewoman. I've got one question. Is there anything in here that says somebody cannot go to court, or does it simply stop the adherence to class action lawsuits?
Are you asking me,
I am.
Mr. Chairman, no, people still have an opportunity to go to the court like they should have the right to contract. And so what we're speaking about is, again, an unelected individual, unaccountable individual deciding for all of America that people actually can no longer have the right to contract to go to arbitration and forego class action litigation. And many of us think that is wrong, but most important, again, to Mr. Burns' point, the process is wrong when one individual has the opportunity to do this. It ought to be a matter that should be legislated on, and frankly, last year, our committee had a hearing on this very subject. But for a lot of different reasons, we know that we cannot trust what the CFPB has done. We don't trust their study. They have not been forthcoming with the information regarding their study, and the law says that their rule must be based upon the study, so we don't even know if this is a lawful rule. Yet one more reason why it should be overturned.
Thank you very much. Judge Hastings, did you wish to have any? Thank you very much. Let the record reflect you're on time and that you are looking forward to the debate that will be on the floor and engaging at that time, and we appreciate the gentleman very much. Thank you very much. I want to thank—
Mr. Chairman,
yes,
yes. If you would yield to me a few minutes, you asked a question, and you ask if forced arbitration prevents one from having their day in court. I don't know if you got an answer. Did you ask that question?
I think I asked something about that. Is there anything in here that says a person cannot go to court? I think what
That's what forced arbitration is, Mr. Chairman. It prevents you from having your day in court.
Well,
Mr. Chairman,
yes,
again, we are speaking of class actions.
That's what I thought, class action lawsuits. We're talking about class action lawsuits that take years to develop, keeps the consumer from getting an answer. They're a part of something that may take years. And then, as Bob Goodlatte has noted, then you get less money back than the stamp that you had to send saying you want to be in the class action lawsuit.
The trial attorneys will take tens of millions, I assure you, Mr. Chairman.
Yes, sir. Thank you very much. Okay. This ends this first panel. Is there any other member that would seek to speak on this? HJ Res 111. Seeing none, this now closes the hearing portion of HJ Res 111. Chair now being received a motion from the gentleman from the young chairman from Oklahoma.
Mr. Chairman, I move the committee grant HJ Res 111, providing for the congressional disapproval under Chapter 8 of Title 5 United States Code of the rules submitted by the Bureau of Consumer Financial Protection relating to arbitration agreement, a closed rule. The rule provides 1 hour of debate, equally divided and controlled by the chair and ranking minority member of the Committee on Financial Services. The rule waives all points of order against consideration of the joint resolution. The rule provides that the joint resolution shall be considered as read. The rule waives all points of order against provisions in the joint resolution. Finally, the rule provides one motion to recommend.
You've now heard the motion from the gentleman from Oklahoma. Is there amendment or discussion to that? Seeing none, the vote will now be on the motion from the gentleman from Oklahoma. Those in favor signify by saying aye.
Aye.
Those opposed, no. No. Ayes have it. The gentlewoman asked for a roll call vote. Clerk will poll the committee.
Mr. Cole. Aye. Mr. Cole, aye. Mr. Woodall. Aye. Mr. Woodall, aye. Mr. Burgess. Mr. Burgess, aye. Mr. Collins. Mr. Collins, aye. Mr. Byrne. Mr. Byrne, aye. Mr. Newhouse. Mr. Newhouse, aye. Mr. Buck. Aye. Mr. Buck, aye. Ms. Cheney. Ms. Cheney, aye. Ms. Slaughter. No. Ms. Slaughter, no. Mr. McGovern.
No.
Mr. McGovern, no. Mr. Hastings.
No.
Mr. Hastings, no. Mr. Polis. Mr. Chairman.
Aye.
Mr. Chairman, aye.
Clerk will report the total.
9 yeas, 3 nays.
The motion is agreed to, and accordingly, the gentleman from Windsor, Colorado, Mr. Ken Buck, will be handling this for Republicans. And Mr. Cole. Excuse me just a moment, please. If the clerk would please tell me, we have completed the vote. Was there a request to reopen the vote? There would be a request to repoll the committee. If the gentleman would please, any member that has not been recorded, if the gentleman would please, the clerk would please ask for that.
Mr. Polis.
No.
Mr. Polis, no.
We will now ask for the clerk to please provide the new total that would be available based upon HJ Res 111 rule.
9 yeas, 4 nays.
The motion is agreed to, and the gentleman, Mr. Buck, once again, and Mrs. Slaughter. Mr. Polis, the gentleman from Colorado, will be handling this for Democrats. We will now proceed from relevant appropriators to an amendment following our votes on this rule now, and we're now moving forward. Thank you very much. The committee wants to welcome our visitors who have come to the committee today. I would note that we have two distinguished members who are here representing the Appropriations Committee, the young chairman from New Jersey and the gentlewoman from New York, our dear friend, Nita Lowy, and we're delighted that both of you are here. We have already provided an opportunity, a viewpoint of what the gentleman and the gentlewoman would be providing, but without objection, anything they brought in writing will be entered the record, and the gentleman is recognized.
Thank you, Chairman Sessions, Ranking Member Slaughter, and all members for having us here this afternoon. Thank you. I'm pleased to present an amendment to H.R. 3219, a legislative package providing critical appropriations for national security. Before I begin, I'd like to thank the chairs of the subcommittees, all of whom I believe are in the room. Chairwoman Granger, Chairman Simpson, Chairman Dent, Chairman Carter, Chairman Yoder, who led the way on these bills and the amendment before you today, and Ranking Member Mrs. Lowy to my right, and the ranking members of the subcommittees, Mr. Voskowski, Ms. Kaptur, Ms. Wasserman-Schultz, Mr. Ryan, Ms. Royal by Allard, for their work through the year's appropriations process. We all share a mutual dedication to the important work of our Appropriations Committee, and I'm grateful for their incredible work to bring all 12 bills through the committee in record time. We're here today to seek an appropriate rule to provide for prompt consideration of this important measure. This legislation ensures that the most important services that the federal government provides to keep the American people secure are funded responsibly and appropriately. This includes funding for the Department of Defense and Intelligence Community, Department of Veterans Affairs, the Department of Energy, and the legislative branch. There should be no uncertainty when it comes to our security. It's our responsibility of the men and women in uniform and to millions of Americans that they're charged with protecting to provide them with the sources they need each and every year. And with the committee's permission, the chairs of each subcommittee will review their portion of this package, but certainly I'm here to support the package and urge that all members give it their due consideration. Thank you, Mr. Chairman.
Mr. Chairman, thank you very much. In fact, as the gentleman suggests, we're going to go through a bifurcated viewpoint, and you have two subcommittee chairs and two ranking members at this time, as well as your ranking member of the full committee who is here, and I want to thank you. Those people have assembled it properly, and we will move to them. However, first we will go to the gentlewoman from New York, the distinguished member who is here, and the gentlewoman is recognized.
Thank you, Chairman Sessions, Ranking Member Slaughter, and all the members of the committee. We thank you for the opportunity to testify, and I'll be brief as we have our subcommittee rankings here to discuss their relevant divisions of the bill. Chairman Sessions, I have been before you several times, most recently in April, to discuss a bipartisan omnibus that passed overwhelmingly. I wish that spirit of bipartisanship extended to the bill before us. Not only are the bills written to partisan levels that undercut economic growth and priorities family relied on, the Republican majority has abandoned any hope of this House returning to regular order. This is an appropriations bill, which should be considered in the House under an open rule to allow members of both parties the opportunity to have their constituents' voices heard. Yet amendments had to be filed by 10 a.m. this morning to be reviewed by this committee. Chairman Sessions, while, as you know, I have the utmost respect for the Rules Committee, I have even more respect for the traditions and rules of the House, which allow members to have open access to amend appropriation bills. Both parties have shut down the open process before, but it is not a tool that should be used without first trying to use an open process. Our fear is a closed rule will be used to add poison pills from the Republican side of the aisle and shut down Democratic amendments that may enjoy bipartisan support. Playing politics with the bill that funds the troops by inserting the toxic border wall to it is really beyond the pale. Also, why not include the entire Homeland Security bill if the intention is to pass security-related bills, or the bill that funds the FBI? Securing our homeland goes beyond the Department of Defense and our own budgets in the legislative branch. Finally, I'd be remiss if I did not express my dismay at the undemocratic move by the Rules Committee to unilaterally remove language from a bill that passed committee. I didn't know the Rules Committee had the authority to overturn the will of another committee of Congress. Barbara Lee, with the support of many Republicans, offered an amendment to repeal the 9/11 authorization for war because a new authorization should be debated. If our soldiers have the courage to fight for us, we should have the courage to give them a day of debate on whether or not they should be fighting in the first place. Her amendment passed by voice vote and has somehow disappeared from the version of the bill on the Rules website. Just disappeared. We can't find it any place. This process should be repudiated by rank and file members of both parties. So I thank you, and I look forward to your questions.
Thank you very much. Both of you deserve answers. Both of you deserve an opportunity to speak clearly and forthrightly, as I know the gentleman and the gentlewoman not only deserve, but would expect those answers, and I promise to give those. I want to move next, if I can, to the gentleman from Kansas to speak about the ledge branch portion of this. The gentleman he is with is Mr. Ryan, the gentleman from Ohio, distinguished gentleman. We're delighted both of you are here, and the gentleman from Kansas is recognized.
Thank you, Mr. Chairman.
Yes, sir.
It's an honor to be here today, and I want to thank you and Ranking Member Slaughter and the members of this Rules Committee for the opportunity to testify with regard to the legislative branch portion of H.R. 3219. I'd like to thank Chairman Frelinghausen and Ranking Member Lowy of the full committee for their leadership and work to bring us to this point, the many hours in subcommittee and full committee late hours we put forward on these bills. Mr. Chairman, the committee did a remarkable job, and the work product we bring before you today is something to be proud of. The recommendation for the fiscal year 2018 legislative branch division provides $3.58 billion. Our bill focuses on security, transparency, and infrastructure in a fiscally responsible manner. We're proud of this excellent bipartisan bill, which funds many of the essential tasks of the legislative branch. I'd like to thank Mr. Ryan, ranking member, for his good work in stewardship, and all the members of the subcommittee who put this legislation together. Over the course of hearings and meetings with agency heads, our subcommittee has listened to all who presented their respective concerns and budget requests and present the legislation to the full House to consider. In particular, Mr. Chairman, in light of the tragic shooting of our dear friend and colleague Steve Scalise, as well as Matthew Micah and Zach Barth and others who are at a congressional event, we believe this bill takes a comprehensive approach to ensuring the safety and security of not only members of Congress, but staff, visitors, and all of the constituents we serve. This bill will provide resources and make structural changes that will address security concerns both here at the Capitol and at home in our districts. And we are so thankful, all of us, Mr. Chairman, for the heroism of our U.S. Capitol Police each and every day, specifically on this day, Special Agents Crystal Griner and David Bailey, who on that fateful day, their actions protected the lives of all those present. This bill is a reminder that we should be thankful and provide resources for the Capitol Police to keep us safe at work each day. Mr. Chairman, I respectfully request this committee grant a rule as requested by Chairman Fraylinghausen, and I yield back the balance of my time.
Thank you very much, Mr. Yoder. The gentleman, Mr. Ryan, the distinguished gentleman who we're delighted that you're here today, is recognized.
Thank you, Mr. Chairman. I appreciate the opportunity to be here. Let me thank you and Ranking Member Slaughter, and I appreciate this opportunity. There are a lot of us here, so I'll be very brief. While I support the legislative branch bill we reported out of the Appropriations Committee, I endorse all of the good things Chairman Yoder just said about it, and I appreciate his hard work and bipartisan approach of both his and his staff. I do question the manner in which this is being considered. First, by attaching $1.6 billion in wasteful spending on President Trump's border wall, the majority is taking a good bill, a very good bill, written and marked up in an inclusive manner, and squandering the opportunity to pass it on the floor in a similarly bipartisan manner. Most of us would agree that this legislative branch appropriations bill is a good product. So why is the Rules Committee tying it to a proposal that many Democrats find highly partisan? Incidentally, I sit on the Defense and MilCon VA subcommittees, and the same goes for those two bills. Attaching the wall funding, not lifting sequester caps, and abandoning bipartisanship on appropriations bills will lead to another showdown in the fall. The American people have grown tired of this. We shouldn't be rushing forward with appropriations bills that violate the law on the defense side and cut programs beyond reason on the non-defense side. At those levels, there simply isn't enough room to adequately fund all 12 appropriations bills. That means if we adequately fund veterans and the legislative branch, all of which I'm in favor of, we will be forced to shortchange important programs that address the pocketbook issues facing families all over the country. And while the modern practice is to consider the legislative branch appropriations bill under a structured rule, the Defense, MilCon, VA, Energy and Water, and Homeland Security appropriations bills should be considered under open rules. Thank you, Mr. Chairman. I appreciate the opportunity to be here. Now yield back.
Mr. Ryan, I want to thank you not only for your comments, but your insight of the process that you believe that should be followed. And I want to thank you very much for being here today. Mr. Chairman, we're delighted that you're here. I know you have an opportunity today to express some of the ideas that you've gotten. The gentleman from Pennsylvania is here to speak about MilCon VA, as well as his distinguished colleague who is the ranking member, and the gentleman's recognized.
Thank you, Mr. Chairman, and thank you, Ranking Member Slaughter, and all the other distinguished members of this Rules Committee. I'll be pretty brief, but I'll just say a few things about the bill. The act before you includes Division C, appropriations for military construction, VA, and related agencies. For FY18, Division C is exactly the same as the MilCon VA bill reported favorably out of the full committee on June the 15th. Thanks to the leadership of Chairman Frelinghuysen and Ranking Member Lowy, especially the input and support of the Ranking Member Subcommittee, Ms. Wasserman-Schultz, this division will provide necessary funding for the Department of VA and military construction projects. We're able to include the vast majority of the subcommittee's over 1,000 member requests. It's a lot of requests, and this division demonstrates our firm commitment to fully supporting our nation's veterans and service members. The total investment is $89 billion for military construction, VA, and related agencies. It's $6 billion above last year, FY17. This division provides comprehensive support for service members, military families, and veterans. It supports our troops with the facilities and services necessary to maintain readiness and morale at bases here in the States and abroad. It provides for Defense Department schools, health clinics, to take care of our military families. And this division funds our veterans' health care system to ensure that our promise to care for those who have sacrificed in defense of this great nation continues as those men and women return home. We owe this to our veterans and are committed to sustain oversight so that the program delivers what they promise, and the taxpayers are well served by the investments. I won't get into the breakdowns of the money, but it's about $10 billion for military construction, $78.3 billion for the VA. It's about a 3.9% over last year, or 5% for the VA, and actually the MilCon percentage increase is even larger, but about a $2.1 billion increase over the previous year. We fully fund the medical care, VA medical care, at $69 billion, and that is at the full request A lot of money in there for mental health services, suicide prevention, homeless veteran services, opioid abuse prevention monies, and much more. Disability claims processing, we provide over $2.9 billion, which is $50 million over the request. And so we're staying on that issue, which is important to so many members of this, not only our committee, but throughout the entire House. Finally, I'll just say, too, on major construction, we maintain oversight for major construction projects. Anything over $100 million, we demand that there be that be contracted out because of the problems we've had with major VA healthcare construction projects like Denver and elsewhere. So in closing, this is a very solid bill reflecting priorities from all members that is focused on the needs of service members, veterans, and their families. We are $6 billion over FY17, more than a 7% increase. We provide for our military and our veterans to the very best level we can in a manner that's fiscally responsible, and I would be glad to answer any questions from the committee members.
Thank you very much, Ms. Washington-Schultz. We're delighted that you're here today. The gentlewoman has been up for a number of years, not only representing the Appropriations Committee, but each time has come with either your ranking member or as a ranking member, and each time the gentlewoman has been clear about the needs as she saw it of the nation. I appreciate the gentlewoman's recognized.
Thank you for your very kind words, Mr. Chairman, and I thank you and the ranking member and our colleagues for your time and attention. Chairman Dent set an appropriate cooperative tone and was truly inclusive throughout this process. He has worked tirelessly with an extremely limited amount of time to get to this point. Even with this short time period, the Milcon VA bill addresses many members' concerns, as well as critical issues impacting our veterans and active and reserve service members. The military construction portion of this bill provides adequate funding for both the active and reserve components. In addition, the bill funds the NATO Security Investment Program at the FY17 level, sending a strong message to our nation's allies that we stand with them as we continue to face evolving international threats. For the Department of Veterans Affairs, this bill provides $3.9 billion, which is a 5.3% increase over FY 2017 enacted. And I'm also pleased that this bill will address the issue of breast cancer awareness and prevention and provides almost $700 million for medical research, which will fund essential efforts such as those to address TBI and PTSD, develop state-of-the-art prosthetics, care for victims of military sexual trauma, and treat veterans suffering from mental illness. It is my sincere belief that if the Milcon VA bill was being considered as a standalone, as is our tradition, it would receive strong bipartisan support. However, instead of following regular order, we instead are taking up 4 bills at once and adding funds to begin construction on President Trump's border wall that he promised Mexico would pay for, and now taxpayers are going to be stuck with the bill. This fiscally and morally irresponsible expenditure leaves the non-defense appropriations bills grossly underfunded. Furthermore, contrary to popular belief, this bill is not even great for defense. The minibus ignores the Budget Control Act, BCA, and provides additional funds that would ultimately be sequestered without a cap adjustment. This minibus would breach this cap by more than $72 billion, resulting in a mandatory 13.2% sequester of all defense accounts, including the military construction title. So even if this bill is signed into law, which it is highly unlikely to be, DOD would not receive $1 of this increase. Secretary Mattis testified sequestration and the continued use of continuing resolutions would result in a steady erosion of military readiness. That is the only outcome that this bill guarantees. With that being said, Mr. Chairman, I join my colleagues on our side of the aisle in our request that when this bill comes to the floor, it comes with an open rule so that the full House can have a thorough debate on this package and return to some form of regular order, which I'm confident that we all ideally support. Thank you. I yield back.
I thank the gentlewoman for her comments. I want to straight up top address the issues that have been brought to the committee by the gentlewoman from New York. She raised at least 3 issues that I'm aware of, and I'd like to address those with fairness to each of you who've come to the Rules Committee today. First, in fact, the Rules Committee can change any language that comes from any bill that comes to the Rules Committee. That's a fact. Doesn't mean we do, but it means we do have that responsibility and authority as is necessary. And in fact, I did do that. I did that with consultation from a number of people, and one of those would be the gentleman from Oklahoma. The gentleman from Oklahoma, Mr. Cole, has been highly involved in the issue of the UAMF and has dealt with the military, the issue of use of force. I, as chairman, have been. Mrs. Slaughter has been involved in this. A number of issues, and members of this committee feel very strongly about the debate that should ensue, not only to make sure that the men and women of the military receive the benefit of this, but also our members who feel very strongly about this issue. I believe that some of the discussions that I had, including with Ms. Barbara Lee, the gentleman from North Carolina, Mr. Walter Jones, and others, have resulted in an agreement that I am trying to move forward with, and that is that we want to include the administration in that discussion also. I believe that members of the military, members of the intelligence community, members of our national security community would choose to be a part of that debate. We have thus instructed through a series of communications and bills that we're passing, including in this bill, where we are not going to defer, but rather directly move at this issue. We're not going to say if we do or don't do something, we're going to defund something at some period of time. We're going to take the issue head on. And I would like to defer to the gentleman from Oklahoma who has been a leader on this issue, not only for the Rules Committee, not only as a proud member of the Appropriations Committee, but as a gentleman who has a distinguished viewpoint on making sure that America is properly presented, the American people, in a constitutional view, and I would yield to the gentleman for such purpose.
I thank my friend the chairman, and this is a difficult issue because, frankly, I very much agree with my friend Ms. Lee, my friend Mr. McGovern, that we need a new AUMF. I've been very consistent with that over the years, and I certainly was supportive of Ms. Lee's amendment in the committee. Now, when I did that, I also knew that we would have a point of order lodged against us because we are the Appropriations Committee and we don't have the power to actually, the jurisdiction to act in this area. But I still think we need to do something to, frankly, catch the attention of our own leadership on both sides of the aisle. Frankly, and I cast no aspersions to anybody, but sometimes it's sort of like when you're growing up, your parents can protect you too much. I think the leaders of both parties have protected the Congress from a difficult vote for many, many years. When we had this debate on the floor on the National Defense Authorization Act and on my amendment, Chairman Thornberry and Mr. Smith both pointed out that the House Armed Services Committee had tried to deal with this issue in 2011 and in 2012. But in each case, the United States Senate chose not to act on it. And I think they chose not to act on it because, and this is my opinion, I don't know this, but my opinion was Democratic majorities at risk, and a Democratic majority leader in the United States Senate didn't want to have his people have to cast a difficult vote. If you recall that period of time, they weren't doing much voting over there anyway. I mean, they simply didn't vote at all. So I think the effort, and I give Ms. Lee, frankly, all the credit. Nobody has fought longer or harder to force this Congress to go back and do its job. She was against the original AUMF because she saw at the time exactly what happened. This has been used over and over and over again by presidents of both parties to go to war in places that we had no congressional authorization to go to, in my opinion, and that we did not have a debate on. And so I thought it might catch somebody's attention if that amendment moved forward. People seem to have forgotten I actually supported it 2 years previously as well. It wasn't just this time. So I was approached by the Speaker with, they said, look, jurisdictionally, this can't happen. And he made another point, which I agree with, which is the administration ought to participate in this exercise. You know, they ought to have an opportunity to put in a report to tell us what their justification is, their legal justification, what their strategic objectives are, what they think the cost is going to be, what the strategy ought to be. And so I certainly agreed. He said, would you carry that? If we did that and we negotiated the language out over a couple of days, and I did, and was happy to do that because now at least that report will be written within 30 days of the signing of the Defense Authorization Act, and now I guess potentially the Defense, Appropriations Act, although I will actually tell you, and I'll speak to this when we get to the gist of the bill, I have considerable agreements with my friends on both sides of the aisle as to how far this is going to get. But I think the Defense Authorization Act will get through. At some point, and this is a ticklishly difficult situation. I don't want to just be critical of the leaders of both parties for, protecting their members. I will say they had a knotty problem as well. This is an enemy like no other. We're fighting a war like we've never fought before. And we have an enemy that can morph into many different forms and many different organizations. And it's transnational. We're not fighting a traditional nation state. And that makes crafting of the appropriate authority, I think, difficult. It's one of the reasons why I like some of the ideas that have been proposed by my friends on both sides of the aisle, that we limit in a temporal frame the amount of time you have to do this, so Congress is forced to revisit this on a regular occasion. And I've been asked on many occasions, well, what's your idea of an AUMF? I said, I actually don't have a perfect idea. I want the committees, I want the administration to submit one, and the committees to look at it and do what we do legislatively, have a real debate, a real discussion, craft something that can pass. But let's not kid ourselves that it's an appropriate thing for us to sit here 16 years after an authorization was passed, when most of us, the majority of us, were not even in Congress at the time, and we're going to war on it over and over and over again. I actually asked the Secretary of Defense in Defense Appropriations hearing, would a new AUMF be helpful, particularly with regards to Syria and ISIS? And he said, yes, it would be helpful. He thought that the men and women that we send out to tough places who put their lives on the line ought to know the Congress of the United States is for them being there, has directed them to be there. That he thought that would be useful. Now, the administration, like all administrations, has said they think they have sufficient legal authority to do whatever it is they're doing. And the Obama administration said precisely the same thing. And I would just tell you that tells me our founders were pretty smart. They know the executive branch will always tell you it has the legal authority to do whatever it is they happen to be doing at the time. Whether they do or not depends ultimately on the courts, I suppose, but it depends on whether we push back ourselves. The Constitution's pretty clear where war-making authority is. So I thought the proposal of the Speaker to give the administration an opportunity to participate in a debate, to not just rely on exactly the same thing the Obama administration relied on, to rethink this, and for Congress to rethink this too. Again, my friend Ms. Lee was, she was prescient, 16, 17 years ago. I guarantee you nobody that voted for that thought it would be used the way it has been used and stretched as far as it has been stretched. And I'm not critical of that Congress. They were acting within days of a brutal and barbaric attack on the United States that left thousands of our citizens dead. They were ready to get in the fight. But I'm not sure we understood the nature of the enemy or the warfare then. We understand a lot more now. And it's time to go back again. And if we're going to be in this thing, give our military the assurance that they have the backing, hopefully on a bipartisan basis. And I think this would be a very bipartisan debate. I actually do. I think my colleagues feel very strongly about this no matter where they come down, and I find different people in different parties actually sometimes have the same view or opposing views within their own party. So I think it's an important exercise to do, but I recognize we were stretching our jurisdictional authority at the time we did it. So with that, and I look forward, I know my friend Ms. Lee will be here later. I look forward to engaging in that debate, but I think we got to the point that we're going to have this discussion, or at least we're going to have the vehicle to have this discussion because of her action, because of the things she did. That made people have to come to the table and have to begin looking at this. I've had discussion with the Secretary of the Foreign Relations Committee about this, I've had a discussion with the Speaker about this, any number of members. And as my friend Mr. McGovern said on the floor, it's a baby step, and I think that's a fair characterization. But it's a step in the right direction, and it's a step that I think will give everybody the opportunity to participate in the debate. And I want to defend my friend Ms. Lee, by the way, on another point where a lot of people said this immediately, took away the justification of the war. It did not. You can look at her wording. She gave us 240 days after the passage of the bill to write a new AUMF. So it extended it, but it put a limit on it. And in that sense, it did what I think we ought to do in anything we pass, put some sort of limit on it so it comes back to Congress again. Now, I know there's a lot of people that wonder whether or not we can get anything done in 240 days. I wonder that myself. But I still, if we can't get a majority of the Congress of the United States to support the deployment of American forces into harm's way, then we shouldn't be there. We shouldn't be there. And by the way, sometimes you can't get a majority even when you should be there. But that's the point is the responsibility is here, and men and women count on us to discharge our responsibilities. They're darn sure discharging theirs. They're going where they're asked to do and doing what they're asked to do. They should know the Congress of the United States for it. So I welcome this as one of the several vehicles at which we'll have this discussion, and I think it actually builds up momentum for something more serious and sustainable in the fall. At least that's my hope. If I prove wrong in that, well, then I'll push a little bit further out of my lane. But I think in this case, something had to be done. I thank the Speaker. Something was done, and we'll see whether or not it takes us in the right direction.
Well,
I'd certainly yield to my friend.
Yeah, no, I appreciate the gentleman's comments, and I appreciate his commitment on this issue. But what he just described is basically an argument for the Lee Amendment. You know, it's ironic, in this committee, before this panel came to testify, we were hearing about that Congress needs to reclaim its power when it came to weakening a consumer protection, that we have to reclaim our power. And then yet, when it comes to the issue of war, we're willing to continue to kick the can down the road. And I supported the gentleman's amendment, but it doesn't require us to do anything after that. The Lee Amendment says you got 8 months to come up with an AUMF. I mean, if we can't do it, that's plenty of time to consult with the military, the administration, with anybody who wants to be consulted with. If we can't come up with something in 8 months, it means we don't have the political will to do it. And I agree with the gentleman. If you don't have the political will to do it, then we ought not to have our brave men and women in harm's way. If we don't have the guts to be able to vote up or down on something like this. And, you know, I mean, we've been having this discussion pretty much for 16 years, and there's always an excuse why we can't do it. Barbara Lee's amendment was germane. I mean, maybe it's subject to a point of order, but as the chairman of this committee just said at the beginning in response to Ms. Lowy, we could do anything we want up here. I'm willing to guess that a lot of these riders that are not germane to these appropriations bills that are going to be protected, rules committees give them protections. So we could do this, but I mean, all her amendment says is we're ending this outdated AUMF. You got 8 months to come up with a new one. We can't do that. Then then there's something wrong up here. We can't bring ourselves to debate this issue, and we're going to have different opinions on it. But I just this is so frustrating, and I think it is so insulting to the people we put in harm's way. And yet we just go on.
Well, gentlemen, well, reclaim my time, but I'll certainly yield time to you again, because there's not much you said with that I disagree with. The difference, I think, is, and I think this is really important, is, we normally wouldn't do something of this magnitude on the floor of the House in a short debate over an amendment. We normally would do this by moving it through committee. I'm a big believer in the much maligned and frankly now twisted and torn committee process. And I'll have a chance to talk about that in a bit too. But I don't want to deliberately undermine it. I want to at least try it. Because, look, I watch this. Our bills get better. We originally, this is a little bit off point, but originally when we were trying to rush bills through to meet deadlines, there was some discussion in the Republican conference that we'd do essentially what these gentlemen and ladies are doing here, and then the Cardinals would just write the other 9 bills. That's crazy. And I said that was crazy at the time. I don't want that authority. You should not want to give me the ability to spend $156 billion without going through a committee and giving my friends who exercised their right to amend vigorously last week for 11 hours in the markup. That bill gets better because of that. It doesn't get worse, it gets better. And we will, none of these bills are final. They're all going to change in the course of the process anyway. But you want as much committee involvement. So that would be, one of my concerns about the Lee amendment, but I recognize the validity of the argument. We're not doing our business, and if I have to do this to move it, I'm going to do it.
And if the gentleman could just yield to me for 2
That's certainly.
Yeah. I mean, 8 months, the committees can do lots of stuff in 8 months. And the fact that the committees haven't acted up to this point, I don't know why. I mean, you mentioned the Obama administration. They actually submitted an AUMF that my Republican friends didn't like, but we didn't act on it. So we can, but 8 months, that you could have lots of committee hearings and lots of consultation, and we could get something, to the floor. Maybe not something that will pass unanimously, but probably something that would pass with a majority in this House and a majority in the Senate. So I appreciate the gentleman's sentiments. This is just deeply frustrating, and I just there's no excuse for it, and it is what it is. So I thank the gentleman. I yield back.
Certainly thank the gentleman as well. Want to continue and will continue to work with him on this, and I'll take. Look, I'm a classic appropriator. If I can get a little bit, I'll take it. And then I'll come back for a little bit more and a little bit more. Certainly yield to my friend from Florida.
Thank you very much. Am I correct that Ms. Lee's amendment was passed in a bipartisan way out of the Appropriations?
That's correct.
That being said, and then the chairman's assertion at the outset that we can change language if we want to, did that have an impact on the decision with reference to the importance of the Appropriations Committee, notwithstanding so-called jurisdictional issues? How did that affect you all when you're thinking that our colleagues thought well enough of the Lee Amendment to pass it out in a bipartisan fashion? And here it comes, and then the way it was taken out is a part of the problem. The process, that there was no outward discussion. When Barbara came to talk with me, I didn't even know what she was talking about because it had just been taken out. And if y'all can take stuff out, I hope we can put stuff in sometimes.
Gentlewoman is recognized. Yes, ma'am.
Much. I'm glad Jim got to speak because he really has seriously worked on this issue for many years. But the fact that this thing is 16 years old, and as all of you pointed out, continuously going to war without trying to upgrade reflects very badly on our democracy. And I appreciate Mr. Cole's explanation, but I'm still not clear in my mind what happened. As I read about it, there was some legerdemain that took place there and that Barbara didn't know about. I congratulated her the day after the unanimous, I think it was a unanimous vote, wasn't it? Voice vote? No? Okay. And she was nervous as a cat then. I said, great, we finally see the end of light at the end of the tunnel here. And she said, the speaker's going to take it away. I said, I don't see how he can. But now we see how he can. So I just want to say that it has nothing to do with the kind of process that I believe was supposed to take place in the Congress of the United States. Whether they were just kept fooling her or not, she got the votes, and it passed. And by all that's holy and all of Jefferson's manual, it should be in order. But I'll tell you, waiting for this AUMF is very similar to waiting for Godot. It never happens. And if you would ask any one of us why, I don't think we could give any kind of decent answer because I've never heard one of why in the world are we afraid to do that, which is our purview, and take us completely out. The Congress of the United States is supposed to declare war, taking us totally out of the process, and to substitute the way to get the AUMF in 8 months with a study, I think just throws us back in the weeds here. And I'm very sorry for it, and I must say it's a blow to me personally. Thank you.
The gentleman who engaged me for a moment, is yours a study, Mr. Cole?
Yes.
Yeah, it is. You cannot legally, I actually wanted and raised this issue with the parliamentarian, can we require the Foreign Relations Committee to pick this up and act on it? And we cannot. We do not have the power by law to require a congressional committee to do something.
But you can through this law, require the administration to provide you strategy and data and information
And
that
legal justification.
and legal justification. That is not in any way what I would necessarily term a study. I believe we're trying
I
to
think
get,
it's called a study, is it not?
for the language, it is actually professionally asking the administration to provide us data and information about this issue so that Congress can appropriately do this. And I will tell you, looking right at you, there's not one bone in my body that's trying to get out of doing this. I'm trying to get us to it.
Well, I have no reason I've not asked her at all. I'm a great admirer of Barbara Lee because she does good legislation. She's a good member. But she was blindsided by this. She followed all the rules. She put out her amendment. It was accepted there. Not that you're in the wrong place, Miss Lee. You got to go somewhere else with this thing. And it was accepted and voted on. And for the life of me, I can't see that that's regular order.
Will the gentlelady yield?
I will.
This is a long explanation or comparison maybe that might not be accurate, but I think it's illustrative. I've been in a situation like this before. I worked long and hard over a fix of a bad Supreme Court decision. It's called the Carcieri decision, and it affects the ability, actually I was on the same side with the Obama administration, it affects the ability of both the Bush administration and the Obama administration to put land in the trust. But we can't deal, and I actually once got it all the way across the floor with the Democratic majority in Appropriations and Interior when Jim Moran was the chairman. He said, would you bring that amendment? And I said, yes, sir. And I talked to my friend, Mr. Simpson, who's there, and because he was the ranking member at the time, and I said, I think I've got the ability to do this. What do you think? He said, Tom, that would be legislating on appropriations bill. You can't do that until we do. And we got it across the floor. And we got it with Democratic votes, Republicans putting the amendment in, all the Democrats supporting it, and all the way across the floor it died in the Senate. So Mr. Simpson and Mr. Calvert and Ms. McCullum and a lot of us have been working on this issue for a lot of years to try and solve it. We thought we had reached an agreement with the chairman of the Natural Resources Committee to put it in an appropriations bill and at least fix it up to 2010. The very last day before we were to mark up that bill in subcommittee, a misunderstanding had clearly occurred. I don't know if it's the staff level or whatever, and the chairman of Natural Resources added language that we had no time to vet, and so we just went ahead with what we thought the original agreement was. Point is, he filed a point of order against what we had done, and it was stripped, I think, before it ever got to this committee. I know it never got to the floor. And we went down there and had a colloquy about it because it was a little bit of an embarrassing situation. So I'm telling you, or in my opinion, I'm no expert, I value very much what Ms. Lee did, but I also know that it can be stripped out like that. And it doesn't have to be done here. I mean, I've seen it done. I've had it done to me by a Republican majority. So it's not partisan, it's jurisdictional. It's chairman asserting jurisdiction within our committee, which they have every right to do.
Well, let me have one more short question, and to Mr. Cole, if I may. Yours is going to pass. Are we assured then that in 90 days we will be able to do a new AUMF?
No. And I think the gentlelady makes a very good point. We are not assured of that. Now, I think it gets tougher for the Committee of Jurisdiction when they have a justification and a report and mounting bipartisan pressure to do something, not to do something. But I've seen people around here not do things a lot. And I've seen it on both sides of the aisle, and I've seen it on both sides of the rotunda, and probably been part of it myself on occasion or two. This is not an easy thing. And it will be hard, as Mr. Smith said on the floor. But I think it has to start, and I think it would start better, not on the floor, but in the Committee of Jurisdiction. And I would hope, effectively, the administration submits their justification. We can debate whether or not we think that's sufficient. And I'm pleased that the Secretary of Defense has said in testimony before Congress he thinks a new AUMF, is progress. So, or is necessary, something we should do. So I see things.
And that's the advice that you would expect him to give to the president.
I would hope so. I mean, it's not for me to speak for the secretary or for the administration, but if I were watching this thing, I'd say this kettle is going to blow at some point if we don't do something about this and get everybody on the same page. So I don't know, but I think this, and it's just my opinion. You have to make judgment in this business. In my opinion, we had a better chance pushing this amendment that I had on the NDAA and it's been put here than we do the other way. But if it doesn't work, it doesn't mean I'm going to quit working at it, or I would accept whatever we saw. I think this needs to happen. So I've picked, a way that I think in consultation with the speaker. I've worked with speakers and against them. When I worked with them, I usually won. When I worked against them, I always lost. So I usually try to, if I can find a way to move forward, this seemed to me one to do that. I think the other thing was very important, though, because we wouldn't be to this point without Ms. Lee's amendment. That is just the truth. And if anybody thinks that amendment's going away, they don't know Barbara Lee very well, and they haven't paid much attention to the last 16 years. So I think this debate's coming, and I think this moves it toward us, but that's just my opinion.
I apologize for taking so much time, as I know we've got a long night ahead of us, but this
fact,
is really important.
That's right.
Our military counts on us for more than procrastination.
Well,
For the life of me, I don't know why we don't do it. It seems we are required to do it, and I don't know why not. Thank you, Mr.
Will the gentleman yield?
Mr. Chairman.
Excuse me, just a moment. The gentleman from Colorado.
Yeah, just to further discussions, obviously, we have a lot of, this is very important because we're talking about, our nation's defense here. It seems to me that a majority, as has been shown, a majority of the members of this body would like the AUMF limitation language in. I don't think anybody doubts the ability of this committee to take it out, but it seems like what's being done is subverting the will of a majority of the members of this body by this committee. This committee has, on a number of occasions, instructed committees of jurisdictions to do work. That's essentially what the Budget Reconciliation Act is. It instructs committees to do that work. Normally, of course, the appropriations language would not instruct committees of jurisdiction to do work, but here in this committee we can do that. We don't do what's normal a lot of the time, right? I mean, we can do whatever we want here, as the chair indicated. So there's no particular problem with, if this committee chooses to, we can certainly instruct a committee to do that work. We do that, wouldn't say routinely, but we do that from time to time. And so this would be no different. I further would just point out that there is a version that's been filed by Ms. Lee and Mr. Jones, number 96, that would express the sentiments of this AUMF amendment as simply a funding proposition, namely it would prohibit funding for the 2001 AUMF after 240 days after enactment. So, I mean, that is a very straightforward funding restriction analogous to others. So I guess my two questions are, yeah, that's germane. So again, I know that on some occasions we do tell committees of jurisdiction what to do. I guess the question is, why isn't this one of them? And then failing that, can we at least have the chair's assurance that we can have a perfectly germane amendment that is expressed as a funding prohibition, to be discussed and debated and voted on the floor?
These are all good ideas. The facts of the case are pretty simple. There was a discussion that took place. He will, and I'll get to him. The gentleman was seeking that, and I gave Mr. Polis the opportunity to express himself. These are important issues and ideas, and we're trying to allow the members of the committee, and I know the gentlewoman asked the question, how and why. We're trying to offer some explanation. The gentleman from Georgia.
Thank you, Mr. Chairman. I'll always yield to the chairman in answering. I think one of the interesting things here, in listening to this back and forth, it brings back some very, real and pertinent information and things that need to happen. But as, frankly, one speaking from this dais is the only one who has actually been deployed under an AUMF, this is something that needs to be discussed. And I believe that, frankly, in all due respect to the chairman and the committee, this was the wrong place. But I respect the chairman and the others to let it come forward. I knew there would be a point of reference. That's what Mr. Cole spoke of. I applaud Barbara Lee for her fight and tenacity on this. It takes a lot to be the only no vote on something that at a pertinent time was very popular. But like I said, at this point in time, let's begin this process of looking at it. I agree with what Mr. Cole has said, my friend from Oklahoma. We've got this thing to a point now, and the gentlelady, ranking member, she made a great point. Will this actually happen? Well, I think that's a perfect opportunity to say, with the pressure points that have been applied here, I still don't think the process was right in getting us here. But I think what has now happened through the NDA amendment is there. And and from both sides of the aisle is someone, like I said, who's actually been deployed under an AOMF, who has doubts about where we're at right now, and having a new administration to talk about this, there is pressure from across the aisles. There is something that needs to be done here, which I'm more than willing to be a part of. But as we look forward, there are things that I'm on record of talking about, the Iraq, others, that need to be gone, that need to be changed. We're not there in that capacity anymore, and we've used that. We go back to the general GWAT, the original one, where we just basically say wherever we need to go. These are things that need to be discussed. We can go on process, and I agree with it. Mr. McGovern makes a very fine argument. We've debated these things many times, and processes matter, just as it was under your leadership, ranking member, is others. We make choices and make decisions. I do believe that Chairman Cole makes a great point as far as both sides have been protected in this issue. We've been protected from both sides of this Capitol. My concern at this point, and we are going to have a later night, but I could not let this time pass without simply saying, as one who has been there, who's one who's actually understood the cost of this from a congressional perspective, and also as someone who had to fly over and be there. We need to have this debate. For me, I want to continue to have this debate. It came to us in a very frustrating moment, so now we're tied up in knots a little bit on should it come out, should it not come out. It was that. I get that. But I think at the end of the day, for folks like myself, for Mr. Cole, I would hope to speak for my friends, for Mr. McGovern and Paul. This is our opportunity to do it. If we fail on this with the new administration's input, with a set time frame, then yes, then there is a problem. But I think standing with Mr. Cole on what he has done, where we're at right now, is let's move wherever you want to on this bill. And there's enough for us to disagree on everything else. But at least at this point, I want to commend Ms. Lee for her tenacity and staying at this. I just believe it was the wrong place at the wrong time to do it this way, but it triggered something that is the right place and the right way and still needs to get to the proper committee. And that's where I think we can get with this. So, I mean, we're in agreement in that regard. I think from here it allows us to have this discussion with the new administration's input, and we move from there. And at that point, I think we can move forward. We voted for it or against it. It doesn't matter. But at the end of the day, it was so eloquently stated, it is about the men and women who go and fight. Yeah, it is for those of us who actually, and there's many members now who have fought in Iraq and Afghanistan who are some of the loudest ones saying these things need to be addressed on a bipartisan basis across the aisle, who've actually been there. And so I think that's the kind of pressure that we'll leave in the proper way, in the proper time, do that, and I think we're going to move forward on that. And I applaud Mr. Cole for stepping forward and doing this, taking something that he really would have preferred to go on even further. But taking that and finding, I think what he said a few minutes ago applies to our House as a whole, both parties, both sides, is that sometimes we can't take victories and call them victories. We have to have everything at one time, and sometimes that's going to lead us down a very bad path. So as we look forward to that, let's talk about how we can win and how we can move forward for the betterment of who we are as a country and who we are as the people who fight. And Mr. Chairman, with that, I yield back.
Thank you very much. Is there any other member that was wished to be heard? I will just end up saying I feel like policy is important and money is important, and I felt like this was a policy issue. And I feel like it is a policy issue, not to be confused with the money issue of funding our military, and I feel very strongly about that.
Mr. Chairman?
Yes, sir.
I was just wondering if you meant, if we wanted to be heard on the AUMF. I'm done being heard on that, but I did want to, I haven't had a chance to talk with the panel. I wasn't sure what you were referring to, whether we were done with the AUMF or the panel.
I was in reference to the AUMF.
Yes, I'm done with that.
Does gentleman wish time?
Not even, I don't know if I'm next, though. Am I next?
Well, we're trying, we've just gone to opening statements about trying to answer Mrs. Lowy, who I told her I was willing to discuss anything that she brought to the committee. I told her there were 3 things. We've now talked about 2. Does the gentlewoman, does the committee wish to talk further about her questions? Okay. Hearing no desire to do that, we will move on forward. I want to thank each of you for, I know you're not about to go yet, but Mr. Chairman, how many amendments did you have in your subcommittee?
During the committee?
Yes, sir. 2. 2 ideas that came to your subcommittee for you to consider?
Well, we incorporated, over 1,000 member requests in the work
okay, 1,000 member requests, excuse me.
But there were 2 amendments that were considered
okay.
during the committee. I don't know if that included the manager's amendment, but 2 or 3.
So you had opened yourself up to the feedback from this body?
Yes.
Yes, you did. Thank you very much, Mr. Cole.
In the full committee, yeah.
Well, I think we've heard enough from me.
Well, we were talking specifically about the gentlewoman's questions. Now it's open to the.
Well, let me make a couple of comments because a number of things were said again that I agree with. And I think as a committee, we're surprisingly functional. And I want to thank the chairman, the ranking member for that. This will be the third year in a row that all of our bills have gone through the full committee process, have been open for full debate at the subcommittee and the committee level. And that's a good thing. That's the most functional part of the appropriations process, and it's the only part that the chairman and the ranking member have absolute total control over. And so we know they've done their job. Second thing is this broader question about open amendments on approach process is an interesting one that my good friend from New York raised, because frankly I remember, and this is a person we all hold in high regard, when distinguished gentleman from Wisconsin suspended that privilege of open amendments on Mr. Obey on appropriations bills. And that's when that started. We actually restored it and kept it for several years. And then last year, I think it was probably my friend, the Energy and Water Chairman's bill, that a poison pill amendment was asserted, and it won, and then people that got the amendment wouldn't vote for the bill. So that's an interesting thing. I warned our conference at the time. I do not like the fact that we're getting away from open amendments, open rules, excuse me, on approach bills. And I will tell you, that was not the majority position. It was, we need to keep the other side from putting us in a bad place, which was exactly what Mr. Obey had done. And so once you open this door on either side, it's awfully hard to close it again. We at least tried for a couple of years. I wish we would go back to that, because the people, I made this argument in conference, I think my fellow appropriators agreed, but people that were not appropriators didn't. I said, you're just weakening yourself. You're weakening your ability to come down to the floor. You're sitting here in the majority and you think you'll always get your amendments. I'll tell you two things. First, you won't always be in the majority. And second, you won't always get your amendments when you are in the majority. Because then it'll be about, well, we have to protect our amendments, our people, from your bad amendment, even though you're one of us. It'll just, you're weakening the ability of individual members. That's one of a very proud tradition. I don't know how we get back there, because I'm not sure the leadership of either party will let us get back there. I'm not sure the membership of either party will let us get back there. Again, when my friends were in the majority, they didn't want to take tough votes, and so they abandoned that. We tried it for a couple of years, but when it finally got too tough, when it was bringing down a vote, we abandoned it. So this needs to be a bigger institutional discussion, probably at the leadership level, but I don't think either of us can really throw rocks at one another, because we've both done it, and I regret that we did. In terms of the other process questions, I think my friends make a good point. I would prefer that all 12 bills come across this floor one at a time, and we all know that some of them would be individually popular and bipartisan, and others would have to pass on a straight partisan vote. It's just the nature of the business. But you know, again, my friends didn't do that either when they were in the majority, and so we've decided we don't have to do it now either, and so we come to these concoctions. I think still we will end up where we were in 16 and 17. We will end up with a bipartisan, bicameral, negotiated deal that probably a majority of each party can vote for. But I'd be happy to sit down with my friend and figure out how, if we can, how to work out this box. I know it can be done because I've watched you and Mr. Rogers before Mr. Frelinghuysen, and now Mr. Frelinghuysen produce all 12 bills, did what other people weren't doing, so we can get there. So just some reflections, but this is important that this pass. I hope it does, but we need to get back to a more open, regular order process.
Well, let me just say, Mr. Chairman, if I may, because I know that we are heading towards a vote, even though I can't see it through my back. But I just want to respond to my good friend, Chairman Cole, and to Chairman Sessions and all who are gathered here today. I have very fond memories of last April, the 2017 bill, which was really regular order. We worked in a bipartisan way. We all were so proud of the bills we produced. And I would like to, if you say how we would like to proceed, we're here now, this is where we are. many of us would like to be supportive of many of these bills, but it's not the kind of bipartisan process that we had in 2017. In fact, my concern is because the rules of the game were not being observed, this will be subject to sequester, and we'll see what happens next. Now, I think your very eloquent words refers to the fact that the Senate hasn't dealt with these bills, and at some point in the process, we'll be getting together with the Senate, and perhaps there will be regular order. But I don't want to just skip over the fact that we know how to do it the right way. We didn't have a 302A, kind of working backwards. So I hope, Mr. Chairman and Ranking Member, that we can go back to where we were in process, April, where we were so proud of the bipartisan work we were all doing.
Mr. Chairman, I think I have time, please.
I'm not sure mine's the last word, but this may be heresy, but I think the last 3 or 4 weeks have been fairly hectic. But I'd like to say that in many ways they have been bipartisan, and it's been done without any acrimony. So I think we've maintained the institutional Appropriations Committee process, and that's why I started off my thanks to all those chairs and rankings for working very closely together. Even though we had our differences, we did get our work done at a very quick pace, and I'm proud of the effort. Thank you.
Well, I know we got to go, but I respond because my good friend from New York is kinder to us than I would have been. We shouldn't have been doing that in April. We should have been doing it in December. And one of the reasons we are here right now, and all our appropriators told this to our side, you need to get this done. Because if you want to do this stuff in regular order, now we did get it done, and we got it done in the right way, and it was bipartisan, it passed with substantial majorities. But that put the chairman and you and all our chairman and ranking member in a terrible spot. And that's why this galloping race that we have and no chance to bring individual bills before, with the best will in the world, we could have had a hard time doing that and getting these things done. So we got to get our work done in the calendar year at least. The fiscal year would be better. Otherwise, there's just simply not the time to do the things we know make for a better bill and create contention. And let me end this to my friends on both sides now that are not appropriators. Look, if you want to ever do anything in appropriations, you have to understand a fundamental reality. Appropriations is always bipartisan. It starts partisan. The majority writes the bills, but to pass the bills, you can't get them through the United States Senate with the rule of 60. And frankly, if you're a Republican, you need to look in the mirror. We haven't moved spending of bills across the floor without Democratic help since 2012. So if you set up a process and you think you can run a partisan game, you are only kidding yourself. You'll run into the wall and it won't work. So in the end, we have to have a mechanism where we can sit down. You've done it within the committees. We did it. And I think left to your own devices, we'll get there at the end of the day. But the rest of the institution on both sides of the aisle, the body, need to understand that too. I actually had a member tell me, well, I don't want to be for another one of these deals where it's 160 Democrats and 160 Republicans. I say, that's the only deal you're going to get, unless you want a year-long CR. And even that would take 160 Democrats and 160 Republicans. So, I mean, that's just not the way we work. That's not the way it can be done. And I just want to thank my friends, all of whom are masterful practitioners of this, all of whom have demonstrated over and over they know how to get to a bipartisan deal within their committees and within the committee as a whole. And we'll just work on trying to...
Probably arrived here, and that is we're going to be open for business till late this evening. We want to hear from every member. We, however, at this time have votes on the floor. I would ask that this panel please come back, and we'll be subject to the call of the chair after the last vote. Yes, yeah, yes, sir, yes.
Testing 1, 2, 3. Testing 1, 2, 3.
Rules Committee to come back in order. Thank you very much for this panel, Panel 1, to come back and to allow the membership opportunity. Is there any other member that would seek to have questions for the Panel 1? See none. I want to thank each of you for coming back. Did the gentlewoman feel like she received the benefit of any questions she asked to be taken care of? Absolutely. Good. We appreciate your consideration. Yes, ma'am. Well, my point was for the gentlewoman, you came and asked legitimate, honest questions, and I want to make sure that you feel like not only this committee takes these seriously, but that we answered your questions. The gentleman, Mr. Ryan, feels very strongly about a number of these issues. He and I have spoken about that. You and I have spoken. Mr. Dent and I have spoken about them. And your seriousness to approach this from your perspective is very important, and I appreciate you very much. This would end your recognition as you chose. The only thing I'd say is please remember, if you brought anything in writing for awesome stenographer and leave for her before you leave, that would be appreciated. And thank you very much. This panel number 2, panel number 1 on the appropriations, panel number 2, we'd now go to the gentleman, Mr. Simpson, the gentlewoman, Mrs. Granger, the gentleman, Mr. Carter, the gentlewoman, Mrs. Capter, the gentleman, Mr. Vislowski. Pete, I know you've been sitting around here, and Ms. Roybal-Allard. We would welcome you to this panel, and thank you very much for joining us. Obviously, the gentlewoman, Mrs. Granger, when she comes back, I know she was here for some period of time. Mrs. Capter, we do want you to be a part of this panel also. Thank you very much for joining us. Thank you very much. We're going to start with the gentleman, Mr. Simpson and Ms. Capter, where they will we will entertain their comments. Appreciate each of you coming here this evening. Anything you've brought in writing, we appreciate you giving to our awesome stenographer such that she's able to move through exactly what your words and comments are. And the gentleman, Mr. Simpson's recognized.
Thank you, Mr. Chairman.
Yes,
I'm pleased to be here to present the 2018 Energy and Water Bill. Mr. Chairman, before I review the bill, I'd like to thank you and the other members of this committee for all the hard work that you do to ensure a fair and orderly process. I'd also like to recognize Chairman Frelinghuysen. It is because of his leadership and unswerving commitment to the appropriations process that our committee has managed to bring 12 bills through the full committee that are ready for consideration by the House. I'd also like to thank my ranking member, Ms. Loy, and Ms. Capter. As always, their thoughtful approaches to issues have made this a better bill. The bill totals $37.6 billion, which is $209 million less than last year's level and $3.2 billion above the President's request. Increases over last year's budget are targeted at those areas where they are needed most to provide for our nation's defense and to support our nation's infrastructure. The bill provides strong support for the Department of Energy's national defense programs. Weapons activities is funded at $10.24 billion, up $921 million from last year's level, to keep our nation's nuclear deterrent reliable and effective. This increase will fully fund the ongoing stockpile life extension programs and will make substantial progress towards addressing the continued deterioration of infrastructure across the enterprise. The recommendation for naval reactors is $1.49 billion and includes full funding for the Columbia-class ballistic missile submarine, formerly referred to as the Ohio-class submarine. Additionally, the bill provides funding increases across the Department of Energy to defend against cyber attacks and with electrical delivery and energy reliability to strengthen energy sector cybersecurity preparedness, response, and recovery. This bill addresses the critical infrastructure work of the Army Corps of Engineers, providing a total of $6.2 billion, an increase of $120 million more than last year. This funding level includes meeting the annual target for the Harbor Maintenance Trust Fund activities, which is $1.34 billion for fiscal year 2018. Finally, the bill sends a clear message that it is time to address the long-term storage of spent fuel and finish the Yucca Mountain license applications, with $120 million going to the Department of Energy and $30 million to the Nuclear Regulatory Commission. Thank you for your time and attention. I respectfully ask for a rule that provides for orderly consideration of this bill.
Mr. Simpson, Mr. Chairman, thank you very much. I note that you have your very able ranking member who not only comes up to the Rules Committee during the appropriations times, but is a very dear friend of this committee, and the gentlewoman is recognized.
Thank you, Boy, for that introduction, Mr. Chairman. Thank you, and Ranking Member Slaughter, and members of the Rules Committee. I appreciate the opportunity to appear before you this evening. Have no doubt the energy and water development portion of this bill is intended to keep America in the scientific lead globally against fierce and sometimes nefarious international competitors to benefit our national security and economic growth. While Chairman Simpson has worked diligently and effectively in a bipartisan spirit to incorporate the interests of members from both parties, where possible, much of the funding in this bill falls tragically short. Let me start with the many areas of the bill where we agree with the Chairman. The Corps of Engineers, one of the most job-creating accounts essential to America's domestic progress, is a bright spot within the bill. The agency is nearly $1.2 billion above the President's harmful cuts, ensuring that some ongoing improvement projects will continue and thousands of construction jobs will be created. The Chairman protected the Office of Science from the drastic cuts proposed in the request. The Department of Energy's scientific facilities are critical in the development of energy technologies to assure U.S. energy independence and also make large contributions to high-energy innovations, for example, in science and in healthcare that will improve diagnosis and treatment of diseases like cancer. Publicly funded research contributes to a strong economy, creates jobs, and ensures the United States maintains its position as the global leader in innovation. The funding for environmental cleanup reflects a balanced approach. On the other hand, the bill's support for the science account is offset by the early termination of advanced energy research. We call it ARPA-E, beyond even that of the administration's request. Since 2015, ARPA-E projects have attracted more than $1.8 billion in private sector follow-on funding. ARPA-E projects have generated 218 patents, and 56 companies have been formed as a result of this funding. This highly innovative and effective program enjoys bipartisan support on both the Hill and off the Hill, including from U.S. Chamber of Commerce and the heads of Southern Company, PG&E, and DuPont, among others. I also disagree with the funding provided to the Energy Efficiency and Renewable Energy Accounts. We call it EERE. While the Chairman blunted the obscene budget request, the amount is far below what is necessary to maintain and, in some cases, regain American leadership in the clean energy economy and create jobs. The rest of the world is ready to lay siege to our technologies and attempt to steal intellectual property every day, thousands of times. If we do not continue to innovate, this bill does not meet that challenge. The energy and water portion of this bill represents a genuine effort at bipartisan compromise. However, it falls short due to impediments created by major decisions beyond our subcommittee's control. Most significantly is the Republican leadership's Budget Committee failing to complete its essential work. Thus, majority spending targets for non-defense discretionary accounts require destructive reductions across the government, ensuring that the energy and water accounts will be only the first casualties which result. Other bills dealing with education, the environment, senior citizen benefits are severely shortchanged and underfunded. This is not the way to manage the affairs of a great nation. America needs a strong nation to defend, not a weakened one. I appreciate the Chairman's strong support for many areas in the bill which are important to the nation's economic competitiveness and job creation. However, while the Chairman largely limited the damage was principally to Democratic priorities. Further, the inclusion of controversial riders is an unnecessary diversion from our primary responsibility. Chairman Sessions, may I plead with you that the committee provide an open rule for this bill? And finally, I would be remiss if I did not express my deepest appreciation for the approach the chairman took in the process of developing this product. While I disagree with several of the outcomes, the chairman's manner is constructive always, spiced with an amiable humor, and his keen focus on getting our work finished under regular order. All of these qualities are deeply appreciated as we witness other committees mired in chaos and not able to complete their vital work. Thank you for the opportunity to appear before you today.
Ms. Capito, thank you very much, especially for your kind words about the young chairman. I know both these jobs, roles that each of you place both of you in a position not only of responsibility but decision-making, and I appreciate your kind words for each other. We're delighted that you're here. I would next move to the gentleman from Round Rock, Texas, the gentleman, Judge Carter, and his obviously very able ranking member, Ms. Roybal Allard, and the gentleman is recognized. If I could, Judge, if I could have you pull that microphone up, make sure the green light's on, we'd appreciate you. Gentleman's recognized.
Thank you, Mr. Chairman. Chairman Sessions, Ms. Slaughter, thank you very much for having us here today. I'm here to propose an amendment to the security package that's being considered here today. This amendment is $1.6 billion to construct 3 distinct barriers, also known by some as walls, on the nation's southwest border. I offer this amendment because it's imperative for DHS to get a head start procuring land on these projects that will be built. And as I know Chairman Sessions knows, and for the information of the rest of the panel, Texas retained its public lands. There's no state lands or federal lands that border on the Rio Grande River. So land will be, wherever we build, we will be building on private land. If DHS does not have the funds in hand, they can't approach these landowners, credible offers to buy their property. Mr. Chairman, every day we wait to begin this construction of these border projects is another day of delayed security for the United States. We simply just can't wait any longer. Let's be clear. This amendment doesn't underwrite the construction of a solid wall stretching from Brownsville to San Diego, California. The wall to be built in Texas will not be built in the Big Bend National Park, the only federal land on the border, nor will it be built in Arizona's Forbidden Desert, because actually they take care of barricades themselves by the dangerousness of those areas. These projects are 3 high-priority vulnerable areas of the country where the Border Patrol says they cannot stop or impede illegal incursions into our country. This does this mean we'll be dealing with illegal migration? Yes. But it also means that terrorists, drug smugglers, human trafficking organizations will be targeted and apprehended, because without a doubt, if illegal migrants can exploit the vulnerability of the nation's border, so can these dangerous criminals. These projects are necessary to gain operational control of the border. What does that mean? Operational control is the ability to detect, identify, and prevent illegal border crossings, to enable law enforcement to respond to illegal activity, and appropriately train and equip the Border Patrol to conduct their mission successfully and safely. The locations chosen for these construction projects were identified by CBP's annual planning process, which identifies gaps and vulnerabilities in border security, and then defines the requirements for attaining operational control of those various areas. Vulnerabilities include criteria like what they call vanishing time. That means time to vanish, which measures the distance from the border to the closest town or major road or other vanishing point, which would prevent agents from interdicting illicit border crossings because they would vanish into the population. This analysis identified 74 miles of border that is extremely vulnerable to to illegal incursions. The analysis also found that border barriers, fencing, and levee walls would enable the Border Patrol to secure these areas. So this amendment proposes to invest $1.6 billion in construction of 28 miles of levee wall in Hidalgo County, Texas, 32 miles of bollard wall in Starr County, Texas, and 14 miles of wall in San Diego, California. The two Texas projects are in the Rio Grande Valley. We in Texas call this area the Valley. The Border Patrol says these areas are their top priority for border infrastructure because they are constantly exploited and the border is almost entirely open in that area. The third project in San Diego is necessary because the existing border fence, which was constructed back in the early 90s, is old and falling apart. And this structure is located in a very densely populated area. According to the Border Patrol, drug smugglers, gangs, traffickers have used battery-operated power tools to breach that fence, and then they push packs through the fence of drugs and other contraband to couriers waiting on the other side, who then vanish into the community. And in last year alone, that fence was breached over 800 times. Mr. Chairman, critics complain that putting up physical barriers on the border doesn't work and aren't necessary. With respect, I disagree. Let's look at the facts. In the early 1990s, 500,000 people were apprehended as they attempted to illegally cross the border in the San Diego sector. 500,000 people apprehended. To combat these illegal crossings, CBP installed security infrastructure improvements. And by fiscal year 2016, the number of apprehensions in the sector has plummeted to 25,000. That means barriers work. There's similar success stories that have occurred in El Centro, in Yuma, in Tucson, and the El Paso sectors, all of which have barriers. After investments were made in infrastructure, technology, and agents, crime rates declined, habitats damaged by illegal border traffic recovered, local communities grew and prospered, and commerce increased. Mr. Chairman, I'm committed to bring these same successes to our parts of Texas. More importantly, I'm committed to ensuring that the dedicated men and women of CBP who walk the line every day to protect this country have the capabilities they need to safely carry out their mission to protect our nation's border. For these reasons, I ask that this amendment receive a rule that makes it in order. I thank you, Mr. Chairman.
Thank you very much, Judge Carter, and your testimony is most instrumental. We've now moved to your ranking member, the gentlewoman from California, Ms. Robar Allard. Gentlewoman's recognized, and we're delighted that you're with us.
Thank you very much, Chairman Sessions, Ranking Member Slaughter, and other members of the committee. Thank you for the opportunity to testify this evening. One of the reasons I'm here is because I'm disappointed that the Department of Homeland Security funding bill will not be included in what is being called the Make America Secure Appropriations minibus. I do not understand how the minibus can reasonably be given a security label without including the department that was established precisely to ensure the security of our homeland. As you know, the DHS is responsible for security at our borders, security for inland waterways and the coastal maritime environment, security for air and surface transportation, security for the president and vice president, security of cyber networks and critical infrastructure, and for helping state and local jurisdictions prepare for, prevent, and respond to terrorist attacks and natural disasters. My understanding is that the Rules Committee may include a provision in the rule that would insert funding into the minibus for the President's border wall. Why include just this one part of the DHS funding bill over the funding of more pressing and immediate security needs? Why not simply add the entire DHS bill to the 4 security-related bills the House will consider? The Department of Homeland Security is the 3rd largest federal department after the Department of Defense and the Department of Veteran Affairs, and approximately half of the DHS funding bill supports personnel. Inserting only border infrastructure funding is concerning for two reasons. First, the border wall funding is not well justified and should not be prioritized over other compelling Homeland Security priorities, such as the acquisition of Coast Guard icebreakers and the hiring of more custom officers. Second, I believe it would send a terrible message to the frontline Homeland Security personnel, many of whom routinely put their personal safety at risk to serve our country, that a majority of the House is focused more on the border wall than on the important work they do. While I do not support the DHS bill in its current form, I strongly believe the House should have the opportunity to consider the entire DHS bill as part of the Make America Secure Appropriations minibus. In doing so, the House would be in a stronger position to debate, amend, and more responsibly judge the competing funding priorities, costs, benefits, and trade-offs in the Department of Homeland Security funding bill. Since the majority will not include the entire DHS bill in the security minibus, I have filed an amendment to address the concerns I have highlighted by prohibiting the use of any DHS funds for border wall construction. If the House were to consider and adopt my amendment, it would at least preserve the option for the House to later consider the DHS funding bill as a whole. I thank you for your time, and I respectfully ask that my amendment be made in order. Thank you.
Ms. Roybal, thank you very much. We're delighted that you're here, and your ideas are not only those that need to be considered, but we appreciate your insight into those, and we appreciate it. Ms. Granger, we're delighted that you're here. The gentlewoman is assuming a new role now. She's moving from what might be foreign operations to defense matters, and I know that this is a job that the gentlewoman has sought since she has been in Congress, and I must say that I am delighted not only that you have that responsibility, but also that you have the gentleman, Mr. Viscoski, who to work with you and to be a ranking member, and I'm sure that not only the two of you will look after our military, but to the smallest level of detail that's necessary, and we're delighted you're both here. The gentlewoman is recognized.
Thank you, Mr. Chairman. Thank you for allowing me to testify in front of you today and in support of the fiscal year 2018 Defense Appropriations Bill. The bill provides $658 billion for defense, which is $28 billion above the President's request and nearly $60 billion above last year's levels. This bill furthers the process of rebuilding our military and matches the funding in the National Defense Authorization Act that passed this House. All federal dollars are not the same. We need to prioritize national security after years of neglect in an increasingly dangerous international situation. This bill takes care of our troops by providing additional manpower and fully funding a 2.4% pay raise. It provides additional funding for key readiness programs and robustly funds maintenance of equipment and facilities. The bill includes specific investments in several areas, such as air superiority, a $4.3 billion above request, shipbuilding at $1.6 billion above request, fully equipping the ground forces, research and development to maintain our military's technological edge, which is a $10 billion above 2017. Defense health programs, an additional $644 million for medical research. The bill also provides additional resources in a National Defense Restoration Fund, which is $28.6 billion, to allow Secretary Mattis to begin investing in a new defense strategy now instead of waiting until next year. It's vital that we preserve the National Defense Restoration Fund in its current form to allow Secretary Mattis and the service chiefs to rebuild the military. This fund is structured with strong congressional oversight. After the Secretary and service chiefs determine what they need, they must send their plan to the defense committees for approval. I urge this committee to resist the temptation to repurpose this fund for specific projects. This fund is desperately needed by the Department of Defense, and I will not be supportive of any amendments that use national defense restoration funds as a source to offset spending increases for other projects. The bill gives our military leaders the sufficient, sustainable, and stable funding they have told us over and over again that they need. I urge the committee to adopt a rule that protects the important national security priorities in this bill and safeguards the National Defense Restoration Fund. Thank you.
Yes, ma'am, thank you. Pete, welcome. We're delighted that you're here, and the gentleman is a strong voice for the United States military. I know your love of the men and women and the families that support this great nation. The gentleman's recognized.
Chairman, thank you very much.
Yes,
and my
sir.
question would be, is every member from Texas a chair?
No, sir. No, sir.
No, sir, okay.
No, it's actually, it's not even close. It's not even close. But let me say this, that I hope that wherever there is a Texan, that there is a recognition that that person brings to the best ability, as Mrs. Granger does, as Judge Carter does, a sense of fairness, but they will stand for those things, as you heard Mrs. Granger say. She deeply believes what she believes, and I think that is what we bring to the table. So thank you for your indulgence in our opportunity to lead.
All right. Mr. Chairman, I would just make 4 brief remarks. One, because this is Ms. Granger's first bill as far as chairing the Defense Subcommittee, to congratulate her on her efforts. She took over in a very difficult circumstance where we were dealing with fiscal year 17 matters until May. We did not receive fiscal year 18 budget until May 23rd, and we are here before you in July with a completed bill. She has, as always, been transparent. She has been fair, collegial, and thoughtful, and I appreciate that. Secondly, would appreciate an open rule, but if that is not to happen, would believe that the committee will make sure that we do not have amendments on the floor that are subject to points of order, so we can have an orderly consideration of the bill. Third, just one highlight in the bill. There is a significant increase in spending for the Department of Defense. I've made no secret of my belief that given the commitments our country has made under various administrations, we do need to spend more, but we also must exercise care. My concern going forward is there are still 4 studies taking place at the Department of Defense: the National Defense Strategy, the Nuclear Posture Review, the Afghan Strategy Review, and a counter-ISIS plan. Our bill will be on the floor this week before these plans are completed. The chairwoman was very gracious and I think very intelligent in making sure that we essentially fenced off about $28.6 billion until the results of those reports are brought back to this body so that we can pass final judgment when we know the facts. The final observation I would make, and I do not want to reopen the discussion that was very fulsome earlier this evening on the authorization of the use of military force, but simply would say that I hope the Cole language that I assume will be in this bill will be successful in its intent. I would hope that the administration participates, whether they do or not. It is our constitutional responsibility. We did have a successful vote on this issue in the fiscal year 17 consideration of the bill. We had a vote this year in 18, and would hope that, again, given the direction that the conversation led earlier today, we do not have this conversation for fiscal year 19. Thank you very much.
Thank you very much. The hopes and wishes that each of you bring to the table, not only about your ideas for funding this government, its activities, and the protection of this great nation, as well as building itself for the future, has really been in your hands and is a day-to-day job that each of you share. I don't know if how much we really need to get into all the issues, but I would say that we are trying at the Rules Committee to effectively manage things to where we do recognize that Homeland Security Judge would come up, but we're trying not to jeopardize necessarily the things that would allow people to vote against that bill for a piece part that they disagree with. Judge, I would ask you, is there anything in your mind that would make you believe that this literally one page, it's two, but the print, it could be on one, that the President of the United States is not in favor of or does not support?
I think you would support that. I've talked to Mulvaney, I've talked to the White House liaison.
Yes, sir. That microphone's right there, sir. Thank you.
I've talked to the White House, and I've talked to Mulvaney, and I've run the language around by them and what we were trying to accomplish, and they were fine with it.
Good. It is my understanding, so that I may state properly in public, that it is my understanding that the administrative is supportive of this.
That's the way I understand it.
Okay. Then I want to make sure that I'm not mischaracterizing this, because I believe that as a Texan, we're all aware of, including this last weekend, where there was a terrible circumstance that is tragic in San Antonio, where this evening there are a number of people who lie near death as a result of their transportation to this country. We have seen it for many years. We are sickened by it. We, however, are also very aware that the men and women who protect our borders find themselves where they are overrun in circumstances that is unfair to them. It is not possible to necessarily win a cat and mouse game, which is what that is. I've been on the border. You've been on the border. Mrs. Granger's been on the border. And I believe that this will enable them to come closer to the request that they are making. Bollard fencing is of short stature, not of tall stature.
It's pretty tall. It depends on where it is.
Well, it does depend upon where it is.
Yeah, and the bollard fencing in Starr County will be concrete base. These are steel poles about that big around.
Yes, sir.
And they go up about 18 feet or long.
They are there.
And the newest version, I haven't seen it, but I've been told, is something at the top, and I don't. But it's made out of steel. It's not
Yes, sir.
made
It
out of
is. It is what this administration, and I believe you have very effectively worked out the issues. And I want to thank you for sticking to that. The answer is the President of the United States ran an election on this issue, and we're attempting to work with the President. I want to thank you very much. Mr. Chairman?
Thank you. I want to thank my fellow, I've seen a lot of you guys in the last few weeks, and I want to tell you how proud I am, seriously, of each and every one of you and every other member of our committee. Madam Chairman, I'm particularly proud of you. I think the ranking member hit it just right. This is the biggest single bill that's done by the United States Congress. And for you to finish 17, and then with the amount of time you had, turn around and present us with a considered and thoughtful product that we had a lot of bipartisan support for is a remarkable individual achievement you ought to be proud of. But wouldn't be possible without your sidekick there. And I'm so proud of you, Pete, and proud of our fellow Democrats. We often say up here rightly that the most bipartisan committee in Congress is the House Armed Services Committee, but the most bipartisan committee on appropriations is the Defense Appropriations Committee. This has been done and considered thoughtfully and carefully with contributions from each side. I want to say the same thing to my friends in Homeland. We have some contentious issues there, but I never doubt that everybody there puts the security of the United States first and foremost in everything that they do and say. And I want to thank our friends on energy and water for doing the same thing. I mean, most people outside of Congress, I'm not sure how many people inside of Congress know who really runs the nuclear stockpile, but it's all run, out of Idaho. And you guys come together and work together very well for this Congress. I will make one point, and then I'll yield back. I would have liked to have done all 12 bills. In some ways, we were kind of on a roll. But I think, I think Chairman Granger said it best, this is the most important thing we do, collectively, what the three of your committees do to defend the country. And all the others are important, and all of them are really critical, and they all do important functions. But nothing surpasses this. So making sure this gets done before we go home makes a lot of sense to me. I think it's a really strong signal to the American people that Congress will put, in many cases, first things first. And I would also tell people, as they watch the debates over this, they'll see some commonality, they'll see some differences. The votes really don't reflect a great deal of difference about the substance of what your three respective committees do. And I still think at the end of this process, we did it in 16, we did it in 17, I think we will do it again. We will have a bipartisan, bicameral bill that will pass with substantial numbers of both parties voting in favor of it. And I would urge the administration to work toward that goal, because I promise you, if we don't get there, we're in a year-long CR, and we all know what that means for your respective committees, none more than yours, Madam Chairman. I mean, the worst thing in the world we could do to men and women in uniform is give them a CR or allow a sequester to occur. The only way that can be avoided is for Republicans and Democrats to sit down together with the administration and come to a bipartisan deal. There is simply no other way. So while there's always a certain amount of posturing and positioning, I actually look on all this as progress. You know, there's different stages along the way when this is partisan, but it either always ends in a bipartisan agreement or with a good, God forbid, a year-long CR, and I've seen that happen around here too. That happened under my good friend Chairman Boehner, and it was a bad thing. So I'm glad, appreciate all each of you do to help us avoid that. And with that, again, congratulations on work well done.
I'll say just one thing. Thank you for those kind words. We all have, this is a very rushed thing that we had to do, and you know that, of course. Our staffs are just, you can't say enough about them, and the defense staff did a wonderful job. Jennifer Miller, who heads that staff, had a tragedy occurred. Her father died just days ago, and so she was constantly still on the phone saying, "What do you need?" They're just amazing, and so we'll take some thank yous to them.
Thank you very much. Point well made. With that, yield back.
Thank you, Mr. Chairman, and I want to echo the Chairman's comments, particularly having this be the first season that I've been through on the appropriations process, and as a member of the Armed Services Committee, very pleased to see the bipartisan approach to these issues that we've taken, and also pleased to be able to go home, hopefully here shortly, and talk about the important work that we've done to get these bills out of committee, get them passed, and keep our promises to the American people. So I want to echo the compliments to all of you that have been heard so far, and thank you very much for your hard work and the work of the staff on these issues. Ms. Slaughter?
Thank you very much. And congratulations, Ms. Granger, on your ascension there. That's wonderful news. I've been an admirer of your work for many years. I mostly just want to give thanks. I want to give thanks to Mr. Simpson and Ms. Capter for your support of the University of Rochester Laser Lab, which is doing some incredible work. I also want to speak to the remade manufacturing, which is part of the Energy Department. The plans, I think, for this budget would cut that program out altogether. We have one going on already that I think will continue because the money is already there. And as you know, there is a set amount of federal money, and then the rest of it is through partners that they work with both in business and in academia. So we're very concerned about having these go, not that we're worried about ours because we think it's okay, but it drastically reduced the energy required to manufacture key materials. And we've had remanufacturing in Rochester going on at Rochester Institute of Technology for decades here. What's been extraordinary, they can increase the life of military machines to a credible degree, and both the Army and the Navy have been very happy with what they're doing, and they are leading this battle to do the same thing with many more things. They have over 100 partners, including the Idaho National Laboratory, of which we're extremely proud, and 70 private industry companies. So we're happy about that. But there is an issue. Oh, and let me throw AIM Photonics in while I'm doing that as well. AIM Photonics also has one of the innovative manufacturing groups, which does extremely well. And I need to illustrate that best for you by telling you about a small company of 12 engineers from Kodak who started their own business, Rochester Precision Optics. They had 35-year-old Kodak equipment that they repurposed and did the laser beams that took down the Somali pilots holding Captain Phillips. They've done some extraordinary work with very little, and I think we'd all love to know what they could do if they had some new equipment. I think it would be pretty remarkable. But I'm very concerned about some radio equipment that we're worried about. I represent Harris Corporation in New York. Once we were able to bid on combat radios, always won because they have the best radios in the business. And they have apparently I'm drowning in paper over here. They have gotten a new contract. Let me start with that. And they also did that under the Army's unique non-developmental item, an acquisition model where industry invests its own money in developing solutions that meet the warfighter needs. And the Army, in turn, leverages procurement dollars for developmental purposes. Harris has already invested over $300 million in this new manpack. It's going to be software-defined, can be every year modified, changed, added on to, whatever needs, and will last so much longer than what we have in the back. So the problem is we simply don't know why they haven't started that contract. It was supposed to have started in September with some vendors, but there may be a need to evaluate network capabilities, but a delay in the procurement of software-defined radios is not necessary, as they offer a platform, as I said, that can be upgraded with new waveforms over time to meet all the evolving needs. If you could help me get some answer from the Army as to what it is they're doing over there, having invested $300 million, that is a major investment, and as part of that contract. So if you could help me with that, any possibility?
Thank you. I understand the need of the Army following through on the commitments. We need to ensure that the soldiers' communication needs are also met as we send them into more remote areas. And so we will look at it. The satellite connections may not be feasible, may be denied by our adversaries, but I believe the committee needs to review the findings of the Army's recommendations prior to taking any action.
Right. Well, we want the Army to have the best there is.
Right,
And what we want is the warfighter to be perfectly equipped.
Yep.
But having started on this venture with the Army and investing $300 million of their own money in it after they won the contract, and then waiting forever to follow through with it is, we're just unable to get the answer for that. So if you could help me with that, I'd be most grateful.
Thank you. We'll get you an answer.
And Ms. Slaughter, if I could also mention
yes.
that line item that funds those types of programs is fully funded in the bill. So
It's
not
fully
a question-
funded?
It's
Okay.
fully funded at last year's level, so it's not a question of a reduction of funding, and would also join with the chairwoman as far as following through once the Army has made a decision as to how they want to proceed.
Do you know whether Harris might get a refund if they decide to go in another direction? They have no protection with this contract at all, do they? It's a wonderful company, been around about 100 years, and they produce the very best, and we all demand that they do that. Well, I guess I want to thank you all for your great work. Appreciate you so much. I know how hard you work. You work almost as late as we do sometimes, don't you? So thank you very much for that. Appreciate it.
Gentlelady yields back. The gentleman from Texas, Mr. Burgess.
Thank you, Madam Chair. Maybe the Appropriations Committee could appropriate some money for a clock for the Rules Committee, since we seem to exist in a clock-free zone up here. Too late.
We'll be glad to do that.
So I thank the gentleman for his insight. Gentleman from Texas, Mr. Carter, thank you for bringing this amendment. Can I ask you, is it permissible to ask where we're talking about these two, particularly the two in Texas?
Yeah.
Where the fence is located?
We've already got levee fences, levee barriers, and they are semi-walls.
Correct.
Now, you know, levees a mound of dirt. It's a combination of solving our problem and solving flooding problems on the lower Rio Grande. This would be in the Brownsville and up the river from the Brownsville area where it does flood annually. And this will keep the river within the banks. There's been an agreement with Mexico, so we're not dumping the water on Mexico, and all that's already been worked out. And there's some in place. This will just continue that. It has also been approved by various county governments as something they like. Now, recently, some of them have backed off, but that's all part of the politics of the valley. But it works, and yet it keeps people with access to the land by the river because it has automatic opening and closing steel gates that both block the water and block the access. So the landowner has access to the controls of those gates and can open them to get out to other areas where he has crops or livestock. Starr County is Rio Grande City. Back in the 70s, when I was a young lawyer, I represented a bunch of developers down in the valley, and Rio Grande City was Smuggler's Gulch then. That was a long time ago, and it's still a real issue. And they don't have a flooding issue. They have a real smuggling issue. And so this is what, and that would be the ballot fences, which I described to the chairman. And then going over to California, you probably heard about the fact they advertise for various people to compete with ideas for fencing. Well, whatever they've come up with, and they haven't come up with anything yet that I'm aware of, will probably be, there'll probably be several test sites along this area. But that fence, they've got two fences down there, and the secondary fence has gotten to be full of holes because it's been around and it's fallen apart and they've cut so many holes in it. They're going to replace that part of the fence with some new idea fence, and that's all I can tell you.
One of the things, and like many members from Texas, I've made a lot of trips down there and seen the situation. And one of the things that always comes up when you go down there, Customs and Border Patrol brings up the darn inability to clear cane and mesquite from the U.S. side. We're not talking about going into Mexico and clearing their brush away, but clearing on our side. You talked about the vanishing time, and boy, someone pops out of that river and into that underbrush, and they're essentially gone. There's no, I mean, you can have the most expensive aerostat in the world up there, but you can't track somebody going through that underbrush.
And the chorizo cane, which is the non-indigenous cane along the river, that's been a request, especially in Webb County, for a long time. I am in favor of clearing chorizo cane, and we will be working with those counties in a state and hopefully federal project combined to clear chorizo and hopefully kill it off. Because cane's kind of hard to kill. And then there are people that actually raise sugar cane down there too. And I tested, in fact, you might have been with me when I had me on the video. I took 2 steps back into the cane and disappeared. It was amazing. I'm no little guy.
Let me ask you a question, or it's more of a statement. I mean, in San Antonio, Texas, this weekend, we had a terrible tragedy.
My wife has been crying about that for 2 days. That is that's a really horrible thing when they put them in that many people in an 18-wheeler in 102-degree weather with no food or nourishment, and they just burn up.
Just perished. Last August, I was down in the Rio Grande Valley, lower Rio Grande Valley sector, and the number of people coming across was just unbelievable. I mean, it's like Greyhound buses going down, honking the horns, flashing the lights. People come out of the underbrush, get on the bus, and be taken into the Border Patrol station for processing. I mean, those numbers have just plummeted now. And I was down there over Memorial Day weekend and saw for myself how the holding center at Weslaco, Texas, was basically vacant. and that's a good thing. But also recognize that a lot of that is because of the rhetoric here has changed, and okay, good for that. But if we don't make some substantial changes, the folks that exploit this for gain are going to find other loopholes to exploit. And I think this weekend we just got a glimpse of the loophole that's coming next. Put people on a truck the other side of the border, somehow defeat the whatever screening process there occurs at the border checkpoint, and then it's on to somewhere in the interior. And
well, we have X-ray scanning both for 18-wheelers at Laredo, and Laredo, Nuevo Laredo, they have 14,000 trucks a day across there, so it's a lot, and they must obviously missed one, and but it may have come from someplace else too. I don't know where it came from, but we do have X-ray that pierces the trailers, and it's pretty effective, and we've got it set up portably at the away from border checkpoints, which we vary where those things are. But they walk around those checkpoints. A lot of them die on those ranches when they walk around those checkpoints. I was up with a rancher last time I was down there, and he gave us some dinner, and at dinner he told us that he'd pulled 125 bodies this year already of people who died trying to walk around the checkpoints. So it's a tragic situation. Very dangerous for people coming.
well, I thank you for your efforts for trying to solve this problem, and appreciate you not taking your eye off the ball. And thank all of our appropriators for being here. And I'll vote for all 12 bills if you'll bring all 12 bills up.
Thank you,
I told you that last week. I think we should. Thank you, Chairman. I'll yield back.
Thank you. The gentleman yields back. Does the gentleman from Massachusetts seek
I do,
recognition?
yeah. And I just point out, I don't think anything in your amendment would have prevented that terrible tragedy that the gentleman referred to. And I want to be on record as strongly opposed to this wall. You know, and President Trump promised, as everybody already forgot, but he promised that Mexico was going to pay for this border walls from day one of his campaign. In his 2015 announcement speech, he said, and I quote, "I will build a great, great wall on our southern border, and I will make Mexico pay for that wall. Mark my words," end quote. Later that month, he said on TV, and I quote, "All these other characters say, oh, they won't pay, they won't pay. They don't know the first thing about how to negotiate. Trust me, Mexico will pay," end quote. Then in 2016, he promised in a speech, and I quote, "Mexico will pay for the wall. Believe me, 100%. Believe me," end quote. Okay, well, he said that during the campaign, and he said a lot of things during the campaign that he didn't mean. So, you know, what's he been saying lately? What has he been saying since he became president? Well, this May, he said in a CBS interview, quote, "Mexico is going to pay," end quote. The interviewer asked, 100%, the whole thing? And the president confirmed, quote, 100%. They're going to be happy with it. They're going to be very, very happy to pay for it, end quote. And his thinking hasn't changed since then, because even after meeting with the president of Mexico in July, President Trump answered, quote, "Absolutely," end quote, when asked whether he still expects Mexico to pay for the entire wall. Those are a lot of strong words. Trust me, 100%, absolutely. Mark my words. Not a lot of wiggle room there. So President Trump seems pretty sure that this wall will be built with Mexican pesos. But I'm looking at your amendment, Judge Carter, and all I see is $1.6 billion, 1.6 billion U.S. taxpayer dollars. Now, maybe I'm missing something here. So where in your amendment does it say that Mexico will pay for the wall? I know you said you spoke to some people at the White House, some staff. Did you check with the president on this? He seemed pretty sure about Mexico paying for this wall. And where in your bill does it say?
Mr. McGovern, we are the Appropriations Committee, not the Ways and Means Committee. The revenues are their problem.
Well, I know, but I mean, but again, I'm just going by what the president said, that taxpayers weren't going to be burdened with this wall. Many of us who find it deeply offensive, and so it looks like in your amendment, it's $1.6 billion in U.S. in taxpayer dollars. I mean, experts say this wall will likely cost more than $20 billion in total. Where's the rest of the money going to come from? Taxpayers going to fund the additional $20+ billion for this wall?
I assume that's going to come from something that's done by the Ways and Means Committee.
Well, I mean,
Certainly not the Appropriations
but I think it would make sense if we knew where the money was going to come from, because it sounds like taxpayers are going to get saddled with this. And I'd say, many of us, not just Democrats, but some Republicans, find this idea of a border wall to be offensive and irresponsible, and I think is breaking the president's promise that Mexico will pay for the wall. So I'm alarmed by reports that on an issue of this magnitude may very well be self-executed in the rule. I mean, if that's the case, I mean, the Republican leadership doesn't even have the guts to bring it to the floor and allow members to vote up or down on it. It's just going to be kind of snuck into a rule. And I would hope that the chairman of the Rules Committee will guarantee that all members will have an opportunity for an up or down vote on the House floor. Not as part of a rule, but an up or down vote. I mean, this is an issue that divides this Congress and is very divisive in this country. And the idea that it could be kind of, just kind of in a very kind of underhanded way made in order without us being able to vote up or down on it, I think would be a terrible mistake. And again, I mean, we've been promised regular order by the Speaker time and time again. We haven't seen it yet. I'm not going to hold my breath that we'll have it here, but I think on this issue, there ought to be an up or down vote. If Mr. Carter wants his amendment in order, it ought to be separate, and you vote up or down on it, not self-executed in the rule. And I hope we get that assurance, Mr. Chairman, that the Rules Committee won't self-execute this.
Thank you very much. I guess that's a question to me.
Yeah.
Yes, ma'am.
Something, just to add a little bit of balance to this discussion. Absolutely, I don't think anybody isn't concerned about the tragedies of what just happened, and it's happening all the time. And people are crossing under horrific conditions, they're dying, they're mistreated. But the wall itself is not going to stop that from happening. And one of the concerns I have, other than the fact that I don't think it's right to build this wall for the reasons that Mr. McGovern has already stated, is the flip side is, in order to build the wall, what is it that we are not doing? And if you talk to the Border Patrol, they will tell you not only the tree soaking, the money that we need for that, but they need money to build roads in certain areas where a wall doesn't make sense, which they're not getting. They need technology. They need money for more technology because there are other areas along the border that where you can't build a wall. The only thing that would work would be additional technology. But more importantly, one of the major concerns that I had, particularly when I visited Alaska, is that along the Arctic, the Coast Guard has one heavy cutter that's already 37 years old, probably doesn't have much more lifespan. There are months on end when they have no presence there along the Arctic, where the Russians have 41 cutters. I believe 3 or 4 are the icebreakers, and I believe 4 of them are the heavy icebreakers. So if we want to talk about vulnerability and about protecting this country, we need to think about where the real vulnerabilities are against people who truly do want to do this country harm. And Alaska, what's happening along the Arctic, is just one example of just how vulnerable we are and how dangerous things are there, and we are not providing them with the resources they need in order to protect that area. And I'm talking about, in order to fund maybe 3 more heavy cutters, was something along the lines of $2.1 billion. And one of the reasons we're not doing it is because we're putting $1.6 billion into this wall. So I just wanted to give the flip side of what the impact is of putting all this money into the wall and what it means to other areas in our country where we truly are vulnerable and where our enemies have major opportunities to do this country harm.
And I think that, and I hope that the Roybal Allard amendment will be made in order. But Mr. Chairman, I think that on an issue of this magnitude, we should not be self-executing it into a rule. There ought to be an up or down vote. This is a matter of process. We all have different opinions on this, but as a matter of process, there ought to be an up or down vote on it. I hope we get a guarantee that that's what will happen, and it won't be kind of. The only reason why you'd want to self-execute is because you're afraid that a majority in this House won't vote for it. And I would hope that we could have a separate up or down vote on it.
I want to thank the gentleman for nailing whatever he thinks is correct. The bottom line is, and the gentlewoman is entitled to her own opinion, the drug war in Chicago, where over 100 people were shot this last 4th of July, and that's why they were shot, because it's a $3 billion market. And the people in Chicago, people all over this country have dealt with the Sinaloa drug cartel and lots of others who came to this country and have created a huge market. Granted, they were Americans that chose to do this, but this drug cartel, we've been inundated by cheap heroin, cheap methamphetamines, and other things that have flowed across our border. And we've talked about this for quite some time. The ability that our Border Patrol, the men and women who protect this country, to be able to stop the onslaught of people who just literally run them over and hold guns at their head and hold their families hostage, and the federal judges who have for years been trying to protect us were overrun by people, and including presidents who would have what's called catch and release, a mockery of justice and a mockery of our laws. That is what created the huge viewpoint from Americans that we believe that if a country cannot sustain its own borders, its sovereignty will be gone. This self-enacting amendment provision that is placed in there, which I placed in there because I really am trying not to have it in a Homeland Security to make you choose how you would vote in that bill. And secondly, the facts of the case are the President of the United States, who has a huge say about this bill, asked that this be done as quickly as the first appropriations bills are done. I gave the gentleman a chance, and I'll be glad to again. And we are going to comply with allowing the President to be able to have things that he wants also. This is not unusual for us to have a president who has an opinion about an issue. But the facts of the case are, I'm trying to get this done in a way, and the language which is here, this page, literally one page, is not about a wall. It is about a professional evaluation, as Judge Carter has talked about the needs. Thank you. This is it right here.
Right.
That's the language, and it talks about specifically what would be there and the kind of fencing that would be available. This is to allow the men and women who protect this country to be able to put a barrier there that allows them a chance to effectively enforce the laws of this country, and then to not be overrun in that process by huge numbers of people. That's what this is about. And so I do want to, I will accept it. I'll stand up and say, you're dadgum right. I put it in there. Right. It's going to be self-enacted. It is going to be a chance with anybody who wants to vote against the bill, they can vote against the bill. But there are certain provisions, and the President of the United States personally asked that this be in here. Judge Carter knows that. I know that. And we're going to comply. Yes, sir.
Well, this is a rigged process.
Well, it's a
rigged process, and I will just remind the gentleman that, I mean, the House of Representatives is supposed to be a place where people deliberate and where the majority kind of carries the day. This is an intentional maneuver to basically either protect some members on your side from having to cast a tough vote, or if I could finish, or because you don't believe that a majority would actually vote for it up or down, and so you're putting it into a minibus that contains a lot of things. Many of them are good things. And by the way, I would say to my friends on the Appropriations Committee, by and large, I don't have a problem with you and the work that you've done. I have a problem with this committee and with the leadership of this House for rigging this process in a way that I think is undemocratic, and I think it demeans this House. And this, and on this issue, that's particularly polarizing, an issue, by the way, the President said that the taxpayers wouldn't be saddled with the bill on, which is wrong. And, you know, it's being put into the bill in a way that we're not going to have a real chance to deliberate. I think it's just bad form. And, you know, we go on and on and on about whether this is a good idea or a bad idea about a wall. I think it's a lousy idea. But the gentleman thinks it's a good idea, fine. Let's have it out on the floor. Let's everybody cast a vote and not try to hide it in these procedures. And I appreciate the gentleman taking responsibility for it. It doesn't make it any better. It's a bad process. It's a rigged process. And anyway, I thank the gentleman for the time, and I yield back.
And thank you very much. I would add it's not hidden. It was specifically noted in the rule, and we knew this last week when we put it out for everybody to see. And it was specifically noted, delineated and noted that way. So, look, I think it's well known either you're for this or against it. I give you that respect. I mean, just because there's a bill that's passed, I'm not for everything in the bill. Never have been for 100% of it. And I do recognize you do not like it. And I will tell you, it became a winning issue for the President by the American people. And I do believe that.
They didn't think they would get stuck with the bill.
Well, they thought they were going to get a wall also. They got a barrier.
May I speak?
Excuse me just a moment, please, Judge.
Okay.
Hold on just a moment. Yes, ma'am.
I just want to say that I want to associate myself with what Mr. McDonough said. I don't think sensible people, there's a wall there already in large parts of the southern parts of the country.
Where they aren't is where they're putting this.
What I've been told is that San Diego has 3 of them. Is that correct?
That's correct.
And it still doesn't work.
Well,
so
that's,
why in the world anybody thinks is...
That's not exactly true. What he said is it's been pulverized
Uh-huh.
over time, and they're reconstructing pieces of it.
I remember so clearly somebody saying when they're going to build a 20-foot wall that there will always be a 21-foot ladder.
Well, there may be, or underneath it, too.
And since it's going to cost $1 billion, $20 billion, that's it.
Well, we're not even near that figure yet.
Well, that's what experts tell us it will cost.
Well, but that's not what's before the committee at this time.
No, 1.6 billion is.
Right, 1.6.
Which we could use for an awful lot of things.
Including Coast Guard
Awful lot of
cutters.
things.
I don't know if that's the trade-off, but there are all sorts of needs.
Infrastructure is appalling in the country.
Yes, ma'am.
Flint's been drinking bad water for years, and I think if women ran the country, we would probably have higher priorities.
That's why Mrs. Granger's coming darn close. Judge Carter?
Mr. Chairman, I just wanted to say first and foremost, I've been blessed to serve with Ms. Roble Allard, and she's a good colleague, and we work well together. Our bill does contain a lot of electronics on the border. Our bill does contain money to begin the process of building an icebreaker. We banged out all these issues, but a portion of our bill is coming in this manner. The balance of our bill, we're hoping to pass in September. And I thank you for allowing me to be here.
And Judge, I agree with you. It might come before September, but we just don't know yet. We're hoping maybe.
I'm ready whenever you are.
Yes, sir, I know you are. Well, that's why your committee and the gentleman's committee, Mr. Freelandheisen and Ms. Lowy, worked so hard. Each of you did that too. Yes, ma'am.
In the 2017 appropriations bill, we asked the administration, the appropriations subcommittee did, to send us a plan and a justification for where they were going to be putting the wall.
Yes, ma'am.
Perhaps you can ask the administration about that because we've yet to receive it.
Good. Well, just so I'm going to partially respond back what I think the answer is. and $38,239,000 for planning for the border wall construction. They're going to come back with a plan to you. That planning function is in here also.
I think that's your language, right? That your request, yeah.
So I believe that the way I took it is, and it allows them a chance. See, I'd like to get that answer too. And I think Judge Carter would also. Okay, I know everybody's getting a little antsy. Judge Hastings, do you have any questions for this panel?
Very brief in my comments. I want to associate myself with the remarks of Mr. McGovern that I think were particularly pertinent. I also am deeply appreciative of all of the members of the Appropriations Committee, both chairs and ranking members. I think that they've done, as has been pointed out here, an exceptional job in getting us from 17 to 18, and although I'm in disagreement with the process itself with this minibus in the way that it's going about it, I just hope that we could return to regular order and allow for these matters to be handled under an open rule. Let me say this, Mr. Chairman. As the oldest person in the room, I've seen the development, excuse me, second oldest person in the room. I've seen the development of drug activity in this country in a variety of ways. I wish to correct a misassertion that my friend from Texas made about the rhetoric today stopping people from coming here. The rhetoric did not stop those persons that were in that truck in San Antonio. I might add, it goes unnoticed, but President Obama deported more people. And as a matter of fact, the running joke on the streets was that he was the deporter-in-chief. He deported 2.5 million people from this country at a given time. One thing you all need to understand, build a wall. Go ahead, do whatever you're going to do about it. It ain't going to stop the drug problem. If we were to be about the business of using the same money to work with our children in a more meaningful way, we would be better served. The drug lords, not the functionaries, not the little gangbangers and all of that crowd, the drug lords have great flexibility and great amounts of money. They outgun our law enforcement. When they were, during the period of the cocaine cowboys, it was about the Coast Guard trying to catch them and the few airplanes that we had. They developed fast boats that were faster than the Coast Guard boats. And one thing I want to make very clear, we aren't going to wall off the ocean. And I don't know why it is that we have this enormous feeling about the border in the southern portion of our country. And let me tell you one period, you know it from the movie The French Connection. Poppy seeds were grown in Turkey. They were processed in Marseille, France. They were delivered to Ottawa, Canada, and then transported to Kiptopeke, Illinois, in this country, and disseminated throughout this country during the period of the French Connection. Build a wall, they'll find another way unless we can do something about our own attitude with reference to drugs and our own dealing with our own children to really teach them how dangerous this particular activity is. And unless we get to that, then you can build all the walls you want to. It ain't going to stop drugs.
Gentleman yields back his time. Gentleman, does any member seek time? Gentleman from Washington is recognized, Mr. Newhouse.
Thank you, Mr. Chairman. I just wanted to, as one of the newest members of the Appropriations Committee, thank the chairman of these subcommittees as well as the ranking members for their hard work, and the entire committee, actually. Chairman Frelinghuysen and Ranking Member Lowy are no longer here, but the last couple of weeks I was able to witness a very good process and consideration of not only the bills in front of us, but also the opinions and the input of every single member that so wanted to be part of the discussion. So These are very deliberative subcommittees, as you probably suspect. These are very important issues, and I just wanted to give my compliments to both sides of the aisle for the way that they handle themselves. I think that's indicative of how the whole body should be, so just wanted to add my 2 cents as to how this process is going in the appropriations side of things. Thank you for bringing these important parts of this larger bill here in front of us. Some big stuff, important stuff, but I think something that we heard from the American people this last year, that there are many things in here that they wanted, and so we're responding to that, and hopefully through this process we'll give them what they want. Thank you, Mr. Chairman.
Thank you, sir. Mr. Polis.
Thank you. First, I wanted to, Mr. Carter, it's my understanding that this bill, or the amendment you're seeking, is how much would it fund the wall? 1.6 billion. Now, the cost of the wall, the estimates I've seen, they're kind of all over the place, but they're generally in the $10 to $40 billion range. So I guess my question is, what do you get for 1.6 billion? What does it actually build? Is there a wall somewhere, or a cheaper wall everywhere, or kind of what actually gets built with that money?
I believe it's 74 miles.
74 miles of the wall?
In 3 locations.
Okay.
Maybe you weren't in here when I was 28 miles into Dallas County, which is Brownsville and north of Brownsville on the river. 32 miles of Ballard Wall in Starr County, which is Rio Grande City, which historically has been sponsored bills in Texas for about 150 years. And 15 miles of replacement wall in San Diego.
And if you could, I'm not a wall guy, so I'm hoping you can explain to me a little bit what the different, what is bollard fencing and bollard levee or levee or whatever that is, kind of.
A levee.
What do those walls look like? What is that? What is a bollard levee wall and what is a bollard fencing wall? Maybe you can help, point me to famous walls in the world. Yeah.
All right. A levee is a mound of dirt that holds back water.
Okay. I'm aware of that.
Okay, that's a levee.
Mm-hmm.
Because it's not a levee, it's a levee.
Mm-hmm.
This levee has concrete reinforcement, which is necessary because that river backwashes, and this is sandy loam soil down there.
Mm-hmm.
So it has built into the levee a concrete wall that is about 18 feet high.
Mm-hmm.
On top of the levee is bollard fencing, which is steel poles about that big around and about that far apart. The ones on top of this wall are about 6 feet tall.
Mm-hmm.
So, and that is a levee to hold back the water with a cement wall that's part of that levee. Gates that allow the land, these are not on the river, they're off the river, and the land that's on the river belongs to a Texan or somebody. And so there are gates which allow them to access, but they're waterproof steel gates that close that allow them to access their land.
And then,
that's what the levee wall is.
And then what's the bollard fencing?
Bollard fencing is a concrete base about as tall as that dais right there, maybe a little bit taller, set down in the ground a pretty good ways. On top of that, those steel poles that are about 1.5 inches apart, but you can see through it.
Mm-hmm.
But it's a big steel wall, 18 feet tall.
And then finally, what is the secondary fencing that it refers to?
In San Diego, you have 2. This was done in the 1990s. You have an on-the-border fence. Remember, they don't have a river, so you can build on the border in the other states, not in Texas. Mm-hmm. Okay, you have a primary fence and a secondary fence. That's what they have. The secondary fence has been penetrated multiple times, cut holes in it, and it's worn out.
So it needs to be replaced.
So it needs to be replaced. Only certain parts. Mm-hmm. It's a much longer than 14-mile fence, or wall, whatever the heck you want to call it. Mm-hmm. But we're just doing 14 miles of it.
And the 1.6 billion. So I mean, I heard my colleague from Washington saying, this is what the American people, voted for. They wanted a wall. The only issue I have with that is in this particular version of 1.6 billion. To be clear, this is American taxpayer money, right? I mean, there's not Mexicans paying for this wall.
As far as I know, yes.
Yeah. Because, I mean, the other part of that Americans might have voted for a wall, but they voted for a wall that other people would pay for, not out of their own pocket. So I just want to point that out. I would also point out that in comprehensive immigration reform, we actually had $40 billion for border security, which would that have been enough to complete the entire wall, Mr. Carter?
Well, oh, and by the way, the question was asked about, I'm going to answer a question was asked about Canada.
Oh, that wasn't for me. But
Canada has 30 million people living in it, which is a little bit smaller than Texas. And below the Rio Grande, there are about, I think, 2.5 billion people. So there's a little difference between the southern border and the northern border. Back to your question.
And let me, by the way, and I don't remember where you were on immigration reform yourself, Mr. Carter.
I wrote an immigration reform bill, worked with Democrats and Republicans for 4 years.
That's right. So, and in that in one of the bills, I think it was the bill that was the Senate passed bill, had $40 billion for border
I didn't
security.
like the Senate passed bill.
What's that?
I didn't like the Senate passed bill.
But let's talk about that part of it, right? So it had $40 billion.
Our budget is $51 billion.
So that would even that would not have fully funded the walls. The budget for the new budget.
I don't know what the wall's going to cost.
Okay.
I'm talking about where they requested they needed barriers. It's all about getting from where the Border Patrol is to where the offender is. You need roads, and we've got roads in our bill, and you need something that slows them down so you can get to them.
Yeah, I don't think there's, disagreement about protecting our border. I think, I hope that as part of this bigger package, I know it's not in this one, there's also border improvements to facilitate legal commerce, legal immigration, all of those things.
There is in this bill.
And that's, there's in this bill too, which is great. That's the, which part of it is that? It's not the fencing.
Well, you're not looking at my bill, you're looking at an amendment.
Oh, okay. In your full bill, you have okay, sorry. In the full bill, you're saying you have some money for the commerce facilitation, the immigration, the tourism. Now, I would just point out again that the second part of what the American people wanted that my friend from Washington referred to is that other people would pay for this wall. We did have a proposal to do that, and that was comprehensive immigration reform, where in essence, we would require the people who were here illegally pay for the wall. They were to pay a fine, and that money was basically to pay for the wall. Rather than force hardworking American taxpayers to pay for a wall. So, I just want to see as we go forward, this is just as you said, this is a small payment here, but as you go forward and find a way to fund a $30, $40 billion wall, can't we find a way where people who are here illegally pay for it instead of American taxpayers?
I'm an appropriator. It's not my job to find out how to pay for it.
As a member who's been active on working on immigration
I can give you
reform.
half a dozen ways you can pay for it,
Yeah.
but you wouldn't like it, most of them.
Well, let's find the one I do. How about that? Ms. Roybal Allard, would you be open on, you remember comprehensive immigration reform as well, and if you recall, there was $40 billion for border security in that. And I think in that context where there was a way where we could actually address the broken immigration system in our country, Democrats showed willingness to fund the border security at levels way beyond what Republicans are seeking to do it. Maybe you can talk about kind of the Democratic approach where we believe that the resources shouldn't come from American taxpayers, but should be from fines that illegal immigrants themselves pay as they register and get right with the law.
Well, I think that's one possibility, but I really do believe that that is something that we need to debate. That's why we need to have a bill where we can debate and make those decisions based on all the information that we get. Unfortunately, we haven't been able to get to that point.
Yeah, and I do think the topic of pay-fors is relevant because there were specific pay-fors that were promised by the president, namely another country would pay for it, and I don't see any of that reflected here. If this was a gift from another country, I think many of us would be more receptive, especially if they provided jobs for Americans and we were building it and they were paying for it. That would be quite nice. But instead, I'm going to hardworking taxpayers in my district for a wall that they don't want to pay for. And there's so many other ways to pay for it. If you want a wall, again, there's as long there's no inherent opposition to border security. Democrats are for that. I think just the question is, we should find a way to make other people pay for it, not American taxpayers. So I know that that's not in the jurisdiction of the Appropriations Committee, but when you come with a spending bill that's just a deficit spending bill and adds $1.6 $6 billion to the deficit, you're essentially asking us to mortgage, our future and our children's future and increase the national debt by $1.6 billion for something that there are other ways to pay for it, that we don't need to increase the debt to do, and that we actually paid for as part of comprehensive immigration reform. I point out, not only did comprehensive immigration reform fund $40 billion of border security, it reduced the deficit by over $200 billion over 10 years. That was the scored version. So, I mean, there was money left over. You got the wall, and you made a substantial impact on the deficit. So I hope we can start moving that way. As Ms. Roybal-Aller said, we're not even allowed to in this closed process. I mean, here we are, and I hope, I don't know exactly what the methodology this will be used to include. I've heard rumors, but clearly this is not a process that allows Republicans or Democrats to come up with other ways to pay for border security, even though we have bipartisan support for a $40 billion border security package in prior sessions. Many of those members are still here. I'm still here, and would be happy to support that again. And I think that would be a way that it would inspire the confidence of the American people moving forward, as opposed to something that is fundamentally divisive, and I would add fundamentally unpopular, right? Again, popular if other people pay for it. Why wouldn't it? Why wouldn't it be popular? But not popular if you're asking you and me and my mom and my sister to pay for it, and your moms and sisters and your constituents to pay for it. So that's a big difference, between what the American people thought they were voting on and what they're getting. And I do think there's a way to deliver what the American people thought they were voting on. There's absolutely a way to deliver border security that we do not have to charge the American taxpayers for. And I think we did that very effectively through comprehensive immigration reform. And I hope that we can move quickly back to comprehensive immigration reform so that we can get this done. And I yield back.
Gentleman, Yosevak's time is there. The member that would seek time with the panel. See none, I want to thank this panel not only for their indulgence with us, but more importantly for your hard work, your offer to come defend your product, and perhaps more importantly for your expeditious time that you have done to help us to deliver a bill that the American people can recognize and see that we're moving forward, that Congress is doing its job. Thank you very much. If you'll please make sure anything you brought in writing will be available to our awesome stenographer. I appreciate it. We now are going to, yes, Judge, thank you very much. We're now going to move to the next panel, and I would ask that the gentleman from Alaska, Chairman Young, the gentleman from Virginia, Mr. Griffith, the gentleman from Rhode Island, Mr. Langevin, Mr. Polis, we will engage you. You may choose to go as you choose to the front or in your chair. Mr. Courtney and Mr. Gomez.
Mr. Chair?
Yes, sir.
Can I ask unanimous consent to
Yes,
insert in the record my testimony on behalf of my amendment? I might have a better chance of getting in if I don't testify.
Well, that objection will include that also.
What are we waiting for? I thought you were up there. Hey, well, listen, I thought you were up there. Oh, yeah. We meet again, buddy. We got to stop meeting this way. I got to get you to Alaska.
Thank you very much for joining us tonight. I know that each of you, including Chairman Young, have been here for a number of hours with your opportunity to come speak to the Rules Committee. We're delighted that you're here. Please know that anything you have in writing will be entered in the record. That objection so ordered. Mr. Chairman, I know that your young bride is waiting for you at home for dinner. The gentleman's recognized.
Thank you, Mr. Chairman. And I see the ranking members left. I will submit from the record my opening statement. I'm really here to offer Amendment 84, and that number may change. We've been talking to the Appropriations Committee to finance the regional corporations commissions, the Appalachian Commission, the Northern Border Commission, and the Delta Commission, of course, my Denali Commission. I can go into how good they've worked over the years. I want to compliment the Appropriations Committee because they did include some funding, but not nearly, I think, is necessary. We're not asking for a great deal more money than we did last year. We're not asking for a raise. We're trying to have a high-cost-to-board funding, so I'm asking the committee to accept my amendment and go forth with this bill, because it's been interesting to listen to this debate. Someday we'll get into that debate with yourself, and we'll see if we can't figure it out, because I have a larger border than the southern border. And there was mentioned about the Alaskan icebreakers. They are important. I funded and helped finance the first three icebreakers 37 years ago, and they're all worn out. That might want to tell me something. I better not. So, Mr. Chairman, I yield back.
Thank you very much. In regard to the gentleman, is there any member that would seek to question the gentleman, Mr. Young? Mr. Young, you're excused. Thank you very much. If you'll please leave that in writing, and please tell your young bride that I did get you home only several hours late.
And you're going to make me really very, very popular at home.
Yes, sir. About 25 minutes ago, you told me I was not so popular in your house.
Thank you, sir.
Mr. Langevin, we're delighted that you're here. Gentleman's recognized.
Thank you, Mr. Chairman, members of the committee. I want to thank you for the opportunity to testify before the committee today. I have several amendments that I will speak to briefly this evening, all within the Division A of this legislation. The first is Langevin number 64. Since 2001, DOD has funded the Information Assurance Scholarship Program, or IASP, in order to boost the nation's cybersecurity, the cyber workforce through scholarship and capacity building grants. Mr. Speaker, the cybersecurity is really the national security challenge of the 21st century that we face. And this challenge, this difficulty is going to be with us for many years to come. And the challenge in particular is the fact that we don't have the workforce necessary to do the jobs that we need done right now, both in government and in the private sector. And there are some hundreds of thousands or millions of jobs in cybersecurity that go unfilled right now. So my amendment right now aims to close that gap. Scholarship recipients are required to fulfill a service obligation by working in a cybersecurity position at DOD upon graduation, were this program to be fully funded. This program has been extremely successful, bringing nearly 600 students into the DOD workforce. However, due to budget constraints, the department reduced funding for the program beginning in 2013 and stopped recruiting new students. This program received $7.5 million in 2005, its peak funding level, but for FY 2017, it received a mere $500,000. So, Mr. Chairman, in this year's House-passed NDAA, we reinvigorated the funding while simultaneously expanding it to students pursuing associate's degrees so as to tap into a larger candidate pool. As you all know, the cybersecurity challenges we face are growing every day, and the scholarship program will help ensure that students are encouraged to pursue cybersecurity degrees and that more of them can come to work defending our nation. I'm simply seeking to do the same in this year's Defense Appropriations Bill so the two levels match. Mr. Chairman, I'd also like to highlight Langevin number 67. The Navy is currently developing the electromagnetic railgun, a game-changing technology that could enhance the missile defense capabilities on surface ships. Railgun has already demonstrated the capacity to launch projectiles at higher velocity than conventional naval guns, which provides extended range, improved response time, and enhanced lethality. So while the program is still in the midst of completing its science and technology objectives, it's clearly ready for the next step, a shipboard demonstration. So appropriating the transition funding, as was the plan all along, would sincerely help in this endeavor. Mr. Chairman, I'd also like to discuss Langevin number 63, which would support the Strategic Environmental Research and Development Program within the DoD for environmental and mission resiliency purposes. SERDP, or SERDP, as it's called, was established to address the environmental matters of concern to the Department of Defense by providing support to R&D efforts to enhance the Department's resiliency, reduce installation energy consumption, improve energy security, and facilitate water conservation. These issues are all matters of concern for the Department when it comes to mission resiliency, especially when it comes to our readiness for our training. CERDIP not only invests in pioneering technologies and methods to help achieve these goals, but it also provides local-based commanders with the data and the information they need to keep their installations and their service members strong, ensuring DoD environmental and mission resiliency for years to come. The bipartisan amendment that I'm offering with my friend, Mr. Lobiando, would restore funding to the President's budget level, which is itself below the level we authorized 2 weeks ago in the NDAA. And finally, Mr. Chairman, I'd like to highlight Langevin number 62, an amendment to strike Section 8017, which prohibits the Department of Defense from disposing of surplus Army carbines, rifles, pistols, or small arms ammunition. Section 8017 has one purpose: to ensure the $1 million transfer of tens of thousands of pistols from the Army to the Civilian Marksmanship Program, or CMP. While the CMP, which was founded over a century ago, has a storied legacy, it long ago ceased performing an essential governmental function, which is why Congress privatized it in 1996 with the intent that it become self-sufficient. Today, the endowment bestowed upon the CMP when it was spun out from the government has run dry, and the CMP is struggling. But it is not the taxpayers' responsibility to bail it out, to say nothing of the dangers of allowing tens of thousands of pistols to flood onto our streets. Now, proponents of CMP arms transfer argue that storing surplus arms is wasting government funds, and that giving them away to the CMP for immediate release, for immediate resale, will save the government money. Well, sorry about that. However, the pistols in question could easily be repurposed by the Army. It is only Section 8017's prohibition that prevents the Army from disposing of these armies in a cost-efficient manner. So I believe these important issues warrant general debate, and I therefore urge you to make Langevin number 62, number 63, number 64, and number 67 in order. With that, I'd be happy to answer any questions that may have, and I yield back.
Ms. Langevin, thank you very much. I did write those 62, 63, 64, 67 down, and I want to thank you. Does any member have a question for Mr. Langevin? Jim, I want to thank you not only for taking time to be with us, but I want to let you know that I ran into some of your Boy Scouts this weekend from Rhode Island at the Boy Scout Jamboree. They asked if I knew you. I said I did, and I thought you were a fine representative, but more importantly, a man who shows up, speaks his mind, and does his best. So I want to thank you for taking time. If you'll please make sure you do me a favor, if either you or your staff by tomorrow would bring anything that you brought in writing to prepare for the stenographer so that she can finalize her records accordingly, and I appreciate you taking time very much.
Thank you, Ms. Jim. I brought a copy with me, and I'll provide that.
That's great. You give that to Mr. Griffith. He'll make sure he gets it over. And the gentleman may, as he chooses, exit or stay.
Thank you, Ms. Jim, and I want to thank you also for the kind words and for spending a few times with our Boy Scouts from Rhode Island.
Yes, sir.
Jamboree.
Thank you very much.
Thank you, Ms. Jim, and the members of the committee.
Yes, sir. If the clerk would help Mr. Langevin, Ms. Booth, we would allow him that opportunity to gracefully exit. Thank you very much. Mr. Polis, if you'll grab that microphone there, the gentleman's recognized.
Thank you so much. I have 5 amendments to the Energy and Water Appropriations section and 1 amendment to the Defense Appropriations section that I'll be testifying about today. I'm not actually seeking that all 5 of the Energy and Water Appropriations section amendments are made in order. There's 3 that are in the same general area, and we just need 1 of those 3. And so I'll talk about that in a minute. So I'm really asking for 4 total amendments out of the 6 that I'm offering to be made in order. First, I'll get to a couple of the energy and water amendments that have to do directly with funding. The first would fund the energy efficiency and renewable energy budget at the same amount it was funded last year, which is $986 million more than this bill. Unfortunately, this bill cuts from a very important account that invests in our future. We draw those funds from several accounts where they are redundant, and I don't think the cuts would be damaging. We draw some from the fossil fuel energy account and some fossil fuel energy research account and some from the nuclear weapons account. I think we need to invest in the future, Mr. Chairman. The future is renewable energy, not only for our economy, but for the health of our air, our elderly, our children. It'll impact the safety and sustainability of communities, our oceans. Regardless of how clean we make fossil fuel extraction, it'll never be as clean as renewable energy, and certainly won't be as sustainable as energy efficient improvements. Investing in fossil energy research and development is in many ways moving backwards from what we should be doing as a country. We also should be prioritizing sustainable energy over $10 additional billion in the nuclear weapons account. We already have the nuclear capability to destroy life on the planet 5 to 7 times by estimates. Even with the minor cuts I propose, it would still be at least 4 or 5 times that we could kill every man, woman, and child on the planet. And we don't live in Cold War times. We don't need a Cold War level appropriation, including facilities the military hasn't even used for 20 years. In fact, in 2013, the DoD released a new report on nuclear employment strategy. The report recognizes the shift in strategic environment since the end of the Cold War, recommends changes to nuclear employment strategy to maintain defense capabilities while reducing reliance on nuclear weapons. And as part of that report from June 2013, the DoD recommends an updated strategy for credible nuclear deterrent capability with the lowest possible number of weapons, meaning it's not necessarily as important to destroy the entire world 5 or 6 times. It should be a sufficient deterrent threat to destroy the world 1 time. My amendment doesn't even cut down to funding to the 1-time level. We could still destroy the world 5 times if it were possible. Unfortunately, once we destroy ourselves once, further destruction is impossible. Instead, we should focus on renewable energy. The most recent study of renewable energy's impact shows us $873 million impact just from the National Renewable Energies Lab. There's important facilities in Colorado, including at CU Boulder and NREL, where we operate the Renewable and Sustainable Energy Institute. The mission to expedite solutions that transform energy by advancing renewable energy science, engineering, and analysis. And from 2009 to 2015, there have been 40 newer updated efficiency standards for 45 household and commercial products, saving consumers on electricity bills $543 billion. So in addition to reducing carbon pollution by 2.3 million metric tons by 2030. So I want to point out that this investment actually can save and does save consumers money. It's not just it can, it's documented that it does save consumers money on their electricity bills. There's amazing work being done. Another example is 3D printing for wind blades. Blades are one of the most costly components of turbines, but through additive manufacturing and some of the research and science being on, we can reduce those costs, reduce transportation costs, further reducing the carbon emission profile, and reducing the cost of producing wind energy. Another example is EERE's Vehicle Technologies Office, which was awarded $500,000 through the Clean City Coalition to support Project Fever, fostering electric vehicle readiness in the Rockies, and to foster the development of Colorado state policies to accelerate the adoption of plug-in electric vehicles. And again, out of this budget, $500,000 is such a small amount that can have such a big impact, but that entire account would be devastated unless we can restore some of these cuts like I'm proposing. So these are the kinds of projects we should be focused on, not expanding our nuclear arsenal, nor the many components of the fossil energy R&D account that only serve to look backwards rather than forwards, and should not be as high a priority. That's why I'm asking you to support my amendment to increase EERE funding with the money drawn out of the fossil fuel research account and the nuclear weapon account. I hope that that amendment is made in order, as well as the amendment by Representative Quigley, which also would restore the ERIE account by $921 million, the exact amount it was rated to fund the nuclear weapons account. So those are 2 ways of going about it. I hope that both can be advanced to the floor. My next amendment is amendment number 70. This is a more modest amendment. If you think cutting $352 million of the $10 billion of nuclear weapons account is too much, then I think this one can appeal. My next amendment will increase funding for the Office of Science by $108 million. which is to a level of $5.5 billion, while cutting just 1% of the nuclear weapons account, which comes to $108 million. So by increasing the Office of Science by $108 million, we can be more in line with the Senate's version of the Energy and Water Bill. It'll allow offices like the Basic Energy Science Research and High Energy Physics Research offices to continue level funding from last year, while in the bill before us, those accounts are cut by $69 million in the case of the Basic Energy Science Research account and $31 million in the case of the High Energy Physics account. If we don't fund these two offices at least at the level they received last year, we threaten to lose our place as a world leader in science. Even more important, we would have a negative impact on our economy. These federal laboratories are critical employers and create additional spin-off technology that creates tens and thousands of jobs at an economic benefit to my home state alone of $2.6 billion. I then have three hemp-related amendments to the Energy and Water Bill, Mr. Chairman, and this is what I was referring to. We don't necessarily need all three. I've worked with various colleagues on all of them, but I want to address them and talk about some of the differences. These three amendments ensure very simply that federal water rights are not denied to any individuals that are growing industrial hemp, legal under state law and the most recent Farm Bill. In one amendment, we're also protecting those rights for marijuana farmers. In 2014, the Bureau of Reclamation put in place a policy that prevents individuals who grow hemp from using their federal water rights, and even goes so far as to force the Bureau of Reclamation staff to report the use of the water to the Department of Justice, even though it's legal under the Farm Bill and legal under state law. That's unacceptable. My three amendments attack this issue from different angles. Amendment 71, which is bipartisan and co-sponsored by Representative Comer of Kentucky, prevents funds from being used to implement this policy in regard to hemp farming. Very straightforward solution. Amendment 72 protects water rights for all hemp growers with identical language to that in the Senate Energy and Water Bill, so it simply conform it to that bill. Amendment 95 does go a step further and would protect water rights for both hemp growers and marijuana growers. It's also bipartisan. Mr. Young, who was here earlier, is one of our co-sponsors, along with Ms. Bonamici and Mr. Blumenauer. So again, given that these are two different things, we would seek that either Amendment 71 or 72 be included. We've understood that they've apprised us that there might be germaneness issues. We would ask that because these are largely non-controversial amendments and would conform this bill to the Senate Energy and Water Bill, that we would waive any germaneness issues for either of those amendments, either to conform the language of this to the Senate Energy, Water, and Bill for rights for hemp growers, or the approach that Mr. Comer and I indicated, which is a prevention of use of funds. Amendment 95, as indicated, I know the chairman's position on the underlying issue is certainly a more controversial issue. I believe we have a majority in the House that would likely support this, but it is one that would likely need to be voted on. It's not one that is without any controversy, as I believe the others to be. I would ask that that one also be included and allowed on the floor, because in the West, water rights are the bedrock of our community. And frankly, since Congress made industrial hemp legal in the 2014 Farm Bill, it simply doesn't make any sense that we don't make a corresponding change here. And we can do it, and we can solve it through the appropriations process. We all know the difficulty of the more cumbersome way of fixing it through the authorization and legislative process. But given that there's not a lot of controversy around this, we find it appropriate in a bipartisan way to bring that forward. The final amendment I have is for the Defense Appropriations Bill, Mr. Chairman, and it's simply a 1% cut. In a time where we need to do more with less, it's time that we save money where we can and reduce the deficit. I'm honored to bring forth this amendment with Ms. Barbara Lee, who's with us as well. My amendment would only go a small way towards protecting the fiscal security of our nation, which is every bit as important, if not more, to national security than our military security. My amendment would give broad authority to reduce the overall amount of money appropriated by 1% in the aggregate, excluding personnel accounts and health accounts, of course, from being included. I should remind everyone, a 1% reduction in the defense appropriations still leaves us above the defense cap expenditure level from the Budget Control Act. If I had my way, frankly, I would have kept the numbers from the Budget Control Act. But if we're going to go above them, let's at least make a cut where we can, even if with my amendment the bill would still appropriate well over $650 billion for defense. I see this 1% spending cut as a compromise that the military can very much live and function under, but still exceeds the original expenditure levels of the Budget Control Act. I know members of this body have many ideas about how to trim our defense budget. That's why we've seen so many amendments between the NDAA and this bill. I believe it should be a two-part question when we decide to keep items in the budget. First, is it needed for national security? And second, if it's necessary, is it more necessary than the need to address our massive federal debt? When we engage in defense spending beyond our means, we make our country less secure, not more secure, by mortgaging ourselves economically to the very foreign powers that represent geopolitical threats, including Saudi Arabia and China. This needs to stop. Expenditure levels beyond what we can afford make us less secure, not more secure. We simply can't be allowed to convince ourselves that sustaining this level of spending in any way, shape, or form makes our country more secure, when in fact the mountain of debt makes us less secure from a fiscal perspective and from a geopolitical perspective. My amendment is but a small first step towards taking a stand against our ever-expanding military budget. We truly don't have to choose between protecting the homeland and fiscal constraint. We can make strategic cuts, protect our national security, and finally start to make progress on reducing the deficit. I'm happy to yield for questions.
Mr. Polis, thank you very much for your thoughtful amendments. Is there any member of the committee that would have questions for Mr. Polis? Gentleman from the state of Washington is right.
Mr. Chairman, just real quickly, Mr. Polis, are there examples that you're responding to where in states where hemp has been allowed and it's recognized by the federal government that farmers are being denied access to water that comes from federal projects?
Yeah, so this has been in the news in Pueblo, Colorado, and my colleague Mr. Tipton's district, where a lot of the water rights are tied up with the federal side, and they've actually had significant, I guess, overhang on development because of the uncertainty that exists now with regard to accessing water from the Bureau of Reclamation. So it's real, and it's real, as you know. Perception is reality, and in the sense that there is nothing prohibiting it, and that letters have gone out and commissioners are acting cautious as a result, there is industrial hemp activities that are not occurring because of the uncertainty about water in Pueblo County, Colorado.
Okay, I didn't realize that because we just recently legalized it in the state of Washington too, and I have not heard of similar circumstances, but maybe I just am not aware.
You know, I would also say you have a wetter state, so I mean,
was going to say there's more water where you are. There's
yeah.
less water where they are, and so the resources are being moved to food.
I see. All right. Thank you very much, Mr. Chairman. No further questions.
Yes, sir. Further questions from the committee? Mr. Polis, thank you very much. We appreciate it. Mr. Griffith, you seem to have a band of brothers that have joined you, and I would encourage if Mr. Perry, if Mr. Meadows, if there's anyone else that you brought to help get you through your amendment, I encourage them to please come to the table at this time unless they're simply here for other amendments. I am not going to recognize you for other amendments at this time. Mr. Perry, do you choose to be with Mr. Griffiths? Ms. Griffiths, you're recognized.
Thank you very much, Mr. Chairman. Appreciate you recognizing that there's some other folks here who are also co-sponsors of the amendment. It's number 19 in Division B, Ledge Branch, and the other co-patrons or sponsors of it are Mr. Jordan, who's here, Mr. Meadows, who's here, and Mr. Perry, who's here.
Yes, sir.
So we appreciate it very much. The amendment abolishes the Budget Analysis Division within the Congressional Budget Office and transfers the duties of that division to the Office of the Director of CBO, allowing for more flexibility to find more accurate scoring processes. The CBO has repeatedly underestimated revenues generated by the sale of wireless spectrum. When Congress authorized the Federal Communications Commission to auction spectrum in 2012, the CBO predicted that the total profit to the government over 10 years would be $15 billion. One particular auction in 2015 was predicted by CBO to generate no revenue. Instead, the sale netted the government $40 billion. As then FCC Commissioner Jessica, and I hope I'm pronouncing her name close to right, Rosenworcel, an Obama appointee, observed after that auction, our airwaves are extremely valuable, but our accounting systems for measuring them in the legislative process don't appear to be fully up to date. The CBO has also misjudged farm bills. The 2002 bill they underestimated by a cost of $137 billion. The 2008 farm bill The CBO underestimated that cost by $309 billion. It appears they may be off on the latest farm bill as well. In regard to their overestimate, which we all are aware of, on the enrollment in the Obamacare insurance exchanges, in 2014, they predicted that 8 million people would be covered. Only 6.3 people had a paid-for plan. 2015, they predicted 13 million, and the actual number was 8.8 million. And 2016, they predicted 21 million, and the actual was 9.1 million. So if you keep getting bad results, you ought to change what you're doing and try to come up with something better. What my amendment does, using the Holman rule, is allows us to do just that. Mr. Perry has a companion amendment that goes a little bit further, and I only mention it as a reference as one. His amendment would be one suggestion of how you do it, and that would be to allow the CBO to use aggregators. That's why we move this responsibility to the director of the Congressional Budget Office, because then they can use aggregators, much like what a field we're familiar with, Real Clear Politics, aggregates polls. I'm not sure exactly how that would work within the confines of what we're doing today, but two, I also felt that there are going to be different subject matters where you might want to use different various sources, where you would want to aggregate from different sources, and so maybe not use the same sources for every single issue that comes before the CBO. I think this is extremely important. Now, I will mention, I'd be remiss if I didn't, that there has been some concerns raised in relationship to the Budget Committee Act and the 306B authorities. It's kind of interesting, so I did some work on that, as you might imagine, Mr. Chairman. And what you find there is that not only has CBO not been reauthorized in the past, but at the beginning of House Res 5, which establishes our rules, as you're well aware, the opening paragraph reads that the rules of the House of Representatives of the 114th Congress, including applicable provisions of law. Now, that's the language that bootstraps in the ability of a previous Congress to instruct us on how we're to operate. So let me go back and read that. That the rules of the House of Representatives of the 114th Congress, including applicable provisions of law or concurrent resolution that constituted rules of the House at the end of the 114th Congress, are adopted as the rules of the House of Representatives of the 115th Congress, with amendments to the standing rules as provided in Section 2, and, all part of the same sentence, and with other orders as provided in Sections 3, 4, and 5. Section 3 is, in fact, the Holman Rule, which would allow us to get at this expenditure. I believe it's in order. I don't know what the floor will do, but I think it's a question that should be sent to the floor, and under the rules of the House as established in H-Res 5 is in order, and I would request that this committee find so.
Thank you very much. Mr. Perry, do you wish to speak on this amendment?
I do, Mr. Chairman.
Gentleman's recognized.
First of all, Mr. Chairman, I appreciate the opportunity to be here. Thank you very much.
Well, let me say this, Mr. Perry. We want to thank you as a member of the United States Army. You provided our country not only with the necessary leadership, but we are very proud of you for your service. We want to thank you, and to have a distinguished member for this committee is important, and gentleman's recognized.
Again, I'm appreciative, and I'm also appreciative and honored to be here with Mr. Griffith. I think there's no person that you will find that's more knowledgeable of the rules, and particularly the Holman Rule in this regard, and other than the chairman himself, of course, and of the fact that this amendment, because of that, is in order. And I just want to buttress the point Mr. Griffith made regarding the inadequacy and the mistakes that the CBO has made, and our attempt to provide some flexibility to the CBO so that they can do a better job. When we think about the ACA and the fact that it was off from the 2010 projections for 2016 enrollment, 50.4%, half, literally half, something as large and as important as health care in this country. And when we look at just recently the Forbes article that came out about 3 weeks ago regarding the American Health Care Act, where the CBO projected that we would lose 24 million Americans would lose coverage, because what the CBO did was they used what their projection was and then compared the AHCA to their projection as opposed to reality, the reality of what was occurring, when in fact, if you look at the Forbes article, the AHCA actually adds 1 million people to coverage. This is critically important. Not only are they often late, so we have to vote in advance of having the information, but obviously on too many occasions, way too many occasions, they are horrifically off target. We're trying to make important and responsible decisions on behalf of the American people in the Public Policy Forum. This is a tool to be used by us. It was set up for us, by us, for us, and unfortunately, over time, the methodology isn't keeping pace with the intricacies and the requirements that are necessary for us to make these important decisions. This amendment allows the flexibility of the CBO to do that, to make those changes so that we can receive up-to-date information that's timely and that is accurate so that we can make informed votes on behalf of the American people. And with that, Mr. Chairman, again, I thank you for the opportunity. I yield.
Mr. Perry, thank you very much. You also mentioned several other members. If those members would wish to join you, they would be allowed to do that. Seeing none, I would ask both of you, have you spoken to at all the chairman of the Budget Committee on this issue?
My team reached out when we realized that there might be a problem, and as we were advised as we were going through this process, and we sent them information on Saturday. They have raised concerns, but as of the last time I communicated with my office, which was just maybe an hour ago, they indicated that, let me make sure I'm not misstating anything, that they have not officially raised any objection under the Budget Control Act, but raised concerns. That's why I used that raised concerns language.
Yes, sir.
In the original, which is why I pointed out that if you look at the first paragraph of HRS 5, it actually says Section 3 amends those sections that are bootstrapped in from the past. And so I think that the clear reading of HRS 5 is that Holman does apply both to all the other areas, but also to those areas. I would point out that if you look at 306B of the Budget Control Act, where it talks about how we're supposed to do things, it actually says that anything that touches on budget is supposed to come out of the Budget Committee. And so I would have to say unless they've waived all jurisdiction, and it's not, I think this is the stronger argument, but unless they waived all jurisdiction, in theory, there would be an objection.
There could be a point of order against it.
Could be a point of order against anything. And I would hope that if there was going to be a waiver for anything under that, that this would also be considered as a part of that. Although I am firmly convinced, Mr. Chairman, that the opening paragraph of HRS 5 with Section 3 being the Holman rule is an amendment to that bootstrapping. And so I think it's included with Holman as well. And I recognize that this is a bold step and may or may not be successful on the floor. I would hope it would be successful. May run into other obstacles if it should reach the other side. But I also think it's important that we start this debate, and the way to do that is on the floor of the House.
Well, notwithstanding your quick analysis, which I know you have spent hours developing your not only thesis, but also some things that might be apparent to members, as Mr. Perry talked about, with some what he viewed as inconsistencies in the relationship that we share with waiting for people to provide scores. I would encourage you, I don't know that I have an answer tonight to give you advice, but on what the committee is going to do or what I would recommend the committee. But what I would say is it would certainly help. I actually sought the Chairwoman Black before we came back up and asked her if she was aware of the substance and the meaning behind what you were attempting to do, and she indicated she was not aware of that. The only thing I'd say to you is I'd probably go do that. Not knowing right now whether there's a point of order that could be placed against it, but just simply because I think your interest, Mr. Griffith, has always been of benefit to me when you got engaged in my business, because you studied it and you very appropriately said to me, "This is my angle. What do you think?" I think you ought to give her a chance.
I don't disagree with that, and I'm just. It was a little bit of a busy schedule today getting back, and we did notify him as soon as we realized there might be an issue there. And I'm I would apologize to her if she was sitting here that she doesn't already know about it, but we're moving fast.
I don't even
And I think that's appropriate, Mr. Chairman.
Well, I
Y'all
don't
doing
even think
great.
that, I'm certainly not asking for that. I think that members of this body, the entire body, know that you're allowed to do your own homework. I'm simply saying, if there is a point of order against it, she may be able to work with you. And I think that would be of overwhelming positive things, so.
I appreciate that, Mr. Chairman. Thank you so much.
Any other member of the committee that has questions? Gentleman from Louisville, Texas, Dr. Burgess.
Yeah, Mr. Chairman, I would just say, I mean, Mr. Griffith on committee with me on the Energy and Commerce Committee, and he does do his homework. He is very thoughtful, and I think he has brought a very powerful idea to the Rules Committee, and I think it deserves our every consideration, and I hope we can see a way to allowing the gentleman's amendment to be heard.
Well, and I concur with that, but pending, I did want to ask Chairwoman Black, we have our own expert on the Budget Committee also. As you know, the gentleman, Mr. Woodall, has not been consulted, as I asked the Chairwoman, but we will thoughtfully consider this, and I know that Mr. Woodall probably has an opinion on this, but we'll figure that out at some point.
Yes, sir. And I suspect many members may be opposed to the underlying concept. I just want to have a chance to talk about it on the floor.
Well, I think,
Thank you,
gentlemen, that's a noble idea. I want to thank both of you and your entourage, including the gentleman, Mr. Meadows, who came up with you, and I want to thank you for taking time to be able to. Oh, did you have?
I just have something for unanimous consent
Yes.
in a moment. Okay, I have an article for the record from U.S. News and World Report in answer to my colleague from Washington statement. It's about a farmer from Montana who was denied water from the Helena Valley Irrigation District from the Bureau of Reclamation. So I just want to answer that in the record. We'll get a copy over to you as well from Montana. Yield back.
Thank you very much. Mr. Gomez, we're delighted that you're here at the Rules Committee. The gentleman's recognized.
Thank you, Mr. Chair and members. Thank you for the opportunity to offer an amendment to H.R. 3219, the Department of Defense Appropriations Act for fiscal year 2018. I offer a simple amendment that would seek to protect the voting rights of all Americans, whether voting here at home or while voting abroad. My amendment would prohibit the use of any funds from being used to comply with a request for information from the Presidential Advisory Commission on Election Integrity established under Executive Order 13799. I believe that this commission is a sham that does nothing to protect our democracy and further undermines the public's trust and faith in our elections. Dozens of states have already identified this commission as a farce and have made the common sense decision to refuse to send data that would compromise the privacy of its citizens. The Pentagon should also have the ability to protect our brave service members and diplomats who vote from abroad as part of the Uniformed and Overseas Absentee Voting Act from this egregious violation of civil liberties. The myth of voter fraud is simply nothing more than a fairy tale conjured up by a fragile ego who cannot accept the results of our democratic institutions. This commission will do nothing more than divert attention away from the fact that the bedrock of our democracy was attacked by a foreign power. Instead of investigating the real threat of foreign obstruction in our elections, this administration has chosen to attack Americans exercising their constitutional right to vote. We should be protecting our institutions, not attacking them. I urge my amendment be made in order so we can protect the voting rights of all Americans. Thank you, and I yield back.
Sir. Gentleman seek time. Gentleman's recognized.
I do. Have you heard from constituents that many of them feel intimidated or targeted by this presidential commission? I mean, what have you been hearing about kind of from constituents' concerns about the approach that under the executive order?
I believe that the fear that my constituents is just a fear from the overall administration in general when it comes to attacking just underlying fundamental rights, everything for the right to vote, to the right to make sure that they feel safe in their own homes. They believe that they're law-abiding citizens that are voting. I wish more of my constituents would actually vote. So that's why we don't believe that there is a real problem when it comes to voting fraud in this country.
I hope that your amendment is made in order. We had in Colorado over 3,000 people deregister, unregister because of fears about their personal information being turned over to President Trump and the Commission. So I think regardless of whatever the Commission was designed to do or actually does, it has had a chilling impact on the franchise. In my home state alone, over 3,000 people have already unregistered. And so I hope that your amendment is made in order, and I urge its passage, and I yield back.
Further questions from the committee? Was there a hearing this last week by this commission? Because one night on C-SPAN turned it on, maybe on Saturday night.
Mr. Chairman, I'm not aware of that.
They appeared to be talking about, among other things, $2.5 billion that was provided for states some 10 years ago after the 2000 election or 2004 election. And most of those states that bought machines, if that was from this same commission, they said that almost every bit of the $2.5 billion went for machines that are now gone because they did not actually function well, and states like Maryland have gone back to paper ballots. Secondly, they talked about how it is not unusual, and they went through several states. Federal district courts are reporting that there are some number of people who do not show up in federal court and or state court to serve as jurors because they have written back and said, I'm not a citizen. Please don't contact me. And the federal court and the state courts operate only off voter registration files. And so they were talking about a large number of people that chose to answer that way, and there was an investigation going on. So I don't know whether it's whether the whole commission is an error or not, but that's what I heard. So I wanted you to know, just as a balance, I think that data and information on an aggregate was important from what I heard. Any other member? Seeing none, thank you very much. Appreciate gentlemen being here. If you'll please make sure whatever you brought in writing for our awesome stenographer, it's available.
Mr. Chairman,
yes,
may I add one last thing?
yes, sir. Yes, sir. Of course.
I think we have to look at the intent of why the commission was set up. Right? It was set up because our current president believed that he lost the popular vote by 3 million votes because of folks that were voting that they weren't supposed to be voting. And that is just the underlying reasoning. And I think that we should challenge that underlying reasoning for the commission. If you wanted to set up a commission on how to make voting more secure so that more people will actually vote, and how you can prevent foreign entities from actually attacking our system so that they don't undermine our people's faith, I'm completely in support of that. But I think this commission was set up to build support for his case of why he lost the popular vote, not for actually how do you make our system work better. So I think you have to look at the intent, and that's what my approach is.
Well, I think the gentleman's entitled to his opinion, and I think whoever, if there's president, has his opinion. I will tell you, in Dallas, Texas, we're going through a rather intricate process right now where we're finding out voting fraud occurs in primaries more than it does in general elections. Yeah. And when primary fraud is involved, I think a lot of questions should be asked, notwithstanding that general elections are important too. But I think people are weaponizing against each other in ways that is still fraud.
Thank you, Mr. Chairman.
Yes, sir. Thank you very much. I want to thank the gentleman for being here. If you remember your iPhone too, if that is yours, that's there.
I'm going to
Otherwise,
take it with me. Thank you so much.
Yes, sir. All right, we're going to continue moving, and the gentleman, Mr. Hubbard, has provided me with a new list. Tom, how do we pronounce your name? That's what I was going to say. No, I really was. I see Tom every morning. It's just I didn't want to get it wrong here.
Clothes on, sir.
Yes. Strike.
Move to strike that from the record.
It's amazing how we get even with each other around here. Tom, I look forward to seeing you tomorrow. The gentlewoman, the young chairman of the Ethics Committee, Mrs. Brooks. Mrs. Titus, the gentleman, Mr. Mass, who has served our country so ably and who we recognize not only as a colleague but as a veteran and a man who we admire very much. The gentlewoman, Mrs. Lee, and the gentleman, Mr. Panetta, from California. Jimmy, you're going to have to just, Miss Booth the clerk will give you something right in there next to Miss Titus. There you go. Okay, why don't we just get right to it here? The gentlewoman from California, Ms. Lee, is recognized.
Well, thank you very much, Mr. Chairman and members. And I appreciate the opportunity to testify on my amendments to the fiscal 2018 Department of Defense Appropriations Act. Now, as a member of the Appropriations Committee, I have offered 2 amendments this year for which I respectfully urge you to make an order. These bipartisan amendments are very straightforward. As you know, I've come before this committee many times on this critical issue of war and peace. My first amendment is Leo 74, and it would, after 240 days of enactment of the act, repeal the 2001 authorization to use military force, which Congress passed into law September 14, 2001. Now, this would give 8 months for Congress to debate and vote on a new authorization, should that be what the American people and what members of Congress decide to do. This is the same amendment that was passed out of the Appropriations Committee on June 29th on a bipartisan basis, but it was unilaterally, and Mr. Chairman, we've talked about this, it was undemocratically stripped in the committee print last week. I don't know how that happened. My second amendment, Lee 071, would, after 240 days of enactment of the act, prohibit funding for the 2001 AUMF. The 2001 authorization took 3 days, mind you, 3 days for a congressional vote. My amendment provides 8 months. And I want to just lay out the length of time that it has taken for Congress to authorize the majority of prior conflicts. In terms of Germany declaring unrestricted submarine warfare in World War II, 33 days the president requested. It took 4 days for Congress to pass it. Pearl Harbor, same day that the president brought it forward. Germany declares war, it took 5 days. The Gulf of Tonkin it was the same day actually when the president presented it. The invasion of Kuwait, it took 4 days. The 2001 AUMF that we're talking about today, it took 3 days. 3 days. The Syria chemical attack weapons, it took 10 days. And of course, the ISIS campaign, President, 240 days we're into it, there has been no request for an authorization. So 8 months, Mr. Chairman, is plenty of time for Congress to do its job. Now, this last amendment that I'm talking about is not subject to a point of order since it's a mere prohibition of funds targeting the 2001 AUMF. I've offered both of these amendments along with Walter Jones, Justin Amash, Mark Sanford, Adam Schiff, Jim McGovern, Keith Ellison, and Peter Welch. We're working in a bipartisan way to accomplish this goal. And as many of you know, I voted against the 2001 AUMF, which I believe was a blank check to wage war anytime, any place, for any length. Our brave servicemen and women, they continue to be deployed around the world. Congress is missing in action when it comes to our constitutional duty. And so on September 14, 2001, yes, I cast the lone vote against this authorization because I believed it opened the door for any president to wage endless war without a congressional debate or a vote. Now, according, and I've cited this before, but I'd like, Mr. Chairman, to put this into the record today, the 2016 Congressional Research Service, which I encourage all of my colleagues to read, it found that the 2001 AUMF has, in fact, become a blank check for war. And I have that report again, and I would like to insert it into the record.
Without objection, we'll enter that into the record. I would also ask the gentleman if she would allow to be entered the record the release from President Barack Obama, February 11, 2015, about his letter to Congress concerning his ideas about AUMF.
Thank you, Mr. Chairman.
We'll enter both those
I think
into the
that's very
record.
important.
Yes, ma'am.
This resolution, the 2001 authorization, 16 years, it's been used at least 37 times in 14 countries with little or no congressional oversight. Now, this report only looks at unclassified incidents, and this was, again, a couple of years ago. How many other times has it been used without the knowledge of Congress or the American people? And how many times since this report was issued has it been used? Not only has this authorization been used to justify military action thousands of miles away, it's also been used much closer to home to allow warrantless surveillance and wiretapping, indefinite detention practices at Gitmo, targeted killing of drones, including of American citizens, and the open-ended expansion of military operations abroad. Right now, we know that any president can unilaterally wage war under this outdated 2001 authorization. The last two presidents have bombed the Middle East and Africa. According to a U.S. News and World Report, it's been used from the Philippine archipelago to Yemen and Somalia. And President Trump is following down a similar path. The administration has launched airstrikes against Syria, sent more troops to fight ISIS, and is contemplating sending thousands of additional troops to Afghanistan. I know that while we may not share, Mr. Chairman, a common position on the replacement of a 2001 AUMF, many of us do agree that the overly broad authority is a major and concerning deterioration of congressional oversight and war-making authority. Clearly, with the passage of my amendment in the full Appropriations Committee markup, there is bipartisan support. And I know many of us have also agreed on both sides of the aisle that a robust debate and vote is necessary. It's long overdue and it must take place. The fact of the matter is, with the 2001 AUMF still on the book in its current form, any administration can continue to rely on this blank check to wage endless war. That's why both of these amendments are so important. Congress cannot continue to abdicate its constitutional responsibility while the United States is embroiled in yet another open-ended war in the Middle East. I'm here before you to ask you to look at both of these amendments. Both are very important. I would like my bipartisan amendment, which was stripped undemocratically from the committee print, made in order under this rule. And I strongly urge this committee to rectify wrong and allow a debate and vote on this important issue. I understand that Speaker Ryan has said that it was a mistake to include my amendment and that it would endanger our national security, and I'd like to just briefly address that. Both of my amendments would allow Congress and the executive branch plenty of time to debate and vote on any new authorization. As I mentioned earlier, in matters of national security, Congress acts swiftly. 8 months is a long time. We passed the AUMF, the 2001, within 3 days. Surely Congress can muster the courage to debate and vote on a replacement within 8 months. I'm also aware that many members have expressed concern that the bill language amendment did not come through the authorizing committee. Now, if my memory serves me correctly, the 2001 authorization did not even have a committee hearing and went straight to the floor. However, given that there were over 100 policy riders this time attached to the fiscal year 2017 Consolidated Appropriations Act, this should not have been a legitimate barrier to protecting my amendment in the bill. And that's why I'm here today with an alternative amendment that would not be subject to the point of order, as it is a straight funding limitation under this Appropriations Act. More importantly, this amendment was made in order last year under this bill. I've heard from many colleagues on both sides of the aisle that they want to repeal and replace immediately. I'm supportive of that effort, but the bottom line is that we have to have this debate and the vote. Some have said that this is political, and I say just the opposite, Mr. Chairman and members. Our brave troops deserve us to come together and do this so that they know that their country has their back. My amendments today will help jumpstart that effort and force Congress to finally do its job. So I thank you for the opportunity to testify, and once again, I respectfully request this committee to make these important amendments in order under the rule for this appropriations bill. Thank you very much.
Thank you very much. Those of you who have just come to the committee tonight, we're attempting to knock these out one at a time and then allow that member to exit and leave rather than sticking around for 4 or 5 hours. And so we're going to do that. Ms. Lee, let me say this to you. I have rarely am I approached by someone as not only as sincere, but as genuine as you are. The gentleman, Walter Jones, a very dear friend of mine, approached me several months ago with an indication that he had filed a bill of which the Rules Committee was part of that jurisdiction chaired by the gentleman from California, Mr. Royce. Mr. Royce and I met very seriously to understand this. We believed at the time that it was important to engage from the purpose of an analysis about money and time and ideas that we were going to approach the gentleman, the Secretary of State, about his ideas, about the Secretary of Defense about his ideas, and to allow the White House, NSA, to do the same. I believe that we are going to approach this. I believe we will pass, and nobody will ever be happy that simply wants us to stop all combat operations. But I will say this, I am unilaterally for it no matter what, that if a President of the United States finds that maybe in Tora Bora, that there's somebody over in a far part of Afghanistan who's preparing to dump 3 or 4 or 5 airplanes on this country, and that the mission is being planned out of somewhere by people who want to destroy this country and kill thousands of people. If we do not give that president that authority, if we wind this so darn tight that the president has his hands wrapped around something that he can't get at that, we are making a mistake. I believe the United States military, from all indications that I have, is full of people who are very thoughtful and very careful, but they are given one job. And I've met with Admiral Harris out in Pearl Harbor, and every single time he says their sole job is to protect the homeland of this country. I raised my hand to promise that I would support and defend the Constitution, and that would include where you're coming from, and that is to make sure that the philosophy behind the use of dollars and the policy that would be done. But I guarantee you, we're going to get at it, and we're going to approve something that says that the President of the United States needs to consult with us, but that we need to make sure we defend this country, because I guarantee you there are lots of deep, dark places that we have never even heard of, and there are evil people who are against us. So the gentlewoman's going to get her argument, and she's going to get her vote, and I'm going to make sure that happens, because I want to make sure that we allow our United States military anytime, any place in this world to drop a package within about 10 feet of somebody that wants to bomb our country, harm my wife, my children, and people in this country. And I will guarantee I'll pay for that myself to deliver that package. And,
Mr. Chairman, can I just respond by saying this is not about the substance of
Right.
any authorization, and you're talking about what possibly
well,
the
if you
substance
wrap
would
us
be.
too tight around the axle and require
8
certain
months.
things.
No, I'm just requiring
we're
8
gonna,
months.
I already told you, we're going to have that debate for 8 months. And we're going to get into it, and you're even going to get your vote. But what I'm suggesting to you is it ought to say anytime, any place, anywhere, but that on an appropriation cycle, you'll get a chance to either fund, vote yes or no for the military. You know what the military is doing, and so do I, and so does every member. You know what they're out there and doing. So to think and say that the people who are out there deserve this debate, they give their lives defending something so that our children, our wives are safe. And so we're going to do that. We're going to take you up on it. I want to take you up on it because I quite honestly want to make sure everybody in this body gets a chance to vote especially for the next election, just where we know who's for it and who's against it, because I guarantee you it's going to be important. Mr. Cole?
Thank you very much. I want to thank my friend for being here, not that I ever doubted she would be here. And I want to thank her for what she's done. We would not be having this discussion were it not for my friend's persistence in here and, frankly, for her far-seeing analysis of the 2001 AUMF. You were exactly right. What you saw at the time and nobody else in the chamber saw has indeed transpired. We have given war-making authority so broadly that very different presidents with very different points of view have been able to go to war pretty much whenever and wherever they wanted to. And many of those actions, quite frankly, I support, but they didn't come here and ask. You can be very critical of George Bush 41 or George Bush 43. The history will debate whether they were right or wrong in the Gulf War and the actions against Afghanistan and Iraq in 2001 and 2002, but they at least came and asked. And there are votes. And that has not really happened since that time. So I think this is a tremendous contribution to the debate. As you know, I've got amendments as well, and those would not have happened were it not for your amendment. Frankly, that's the leadership reaching out, beginning to finally realize, wait a minute, there's something wrong here when there's this much bipartisan support. Now, I actually think, Mr. Chairman, I want to not disagree, but I think we're far more danger of the executive having too much war-making authority than too little. Because they certainly haven't lacked for war-making authority in the last 16 years. I don't know any place that they've wanted to go that they haven't. And they've gone some places that I think had they come to Congress with a straight-up vote, let's just take Libya, for instance, I don't think they would have gotten the authority. That was a terrible decision. It was a terrible decision. And I say that in no defense of Muammar Gaddafi, but we went in under a NATO pretext against a country that had not attacked anybody in NATO, that had turned over every one of its WMDs to us. They're all sitting in Oak Ridge, Tennessee, that did not have any terrorist organizations operating within it and striking from it as a home base. And again, that doesn't mean Gaddafi wasn't a butcher. He was. But what was the justification for that? And I promise you, this use of this kind of force, this irresponsibly without debate, is one of the things that encourages the Iranians and the North Koreans to keep or develop nuclear and WMD capability. Because they look at this and say, this is what the United States does to somebody that cooperated with them on everything. They give up their nukes, they give up their WMDs, boom, we're going to take them out. So I think you're making a tremendous contribution. It's why I supported you in Appropriations Committee. And it's why you had the near unanimous support of that committee. I think one of the most striking things was when we had combat veterans getting up after your presentation saying, this is right, we should do this. We know these people, or we've been amongst these people deployed. They do need to know this is a mission the United States wants them to do. I asked, really partly as a result of your amendment, I asked Secretary Mattis, and I know you had an exchange with him. I didn't get to hear it all, but I certainly heard about it right afterwards. And I know he may have disagreed about removing an AUMF before we had one in its place, but he certainly acknowledged to me, and as I understand it did you, yeah, a new AUMF would be a good thing. And the reality is we wouldn't be having this debate today and the possibility of this discussion if you hadn't been doing what you're doing. So I look forward. I so admire and respect what you've done here, because I'm not going to say everything I said earlier. I do think our leadership on both sides of the aisle at different points has tried to protect members from tough decisions. I actually acknowledge that, and to some degree, we create leaders to do that. We create the Rules Committee to do that to some degree. We cast a lot of tough votes up here to keep people from casting tough votes downstairs. So that's just part of the process. But this is a preeminent constitutional responsibility. We are sending men and women to war. They ought to know whether we agree with it or not. If we don't, we shouldn't be doing it, quite frankly. And this country at times has avoided conflict when it shouldn't have. We're not always right in these decisions. I don't think we made real smart decisions in 1940 and 41 when the whole world was at risk. But be that as it may, at least people we're willing to take responsibility for the decisions. I think that's all you're asking us to do. And, while I would prefer a full replacement before repeal, I agree with your point. You gave us 240 days. I mean, the way some of this has been characterized, it's as if you were pulling the rug out from people. I'd say 8 months is plenty of time to do this if you're serious about doing it and you can reach consensus on it. And if you can't, probably shouldn't be doing it. We shouldn't be at war unless the American people believe decisively that's what we ought to be doing or willing to support it. So I just want to commend my friend. And I think, frankly, the funding issue, without question, is germane here, without question or debate. That's very appropriate on an appropriations bill. We do it all the time for a variety of things. So anyway, I look forward to this, and I think you started a process, I would hope, whereby the committees of relevant jurisdiction, which have not picked this up, do that. Which the administration, and I'm pretty, I want to be fair to the administration. They're not doing anything the last administration didn't do. The last administration said it had the authority to do anything it wanted to do, pretty much any time it wanted to do it. You know what? I've been around long enough to know that all administrations say whatever they do is based in law and they have the full authority to do it. Doesn't matter if they're Democrats or Republicans, they just do it. That's why we've divided power and tried to restrain them. It's a dangerous thing to give that kind of power. And so I would hope that the committees of jurisdiction pick this up. We're going to have a report from the administration at the minimum that lays out its legal justifications, its targets, its strategy, its estimated cost. Then we shouldn't just accept that. We should have a debate. We should let that thing move through committee. And again, insofar as we've made any progress at all in this in the last few minutes, it's solely due to your efforts. I want to commend my friend. We are very unlikely and unusual allies. If that Afghan funding thing came up, I'd probably vote not to cut it off, and you probably would vote to cut it off. Not that I would pretend to predict your vote, but the point is, you would have taken responsibility for your decision. I would have taken responsibility for my decision, and the Congress collectively would have taken responsibility for its decision. And it seems to me that's the point of what you've been trying to accomplish, is simply make us take responsibility, the same responsibility that Congress gives us. You've been willing to do that, and you've been willing to do it at great political peril. I doubt that was a real popular vote in 2001. But in retrospect, it certainly was a wise vote, and you were correct. So anyway, I look forward to continue to work on this. I think we've made some progress, but I think this is pretty much solely due to you. And the rest of us are trying to rally behind and work with you on this and see that we get the process going. And I hope the administration embraces this. I really appreciate Secretary Mattis in public saying this is something we need to do, not just saying, well, we have the legal authority. They think they do, but this is something we need to revisit. And I would hope if we do, I get asked all the time, do you have a particular AUMF? I really don't. I just want to see it go through the process. And if we did it again, my one big recommendation, and I wasn't here the last time, is I don't think anybody that voted for that thing envisioned we'd still be acting on it this far down the road. We ought to have some sort of periodic 3 to 5 year, some built-in review, so we don't ever go this long again without re-examining something that gives this kind of extraordinary power to any chief executive. And again, I'm not knocking President Obama. I'm not knocking President Trump. I just know presidents, and presidents always think they can do anything they want to do, and they can always find plenty of lawyers to tell them that they're operating within the law. The only thing that pushes them back is whether or not we have the courage to defend our institutional powers in a bipartisan sense and to make sure we don't allow this much authority to evolve in the hands of any single individual ever again. It's dangerous, extraordinarily dangerous. So with that, I mean, this committee's heard from me way too much on this, but this is something, I will say this, when the speaker called me about it, and as I know my friend knows, you very seldom get calls from speakers say, you've just been doing a great job, and I was thinking about you. I just wanted to call you and tell you I'm real happy with what you did. But he came back at me with here's another way, and here's why I'm concerned about it. So I appreciate that. But that call would never have been made if that amendment hadn't been offered in Appropriations Committee and if there hadn't been enough bipartisan concern that it moved through that committee. And I'm glad you pointed out that, people seem to forget this. They were all like shocked. I voted for this thing 2 years ago. We had 8 Republicans that voted for it and made it in order then. I think on the 16 bill, if I recall correctly. This isn't new, and that's one of my frustrations. It's not like we haven't been knocking on this door for a long time. And the first, well, we don't know if we trust President Obama. Well, at least he sent up an AUMF. It wasn't my favorite one, and I would have preferred it be changed, but I would have voted for it if that's all that got to the floor, because I think it was the right thing to do. And he recognized, if you go back and read his statement, that there needed to be some changes. And I mean, grudgingly, they'll all admit that, yeah, this needs to be looked at. They've just never found it convenient to come back and do it again. They'll always have a reason why it's not. The gentle lady, my friend, has not accepted that. She's been wise not to do it. And because of that, we have an opportunity now to not only give this the authority I think it needs and let people express their opinion, but put us on firmer footing, and I would hope send a clear signal to the men and women we're asking to fight that they shouldn't have any doubt that the Congress of the United States supports the mission that we've asked them to undertake and risk everything on. So, thank you. I'll try and I won't do this again, but I apologize. But yeah, I know. Well, that's why I won't do it a third time. But feel strongly about it. Yield back.
Thank you very much, gentlemen. Mr. Polis.
Yeah, the last time our nation and Congress declared war was June 5th, 1942. All of the subsequent military actions have been various degrees of these authorizations for military action. I like Mr. Cole's recommendation the future AUMFs have a sunset provision in it. I think that's very important. But I would also point out the importance of Ms. Lee's amendment, and I think our chair indicated that Ms. Lee would get our vote. Did her vote? Did I hear that correctly when you said that? No, Mr. Chair?
I think what the intent was is that we're going to end up getting the vote quicker than 8 months.
Okay. Well, that's great. It's more than just a vote. It's actually passing one, as you know. And I think that the argument about what's in it is very important. I mean, there's a lot of problems with this current one. It doesn't even name or contemplate ISIS. The link is very, tenuous to ISIS. Look, I've been in Congress 9 years. Congress, do they do their job when the clock is running out? That's when we do our job. I mean, we could do spending bills anytime. I would bet anybody here that we're going to be back right before, a day or two before the money runs out for spending the money. That's just the way it works. I don't know why, but I don't think we're going to do an AUMF unless we have a time certain. So I think this, this one that comports with our germaneness rules, prohibits funding for 2001 AUMF after 240 days of enactment of this act. That's fine. It could be any period of time. Let's be honest. If we get to day 239. This Congress would pass a continuation. It's okay, 2 more weeks. Okay, 3 more weeks. That's just, I mean, this Congress is responsible, Mr. Chairman. I mean, Democrats and Republicans are responsible. They're not going to let an AUMF lapse in a dangerous world. But what it will do is the same pressure we have on spending. It'll force the debate. I just don't see it happening absent a timeline and a clock that ticks. Unfortunately, that's for all of our big decisions, and this is a big decision. This is, war and peace. This is the use of our military. This is keeping America safe. For all of our big decisions, Congress only acts as a whole when they're on the clock and they have to. And I think that we have to put Congress on the clock, Mr. Chairman. I hope that we make in order either or both of Ms. Lee's amendments. They both, I think, accomplish something very similar. One would require a additional waiver. The other should be completely germane and simply allowable. I hope they both pass, and I hope we're back working on the AUMF. But otherwise, I really fear, Mr. Chair, I know you said we'll vote on one before 240 days. I don't doubt that, but there's a difference between voting one and passing one, right? We could vote on one any day and not pass it. Passing one into law requires working with the Senate and the President, and that's challenging. And I don't see all those parts coming together unless there's a clock.
I cannot, what I can tell you is this body needs to pass one.
Yeah, and
notwithstanding, I can't speak for anybody else. What I will tell you is this is among the most complex pieces, because all of a sudden we're going to fight for one of our friends. We'll actually say in there, we're going to go fight if one of our friends needs us.
For NATO, we're going to put it in there.
I'm just saying, we're going to say.
Well, yeah,
that.
I support that. I support our
You
commitments
maybe
under
will.
NATO.
All I'm
Yeah,
saying is it
that's
is
fine.
hard.
Yeah.
All of a sudden, who's our friend?
Well, it's our, yeah,
Yeah, I agree.
our
with
NATO
that. All
commitments.
I'm saying is this
Yeah.
is hard.
Yeah.
But we ought to debate it, we ought to put it out there. And
Yeah.
the people that want us out of all these operations are gonna vote no, and everybody else is gonna say, I wanna protect the country. And
Well-
we're gonna have the vote, and it'll be fair for everybody. But to say that our people don't know whether we're behind them or not is just not true. We are behind our military.
I didn't make that argument, Mr. Chairman.
I didn't say you
Yeah,
did.
okay.
To say that is just not fair to our guys. That's like saying every firefighter that takes a call, every call does or doesn't matter. We're behind our police officers, even though we know we have problems, we're behind our firefighters.
And I take the gentleman at his word, and I think that there's a good chance that this body, which is a very efficient body, will probably pass an AUMF if that's what the Speaker wants it to.
That's the extent of what I think I could say we owe it to get done.
Okay, well, I think we owe it to actually get it done, which means not just this body, it means the Senate, it means the President.
I'll let you run for the Senate and you go get it done.
Well, if it's part of an appropriations bill, we put the clock on both bodies, on the whole entity. So that's the difference, Mr. Chairman.
I'm not going to put that on whether we pass an appropriations bill and fund it.
No, I get it. And look, I mean, it's like we are appropriating $700 billion this week, but that doesn't mean the money goes out the door. There's still, you know, and we can take some pride in saying we fly appropriations bill through here. We do compared to the Senate. There's no question. The House is faster, thanks in large part to your leadership in this committee, right, Mr. Chairman? We have that process, whereas the Senate is much more difficult. They can't spend $700 billion in a week like we can. But what we really need, again, is I think a clock. I mean, it's just the only way it'll happen. I hope that we make amendment number 96 in order. That one, you know, if we're willing to make the necessary waivers, 95 also would accomplish it. I think it would pass. And I think, you know, again, we all know this appropriations bill is a long way from law also, but at least it would send that signal every step of the way that this is what the House wants. And hopefully our friends across the Capitol would listen, and I yield back.
Thank you very much. Other members of the committee? Gentlewoman, Ms. Cheney.
Thank you, Mr. Chairman. With all due respect to my good friend Chairman Cole, I really disagree with the notion that we should put in place any kind of an amendment that basically immediately cuts off funding, and with all due respect to the hard work of Ms. Lee, we have to be very careful, as we've discussed in here before, about the message we're sending to our men and women in uniform. And if we go down a path here where we adopt any language that suggests in any way that we are rescinding the AUMF, that we are cutting off funding for the AUMF, and we can all sit here in this body and say to ourselves, well, we've got 240 days, we will get it done. I have my skepticism about that, but I can tell you absolutely for the men and women who are on the front lines fighting to keep us safe, the message to them will be the U.S. Congress has just pulled support from what we're doing and what we've been asked to do. I think that there are some real constitutional questions involved, and I think we've all got to remember that the Constitution does not give Congress the power to make war. The Constitution gives Congress the power to declare war. And that was a very clear decision by the framers. The language was changed by James Madison. The wording to make war was removed because there was concern that that could be interpreted as the power to conduct war, and that is not our power. The power to conduct war resides with the executive. We have crucially important oversight obligations and authorities, and we ought to be conducting those. And I fully support the notion that we need a strategy, that we need to see this new administration put a strategy in place, that the people that we're asking to defend us need to know what the end game is, what the objective is. But we have to be very careful and tread very carefully here as we look at how we can best implement those oversight obligations, and opening up a debate in which we begin that process by saying we're rescinding authority or rescinding funding would be highly damaging. And I think, frankly, all one has to do is go back and look at the end of the Vietnam War and look at the message that it sent to people in the field in Vietnam when Congress stripped funding. If you want to make sure that we're not abandoning our troops, we have to take our obligation for oversight seriously, but we've got to do it in a way that doesn't confuse the people that are fighting for us about whether or not they have our support. So I think as we think about this, we've got to always remember that what we say and do in this body is heard around the world, and we never want to send the message that we somehow don't understand what we're fighting for and that the defense of the nation is not crucial and at the top of our list of priorities. With that, I yield back.
Thank you very much. Further feedback from members? Ms. Lee, I want to thank you for taking time to be with us.
Thank you, Mr. Chairman. A couple points I'd just like to make in closing. I want to first thank...
Gentlewoman's recognized.
Pardon?
Gentlewoman's right.
Thank you very much. I want to thank my colleagues for their comments and thank you for helping to move this ball forward. This should be, or it should continue to be, a bipartisan effort, and I thank you for that, Chairman Cole. I want to clarify the fact that this is not cutting off funding immediately. There's no way I would do that or even present an amendment that would be close to cutting off funding immediately. This gives us 8 months to do our job, to do what the Constitution requires us to do. Secondly, I'm the daughter of a veteran. My dad was a retired lieutenant colonel. He was in the African American Battalion in Italy, supporting the Normandy invasion, part of the Tuskegee Airmen group. He also fought in Korea, stationed in Korea, and lived in, served in Japan also. And so he served 25 years in the military, and I just want you to know there is no way that I would engage in these actions, in my amendments, my legislation, if I did not believe in our military and our troops and want them to want to ensure their safety and their well-being. I think it's important that they know that we recognize that they're in these new theaters of war that have not been authorized and that we either will or will not authorize them. And so they know that they're members of Congress, they're debating this with the American people behind them, and that's our job. President Obama presented an AUMF, as Chairman Cole said. I would not have supported that had it come to the floor. I did not support the Libya operation, as Chairman Cole mentioned. That never received an authorization either. And we could go on and on about the wars that we have been engaged in without an authorization and how this has become a very broad authorization for many, many parts of the world. And so it should continue to be a bipartisan effort. And I hope that one day we will come together and know that we must repeal this. And the substance of what we talked about tonight should be part of the substance of a debate in terms of a new authorization, but we must repeal it. And if we decide to replace it, then we must. But we have to talk about the costs and the consequences of what we're doing. And I think that hopefully these two amendments would move the ball further in that respect. And I'll just close by saying, Chairman Sessions, I swear, I wish someone would tell me, just in terms of process, how in the world was this amendment just taken out in the middle of the night? How did that happen?
It's very simple, and I'll take full responsibility. It was done in appropriations where we were legislating on an appropriations matter. The jurisdiction resides directly within the gentleman from California, Ed Royce, and that is in his committee. The jurisdiction, the AUMF, is very clearly in his committee, and that is where it needs to be.
And so there are no rules that require it to be taken out through a
gentleman
vote of
for a
the
question?
Rules Committee.
Sure, I'm very open to
Will the gentleman yield for a question?
But that's the answer. Did the gentlewoman present that in writing at the time she presented the amendment to the Appropriations Committee?
Did I present what in writing, Mr. Chairman?
The amendment about the AUMF.
In writing? Yeah, yes, I did.
So you gave that to the committee.
Yes.
I've heard that they were unprepared for it.
I think that, Mr. Chairman, and I didn't respond to that in the press because I heard that the speaker had said that they did not really
what I heard. That's why
know what they were voting on or did not have the information.
Previously, everybody knew in the committee that was going to come up.
Yeah.
Okay, but that's not what I heard. That's good.
No, I would not have.
Well, gentleman yields, I can just, and my friends heard me make this point, but just so anybody listening knows, look, what happened, and I understand being, not being happy about it, but it's happened to me. And as a Republican, moving something that was policy-oriented, Native American, on an appropriations bill, I thought with the agreement of the Chairman of Natural Resources, actually I'd negotiated with him, Chairman Calvert had negotiated with Chairman Simpson, Ranking Member McCullum, a group of us were working this deal. We thought we had an agreement, my amendment, and there was just a misunderstanding in that case. And he literally decided he was going to lodge a point of order against it. And so that's what happened. And it never got anywhere. I mean, it didn't get debated here. We had a colloquy down on the floor at my request on this, but there's no question he had the authority to do it. I mean, I would have only moved ahead with his consent. And as I mentioned earlier today, I'd actually gotten that same amendment with the Democratic chairman who had gone, this was Chairman Moran, and talked to Chairman Ray Hall and Chairman Conyers, who had jurisdiction. They had waived the jurisdiction in 2010, so we actually got it across the floor on the Probst bill, didn't make it in the Senate. So I know this isn't much fun when it happens, because it's happened to me, but it is within the rules.
I simply had heard, I don't know, I did not necessarily go check on it, that it was more or less an unplanned amendment that the...
No, Chairman, I can just tell you, we had talked about the amendment in a Republican meeting beforehand. I actually said, this amendment comes, I'm supporting this amendment. So they knew it was coming. I think they were surprised by the result. And I think, not to overanalyze.
That could be the surprise.
But yeah, we had a couple other amendments, or members get up that had a big impact in that debate.
Yeah, thank you, Mr. Chairman. We followed the proper procedure, regular order. We
Yes, ma'am.
Provided the notice. We did everything that
Yes, ma'am.
we were
That was my
instructed to
question.
do, and we did that. And I'm just asking, and Mr. Cohen, I guess, Mr. Chairman, you sort of explain how that can be done. I mean, I know the chair of the Rules Committee is very powerful, but I just assumed that if it were going to be removed, that I could come to the committee and make the case, and it would be voted out.
Well, let me say this. In essence, what I've done is put the proposed bill, the language of the bill that's going to be, that you can shoot against, so to speak, is out there.
It's out there, but there were, I believe, 326 pages to that bill, and the only section that was removed was the amendment that we put in.
Well, that may be true. I know we added several pieces.
Well, the one that was removed, I believe, was this amendment
That wouldn't
only.
surprise me, because we directly delineated it.
Yeah,
We
and
directly
so that's
delineate
the power of
anything.
the chair of the Rules Committee.
Well, gentlemen, yep.
I will.
Yeah, I mean, and to be clear, it's in the Rules Committee's prerogative. So the Rules Committee here can now hope to include your amendment. And if it's not in the chairman's mark, I'll offer an amendment to do that. I'm hopeful it'll be in the chairman's mark for either 95 or 96. 95, the one that repeals the AUMF, does have that cross-jurisdictional issue. But again, we in the Rules Committee can waive that. We do that routinely. That's something we do frequently. We don't have to do it, but we can do it. The other one doesn't even require a waiver, as far as I'm concerned. It's a very simple funding limitation that would be appropriate in the appropriations bill. Happy to yield to my friend, Mr. Cole.
Just one more point. I mean, this does happen, and to be fair to the chair, it's really the decision of the chairman of the committee that has the authority. If they request it, they get it basically, or usually do. They do on our side, and I've seen this happen before. It's happened to me. I've seen it happen to other Republican members. And probably our former speaker, Mr. Boehner, was much stricter about this than anybody I've ever seen, about, maybe because he had been an authorizing chairman, restoring authority to the authorizing and not letting appropriators get outside their appropriate lane. So.
And again, reclaiming my time, I mean, I think our chairman, Mr. Sessions, was right in saying the responsibility is with him. I think what you're saying, Mr. Cole, is that with Mr. Royce's objection, it put our chairman in a difficult situation.
I don't know that Mr. Royce ever expressed an opinion. In fairness, I did not know that he did. What I did recognize was what I considered and what the speaker considered to be a better alternative to the plan, which is what we submitted. It is not like we ignored it. We did not in any way dish you. We did not try and determine. We just openly I tried to respectfully, you met with me, as you recall, in the office.
But, Mr. Chairman, I guess that's two individuals, and I supported Chairman Cole's amendment, but that's two individuals making the decision,
Well,
not a Democratic three.
Because Mr. Cole agreed that with the Speaker that we would try and move forward something that we knew the chairman stood firmly for. He believes there ought to be this debate. You can debate that with me about what I believe, but he firmly does believe that. So the Speaker and I understood this.
But that doesn't speak well for our legislative process and our democratic process and regular order, Mr.
Within the
Chairman.
purview that I have as chairman of the committee to accept these things and do them, and I'm trying to accept responsibility.
And again, no one says it's not. I think that we do need to include Mr. Royce and Mr. Engel. I mean, with regards to committee jurisdiction,
Well, I believe that
made
Mr.
without.
Royce does recognize the decision that was made, and that Mr. Royce, he had very little to do with what we do, but once a decision was made about what we would ask of that, Mr. Cole knows that the chairman accepted that as a response, never to get out of doing it, but more to the direction we go. So.
Okay, Mr. Chairman, let me thank you for the chance to be with you this evening and just say that I'm very, I won't say disappointed, but I'm just really shocked at this process and how this went down. And I would hope that in the future, I mean, I guess you can do this on any amendment or any bill that you so choose, but to me, and I don't know what other members think, but I would think that in the spirit of bipartisanship and regular order and our democratic processes, that this not be done very often, because this is really wrong.
Once again, even though a committee does what they did, they are legislating on an appropriations
Mr. Chairman, we
matter.
do that. I understand that, and I think in the Appropriations Committee, and I think Chairman Cole can tell you this is done each and every day. In fact, last week, I don't know how many policy writers were put on the Appropriations Committee, but there were dozens.
There are some that are agreed to. I do confess
yes,
that.
There are
And
dozens,
done,
maybe over 100.
That is done, as the chairman will tell you, with the approval of the chairman.
With the approval of the chairman of those committees. Well, Mr. Chairman, I think that
there are things that they want to get done, and they know this is a must-pass piece of legislation. I don't need to advise the gentlewoman. She knows this. There are lots of ways to get things done.
Yes.
Lots of people work together. All I'm suggesting to you was we saw a different way, calculus, parameters, and Mr. Royce was most enamored with the ability that we would have to have the debate. I don't think in any way Chairman Royce is going to shy away from this at all.
No, okay, Mr. Chairman, I think that when you look at the policy writers that were adopted with the committee sanction and blessings, I don't believe there were any Democratic on our side amendments that were
that's
adopted.
A point also.
And we're trying to make this bipartisan. I mean, if you understand
I
my
understand
position
a lot of
in terms
things,
of the
but-
bipartisanship nature of what we try to do in the Appropriations Committee.
Yes, ma'am. Well, Chairman McThornberry has a lot to say about a lot of these things, too. And he is very close to his ranking member, and Kate Granger is very close to her ranking member, and there's a lot of ways in which they work together, and we're going to approach the subject.
Okay, Mr. Chairman, thank you. I think that we just have to keep working at it, and I'm going to keep at it.
I think Mr. Cole gave you credit for that one.
It's very important, and I hope it becomes bipartisan, and I hope that, or continues to be bipartisan, and I hope that we're not undermining at every step of the way, because
but
we
you're
have
not
to
be-
feel
you're not
that
being
we're working
undermined.
together.
We're going to have the debate. I just can't promise its passage by the United States Senate, signed by the president. And that's what we're trying to get to by taking feedback actually from the State Department. We believe.
The president actually should submit an AUMF for us
Well-
to debate. That's the way it should work. And the reason I've been doing this for so long.
Or at least we
is
take their
don't
feedback.
have it.
Yes, ma'am.
Well, they should present it.
I don't know. I don't know. What I do know is we got to approach it.
Okay, thank you, Mr. Chairman.
Ms. Lee, you
I'm
can
sorry,
stick around as
members,
long as you
but,
want. You can
know,
stick around
we'll
as long as you
keep
want,
going on.
or-
I mean,
or-
if there were, if we didn't have so many members here, I would want to stay here all night and talk to you
I think
about
you
this.
still ought to, but does the gentlewoman wish more time?
No, Mr. Chairman,
Well,
I
the
just hope
gentlewoman-
that people understand that, you know, democracy is very important, and the democratic process is important, and members should not be undermined, I don't believe, by 3 or 4 or 5 individuals if they have worked together and put something together, gotten it in a bill, bipartisan, and then it's ripped out.
Happens all the time. Happens all the
That
time.
is really a shame,
No, it's
Mr.
really
Chairman.
not.
That doesn't bode well
We
for
take
this
bills from
body.
different committees and we merge them together all the time. And accountants see things different than bankers, and lawyers see things different than CPAs. And we have to make a decision about which mark will come up here. We do this every day.
Okay, Mr.
Yeah,
Chairman. Well, next
I'm
time-
not saying it makes sense to you, but it makes sense to us. We have to make decisions every day.
Just to clarify, Mr. Chairman, I mean, we do it sometimes, but I mean, it's not the normal practice of this committee to change
Well,
committee marks.
We do this as bills get together.
We certainly do it sometimes. I would
I think
agree.
it's been done
It
maybe
happens in my world.
two times in the last year or two, maybe 4 times in the previous.
No, ma'am, they're what are called managers' amendments. They're what are called managers' amendments, and they happen all the darn time. And that is where I go meet with the chairman and I say, Mr. Chairman, we'd like for you to add this or change this or do that. And they go in and they change that. It's either that or I would come up here and have to do what we're doing now. And all I'm trying to do is carefully allow you to see where it is, delineate it in the report, and look you right in the eye and tell you, we're going to debate this issue. If I were trying to get out of the debate, then I'd be willing to be run out of town.
No, Mr. Chairman, I understand you said you're not trying to get out of the debate. I guess I'm just, it's just perplexing that this could happen in the middle of the night and without even my
I don't want to
input
put
or
us into a
debate of this rule
circumstance.
committee.
I don't want to put us into a circumstance where we're not hearing from the administration and we're not effectively going after this. So I appreciate the gentlewoman being up here.
Okay, thank you
Yes,
very
ma'am.
much. Thank you, members. I apologize for this delay.
No,
but,
you're doing it.
this is an
Mr.
issue
Chairman?
that-
Yes,
I ask
yes.
unanimous consent to insert remarks by Mr. Vesey and 2 remarks from Ms. Sheila Jackson-Lee into the record.
Without objection, we'll enter those in the record. Thank you very much. And if the gentlewoman, Ms. Lee, has anything in writing or awesome stenographer, we welcome the opportunity to see that. Yes, ma'am. Thank you very much. Madam Chairman, welcome to the Rules Committee.
Thank you, Mr.
Gentlewoman's
Chairman.
recognized.
Thank you, Mr. Chairman, and thank you to the Rules Committee for considering my amendment, which is Division C of the Make America Secure Appropriations Act, Amendment Number 20, and permitting me to testify here today. My amendment would protect the jobs of more than 45,000 disabled Americans employed by the Ability One program. Their jobs are at risk because of a change the Veterans Administration made to its contracting rules in March of this past year. So just this year in March, the VA issued a memorandum which changed the contracting rules that have been used for decades to give jobs to the visually impaired. Right now, more than 800 workers employed through the Ability One program contracts, and many of you have probably heard of Ability One and maybe, and I know are, Ability One champions, including more than 500 veterans, will face immediate job cuts due to the VA changes, which I find unacceptable. And so protecting these jobs is top priority. The VA's rule change came in the wake of a U.S. Supreme Court decision late last year in June of 16. It's called the Kingdomware Technologies versus United States case that found that the agency was required to follow a 2006 law requiring that veteran-owned businesses be given priority. The VA, I believe, interpreted the court ruling too broadly when it quietly changed the rules in March. The VA focused on for-profit businesses owned by veterans while ignoring a separate 1938 law that granted priority status to more than 550 not-for-profit vendors that employ the disabled and the blind, many of whom are veterans, to produce and sell goods to the government. So we believe that the VA's interpretation would have a disastrous effect, and we've been told by the National Institutes for the Blind, including an important business in my district called Bosma Industries, that this VA's interpretation would have a disastrous effect on these not-for-profits that have the contracts with the VA through the Ability One program. So Bosma Industries Enterprises, Hoosier Business, a nonprofit that's been serving Indiana, the disabled and the blind for over 100 years. And they came to me, albeit late in the process, after the appropriations process had already, as we had moved through the Appropes bill. They are the largest employer of people who are blind or visually impaired in Indiana. And in case you didn't know, 70% unemployment rate is what is in existence in this country for the blind and the visually impaired. And so their services are crucial, as are many nonprofits in your districts and the districts across the country. So I have grave concerns about the detrimental impact the VA's recent regulatory change would have on Bosma and others like it across the country. My amendment does not seek preference of businesses that serve the blind over veteran businesses. It simply is putting a pause on their proposed action until we can find a way for both to coexist as they have for decades. If the VA's procurement policy is allowed to take precedence over federal law, hundreds of these nonprofits will lose the majority of their Ability One contracts. I must say that I believe that we can find a way for the VA and Bosma and other nonprofits to continue their longstanding successful relationship. But if VA interprets their rules the way they plan to, it will have a dramatic impact. We did not know about this when the appropriations marked up the fiscal year 18 Milcon VA bill, so I was unable to address this issue before the bill moved forward. The committee did, however, include some report language because they were aware of the Kingdom Ware decision, but the report language is just requiring the VA to report on the impact of the Kingdom Ware decision. We've been told that this report language is not going to be enough to protect the jobs of the thousands of the disabled individuals, and so it was these nonprofit institutions like National Institute for the Blind and many others who came and sought this change. And I believe that this is critically important. VA, and if any of you have visited these nonprofits and seen the incredible work done by these men and women who want to work and who have had the ability for decades to do this work and to help provide for themselves and their families, you'll hopefully agree with my limitation language in this amendment. And I am happy to answer any questions you might have.
Ms. Brooks, I have been following an issue around this. It dealt with the DOD, and it dealt with the Department of Labor. And last year, we worked with the White House and the prior administration on this issue and advised them of the law. I was unaware of this March directive. And I spoke with Mr. Hubbard, who's the legislative director for the Rules Committee, who'd been handling this. And I must admit, I'm embarrassed to find this out. I have been following similar provisions and similar attacks against it. And I will tell you, I appreciate you.
Thank you.
No questions. Thank you.
Thank you.
Any member? Thank you for not only your time, but your production of this legislation that you think will help gain the notoriety of this issue. And I appreciate it very much.
Thank you so much for your
The gentlewoman, please make sure she leaves anything she brought in writing for our awesome stenographer to enable her to
Thank you, Mr. Chairman. Yield
get
back.
that done. Thank you very much. Ms. Titus, welcome.
Thank you very much, Mr. Chairman.
Yes, ma'am.
Nice to be here with you. I'm going to speak about something you've heard me talk about many times before. My remarks are in reference to two amendments, the QN01 and QN16 under Title D. I'm a co-sponsor of both of these. They both deal with the proposed Yucca Mountain Nuclear Waste Repository in Nevada. I've been fighting against this waste dump in Nevada for many, many years now, which, by the way, has no single nuclear power facility in the state. Now, most people have not been to Yucca Mountain, but I can assure you it's not some faraway, desolate moonscape. Yucca Mountain is less than 100 miles away from Las Vegas, which is home to more than 2 million people, and also we welcome nearly 43 million visitors from around the world every year. Las Vegas generates billions in economic activity. It hosts some of the largest trade shows and conferences in the world, and it's surrounded by some of the most iconic and culturally important places in the desert Southwest. From the native petroglyphs and artifacts that tell the story of southern Paiutes and the region's earliest inhabitants dating back thousands of years, to the Red Rock Canyons, the snow-capped mountains, the iconic Joshua trees, bighorn sheep, wild horses, burro, desert tortoise, Nevada is not a wasteland. The proposed Yucca Mountain facility is based on faulty scientific studies that ignore the risk in the immediate area, including an active fault line that runs under the mountain. You may have seen in the paper recently, just 2 weeks ago, a 4.1 magnitude earthquake occurred just south of the proposed site, and it rocked the Nevada test site, or now known as the Nevada Nuclear Security Site, which has for decades been the site of above-ground and underground atomic weapons testing, and today still is where they carry on many of the critical subatomic experiments for our military and nuclear deterrence. Now, there are countless reasons why Yucca Mountain is unworkable and unsafe, and I won't go into all those because today's amendments are about the fiscal responsibility of this Congress. I believe it's irresponsible to throw good money after bad on this incoherent policy and unworkable project. And it's clear to our colleagues in the Senate that further spending on this project's a fool's errand. That's why the Senate Appropriations Committee chose not to include any continued funding for this project, and why their leadership is authorized in the authorizing committee is preparing bipartisan legislation to move forward with nuclear policy based on the way every place else in the world does it, and that is a consent-based approach. Now, this committee has an opportunity to do the same thing if you make these two amendments in order, and they will remove the associated funding with this boondoggle. So I would ask you to take a long look at where we are on this issue and recognize that more money, just throwing it down a rat hole on this failed project, is simply not going to move the ball forward for how we need to address the disposal of our nuclear waste. We don't need to spend an additional $120 million on this that's going nowhere. So I thank you for your time. I'm keeping it short and sweet, and I urge you to put these amendments in order. Mr. Chairman.
Thank you, ma'am. How much money has the federal government spent there?
They've spent about $8 billion, but the estimate is that they're going to spend about $100 more billion, between $80 and $120 billion, to actually finish the project. That's a tremendous amount of money that would go into this project. I don't know where it's going to come from. Some of it can come from the ratepayers fund, but that will not cover nearly the cost. And people who think that there's going to be additional money on top of that to give Nevada some kind of sweetener, I think are sorely mistaken, because I don't believe there'll be the money for that either.
Well, I'd love to see it come to Texas. Texas would be in favor of moving it over there in half a heartbeat.
Well, that would be the consent-based approach, and that's the way we should be doing it.
It would be awesome. Lay off all those people in Nevada and move it to Texas, just like everybody else. Mr. Cole?
I'm not going to touch that one.
There are not that many people working at the site right now, Mr. Chairman. And, you know, once it's
that's
finished,
your
it doesn't
issue.
take
I'm
many
saying
people
we'd
to
like to get the business.
Well, I say
I think we're all on the same
we'll be
page
glad to
here.
give it to you.
Yeah.
You take it. We're happy if you want to have it.
Gentleman does not seek time. Gentleman seek time.
I think this is great. This is an example of consent-based approach. Texas wants it. That's terrific. Nevada doesn't. We got a deal.
Give Texas that $120 million.
That's right.
I'll vote for that.
I'm happy to.
Talk to Chairman Shimkus. He's got the policy.
Happy to do that. Yeah, I support the amendment. I yield back.
Thank you very much. Any other member seeks time? Seeing none, Ms. Tice, thank you very much.
Thank you, Mr. Chairman.
If you'll please leave whatever you brought in writing for Austin stenographer, that'll help her out, and sure. I would just add every bit of that when you get a chance down the floor. Just talk that way all you want. We appreciate you, Mr. Mass. Thank you for your service to this country. We not only appreciate you, but I think that your duty to this country is yet to really embody the rest of your career, and I know you're engaged in that now. Wish you good luck on that. Jones recognized.
I thank you for those wishes, Chairman. Truth be told, most days I couldn't believe I was getting paid to do the things that I was doing, so it was the honor of my life. I come to you today with 4 amendments to defense appropriations. All of them circled around something every single one of you have sitting in front of you, and that's clean water, something that affects every single one of us, every single one of our constituents. First Amendment goes to Division D, number 24. This is an amendment that replaces a $500,000 shortfall to last year's appropriation to the U.S. Army Corps of Engineers and their research and their development arm. And it's a researching measure to prevent and control the nuisance plants, such as harmful algal blooms, some of which have plagued my area, some of which have plagued areas like Lake Erie, some of which have plagued areas like down there by the Mississippi River Basin, other areas like that. My Second Amendment goes to Division A, number 49. This amendment goes to the Navy's research arm, similar to the U.S. Army's research arm. This is the Navy's research arm for testing and development, and this amendment replaces the $598,000 shortfall from last year's appropriation. Makes some pretty important investments, and again, curbing these harmful algal blooms, often algal blooms containing things like microcystin algin that are very harmful to the water that we drink, the communities that they affect, the real estate values, the ability to go out there and have recreation, the ability to get in the water whatsoever without being harmed both by the toxins that come off of that aerally and the toxins that are in the water. My amendment number 3 goes to Division 3. It's number 23. This amendment specifically increases Army Corps of Engineers Research and Development Center dollars again to the tune of $500,000. This is the only federally authorized research program that's directed to develop technology for the management of these non-indigenous aquatic plant species. So if the Corps of Engineers isn't out there doing research on combating these algal blooms that affect people across the breadth of this country and the water that they drink and the water that they're in, then there is not a technology arm out there within the federal government that's developing the technology to do that. It's been an excuse that I've heard from the Corps of Engineers previously about why they haven't been able to undertake efforts to clean up some of the algal blooms in different places because they simply didn't have the technology to scale what they could do in a fish tank to sometimes in cases as much as millions of gallons a minute. Amendment number 4 for me, Division D again, amendment number 32, and this amendment specifically appropriates $750,000 to the Lakes program. That's been authorized since 1986 in WRDA every single year to provide cost-sharing grants to state projects. So you're going to get a benefit in working with the states on these projects, again, to remove toxic substances from the lakes. And these programs, they were actually designated to be appropriated at $40 million per year. We're asking for $750,000 or $750,000, less than 2% of what's already authorized in this grant program for removing toxins from our nation's lakes. It's all amendments relating to the water that we drink. It's important to everybody out there. So it's in that I just ask every member of this committee to take a long look at where the water is that they drink, where it comes from in their district, in their areas for the people back home, and if this is something that's important to them. Thank you, sir. I yield back.
Thanks, sir. Do you sit on the Appropriations Committee?
I do not, sir. I sit on the Committees of Transportation and Infrastructure and the Committee of Foreign Affairs, sir.
Okay. If I could ask the gentleman, Tom, has this been a discussion in appropriations of some university that really specializes in these? I don't know who's better able to really understand this.
Chairman, I don't actually sit on the relevant subcommittee, so I don't know. You know, we'd need to check with one of them.
Is there a university that really, you're asking the Corps to do this, not to offer a grant to do it. Would you expect that they would go and actually go to something in a university or academic setting to figure this out, or would you expect that they would hire somebody and do the work themselves?
So, sir, on the technology front of it, there are various private entities, and there are as well universities that have been out there. I reside in the state of Florida, and I can tell you some of our biggest universities and colleges have been out there doing research. It is specifically the U.S. Army's Corps of Engineers, their ERDIC, their Engineering Research and Development arm, that has been brought to my attention by the Corps of Engineers saying They have not developed, that testing arm has not developed anything that could allow them to scale the kind of removal of toxins, as I pointed out, like we might look at a fish tank, the way we can remove algae and toxins from a fish tank. Their research and development arm has not seen any technology that would allow them to go out there and do that, and so therefore I believe the emphasis is on them.
See, I didn't know whether you'd say EPA or what you'd say would have some of that. Find it most interesting. Mr. Poles?
No, thank you.
Any member of the committee?
Yeah, Mr.
Gentleman,
Chairman, if I could, I was going to ask the gentleman, when you first started into this series of amendments, I was curious as to whether we were talking about saltwater or freshwater.
Sir, we're specifically talking about freshwater algal blooms, those that often are moved into saltwater areas because sometimes some of the areas that they're developed in are moved into areas that are meant to be salty, but they put so much fresh water because of Corps of Engineer discharges to the tune of, again, millions of gallons a minute that can actually turn a saltwater area fresh and allow these toxic freshwater algal blooms like microcystin algin to exist in what was otherwise a salty body of water.
Okay, so the stuff that we read about, like the red tide, that's not what you're discussing.
You could probably lump that into the conversation because it's saying a cart and a horse conversation. You're talking about things that exist in the same bodies of water, often at the exact same times, often in parallel or one after another.
Mr. Chairman, in answer to your question, let me just offer that the University of North Texas, back in the days it was called North Texas State Teachers College, had one of the premier limnologists ever in this country, Dr. J.K.G. Silvey, and he made a name for himself studying the effects of blue-green algae in what was then Lake Dallas, and now has expanded to Lake Louisville. You're familiar with it because we went out there to the dam together.
Yes, sir.
But every summer when I was a kid, the water smelled bad. Wasn't supposed to be dangerous, wasn't supposed to hurt you, it just smelled bad because of the growth of blue-green algae in the lake in the month of August. And Dr. Silvey spent his lifetime studying that. I think they eventually, and it's been years since I've thought about this, so you've kind of tapped something in my memory, but they came up with a way of superoxidation with potassium permanganate to take the smell out of the water, if I recall correctly. So this is something that, again, I know my little university in Denton, Texas, has had some experience to answer the chairman's question. And of course, again, Lake Louisville, which you're very familiar with because we've been out there to the dam together.
Sir, if I may comment on that. The algal blooms that we're talking about here are not small in size or small in scope or small in their effect. This problem is not ambiguous to me. I've witnessed it personally in numerous areas from Michigan down to Florida. These kind of algal blooms that very specifically plagued the Florida region last summer and are plaguing the Florida region right at this time, they were as deep as a foot thick in algae that had the consistency, literally, of guacamole. Algae that was so thick that birds or other animals could walk on top of it, that killed off the sea life, that killed off the seagrass, which housed thousands of species of sea life, that killed off things like manatees, that killed off birds, that killed off anything that went into it. That resulted in a number of bacterial issues that resulted in hospitalization for citizens across the area. In Lake Okeechobee last summer, one of these algal blooms was roughly 30 miles in diameter, or rather in radius. There's an algal bloom similar to that that's developing out there right now. So I'll tell you, this problem is not just related to smell. It's related to sea life. It's related to human health very specifically, and not just in terms of whether somebody enters the water, but also in terms of what they're breathing.
Well, if the gentleman, I was not trying to minimize the problem that you're experiencing in Florida. I was only pointing out to our chairman that there is a university that has studied this issue not far away from where he lives, just for your consideration.
Yes, sir. Thank you, sir.
And I'll yield back.
Any other member seek time? Thank you very much. We appreciate you bringing serious information, some that I'd really never known before. Tom, we're delighted that you're here.
Thank you, Mr. Chairman, and thank you to the members of the committee. This has been a real education for me to observe the committee over the past several hours.
Couldn't wait to get on here, could you?
No, I've really enjoyed it. I really have learned a lot. And I want to thank you for the opportunity to testify on behalf of a bipartisan amendment that I'm making with Congressman Peter King and Congressman Paul Cook. It's an amendment in Division A, number 47. The purpose of the amendment is to match $34 million in funding provided for unanimously in the NDAA, but was not included in the appropriation process. In my district, for almost 4 decades, the people of Bethpage and the surrounding areas have been dealing with an environmental crisis. Groundwater pollution stemming from the Navy and defense contractors' related activities have resulted in an underground plume of contaminated water that is moving south through Long Island's sole source of drinking water towards Congressman King's district. While costly remediation efforts ensure the water is safe to consume, it doesn't change the fact that residents need to have this cleaned up before it spreads further. The contamination, known as the Navy Grumman plume, is one of thousands of sites at hundreds of locations that have experienced environmental degradation because of defense-related activities. Congressman Peter King and Congressman Paul Cook and I have submitted a bipartisan amendment that will increase funding for the Navy's Environmental Restoration Account, which helps fund cleanup and remediation efforts for these sites. This is not a partisan issue. The funding levels sought by this amendment received bipartisan support in the NDAA. Chairman Thornberry's mark and my amendment together, which was joined by Congressman Cook and Congresswoman Hanabusa at the time, increased the authorized amount by the amount sought here, $34 million. Our colleagues on both sides of the aisle supported that effort because this funding will help clean up sites from Maine to Hawaii and Florida to Washington State, and were provided for with the appropriate pay-for. I ask for your support in moving this amendment to the floor so our colleagues from across the country can vote to help clean up environmental contamination stemming from defense-related activities in our district. Thank you, sir.
Yes, sir. Any questions from the committee?
No, thank you. I support making the amendment in order.
Thank you very much. We appreciate it. If you'll please make sure, Tom, that our awesome stenographer receives whatever you brought in writing, enabling her to finish off your remarks.
Thank you, sir.
Thank you, sir. Jimmy, we're delighted that you're here. Left nobody else standing, so it's all you.
I appreciate that, Mr. Chairman. Thank you. Other members of the Rules Committee. Mr. Polis, thanks for holding down the fort over there on the left side. I appear before you tonight, sir, to support my amendment to H.R. 3219. My amendment would prohibit any funding for the implementation, administration, or enforcement of Executive Order 13795. That was an executive order that was entitled Implementing an America First Offshore Energy Strategy. That executive order, signed by the President on April 28th of this year, orders a review of oil and gas leasing in our nation's outer continental shelf, and it mandates the Secretary of Commerce, in consultation with the Secretaries of Defense, Interior, and Homeland Security, to conduct a review of all designations and expansions of national marine sanctuaries and national marine monuments that have been designated or expanded within the last 10 years for potential energy and mineral exploration and production. Now, that order would directly impact my district. My district, the 20th in California on the Central Coast, holds the Monterey Bay National Marine Sanctuary. And if you've ever been there, you'll see that that sanctuary provides plenty of tourism, plenty of fishing, plenty of wildlife, the Monterey Bay National Marine, Monterey Bay Aquarium, 20 research facilities that actually look into issues that were just being discussed earlier prior to my testimony. But this order isn't about my district, not just about my district. Sanctuaries, as we know, have protected and benefited communities nationwide. In 2010, over 13.5 million people were employed in over 750,000 businesses that were involved in the tourism industry and coastal communities throughout our country. That equated to a combined wage of $266 million. However, the total economic value generated by the U.S. coastal tourism industry in 2010 was estimated to be about $530 billion. The executive order that I mentioned earlier will threaten that economy with the likelihood of offshore oil drilling. This executive order will not benefit the American people, nor, I believe, nor will it improve our energy independence. But it will put our coast and coastal economies at risk. Our nation's shorelines, our national marine sanctuaries, and our marine national monuments are a vital part of who we are, our heritage, and our economies. Neither I nor many members of Congress want our coastlines to be polluted by the consequences of offshore oil drilling, because our constituents do not want to put their coastline and their businesses at risk. I bring this amendment to you, the Rules Committee, to ensure that our coastal communities and economies are protected and that our legacies, the national treasures that we leave for our future generations, are preserved. Thank you, Mr. Chairman. Thank you to the committee.
Yes, sir. I don't know what I'm talking about. I've been there, not been in the water, but I've seen off the coast where you have the old oil derricks that are now havens for fish and divers and other people. But one of the things that I did note when I was out there is that there are still a good number of tar balls that appear because it naturally comes up through the surface and dumps a lot of oil there just by virtue of its own processes that happen.
That's correct, sir. That can happen. That's right.
I think it does happen.
Yeah.
So there's no easy way, no easy way really to look at that. In Texas, we choose to drill.
Understood.
Because we needed the money, but the nation needed it too. So I wish you good luck.
Thank you, sir. Appreciate that.
I encourage the amendment to be in order, and I yield back.
Thank you, sir. Any other member of the committee? Do me a favor and tell your dad you came before the Rules Committee. Did your dad sit on the Rules Committee for a while?
I don't think he did. No, sir. Budget, mainly budget.
Just budget.
Ag and budget.
Ag and budget.
Yeah, that's right.
Smart guy. Thank you for your service. Please make sure you leave whatever you've got in writing for our awesome stenographer, and we'll see you tomorrow morning.
You bet. Thank you, sir.
Thank you, sir. Okay, we're going to go what appears to be the cleanup team here. The gentleman, Mr. Hurd, the gentleman, Mr. Davidson, the gentleman, Judge Gomer, the Eagle Scout, Neil Dunn, Mr. Lamborn, Mr. Perry, and Mr. Barr. Who else do we have that's interested? Killers lineup, Killers row. Judge Gomer, welcome to the Rules Committee. Gentleman's recognized.
Thank you, Mr. Chairman. Since the amendment that I have filed is exactly like one Vicki Hartzler filed previously, I'm not going to spend a lot of time on it additionally, other than to say that since Ms. Hartzler filed that amendment, we've learned so much more. Commanders have indicated that if they have a troop that wants a sex change operation, they're told roughly count on them being undeployable, unusable. We have to send them into combat or in harm's way. They have a slot that it's taken up by somebody going through gender transition, and costs we're looking at over 10 years, $3.7 billion. Regardless, this isn't a debate about transgenders and not a debate about gender reassignment surgery. If someone feels that that is the appropriate thing to do, then the argument here is we're talking about the precious money we have for our military to protect us and to protect themselves. And to spend that kind of money on gender reassignment for those who are diagnosed, got downgraded under DSM to transgender disorder, and then now to gender dysphoria, confusion, unhappiness with the situation. Having spent 4 years on active duty in the home of the United States Infantry at Fort Benning, we can't afford to be having people who are confused or unhappy with their gender in those slots. So that's the amendment. I would also add, though, that when we're looking at people going into combat, for example, a rifle squad, where you've got to count on the 10 people around you and every slot is imperative, it's just not appropriate to tell a platoon sergeant, well, but that's being taken by somebody going through the pre-surgery hormone therapy back in the States. This is not the place. The most extensive study ever done on the issue of sex or gender reassignment was done in Sweden over 30 years, hundreds of people, lots of data, as you can imagine, over hundreds of people, 30 years. But the most glaring piece of information was that if you go through a sex change operation, you're 20 times more likely to commit suicide than the normal population. And with our military at record levels of active duty suicides, it just does not make sense to add this as an overlay on the existing situation. So amendment is there, and as it says, none of the funds made available of this act can be used to provide medical treatment other than mental health treatment related to gender transition. So in essence, that's the amendment.
Thank you very much.
Not new. Thank you.
Yes, sir. Ms. Polis?
Well, how many times do we have to defeat this amendment? It's been defeated. I hope we don't rule it in order. Frankly, it's an embarrassment on the majority to be talking about these kinds of issues. The gentleman from Texas just doesn't have a great understanding of these issues. I would ask the gentleman from Texas, not the chair, the other gentleman from Texas, Mr. Gromer, would you be willing to meet with some transgender veterans who can help educate you on this issue if we can set that up in your office?
Yes, and I've met with Walt Heyer, who also meets with people on a regular basis. He says 40% of those who undergo gender transition, sex transition surgery like himself have suicidal tendencies, and that's why he's devoted the last 20 years of his life to helping people that go through that. So
you would be willing to do that?
Yeah.
Okay, thank you. I thank the gentleman. All I can ask is
the gentleman will also be willing to talk to people
of course,
who have been suicidal as a result of the kind of thing that the gentleman is urging.
Absolutely, and I know that there could be people who have gender dysphoria that might become depressed because certain politicians try to prevent them from going to the bathroom and others try to stigmatize them, and I understand that that can be very difficult for people who have transitioned their gender. So I know that there's all right, so I would appreciate the gentleman's that meeting. We'll be happy to work on that. I would also just say that there's different things we're talking about here. We're talking generally about hormone treatment. It's very inexpensive. It's not a surgery. It is possible, again, there might be a few dozen or less surgeries a year, but we're talking about the vast majority of treatment as hormones, which is inexpensive, does not render a soldier unable to fulfill their duties in any way, shape, or form. We have, as you know, men and women in combat operations. One's gender does not matter with regard to that. Obviously, we have merit-based tests that men or women can fill. Up until recently, women were prohibited from certain combat operations. They're now allowed. So, again, this refers to a lot more than the part you talked about, surgery. I wanted to make sure you're aware of that the vast majority of what we're talking about here is hormone treatment.
Well, there has to be pre-surgery hormonal treatment leading up to the surgery. And that's what we're talking about, the sex reassignment surgery here.
So again, not every transgender individual chooses to have surgery.
That's right.
There's also different kinds of surgery. There's, again, the reason that it's awkward to talk about this is because this is between a doctor and their patient, and that should be the same for somebody in the military. In fact, first and foremost, supporting our troops is so important, including of course, our transgender troops. It's not a discussion that politicians should have. It's not a judgment that politicians should make. It's not a funding decision politicians should make. Just like any type of condition that a member of our military has, that's between them and their doctor. We of course want to get them back into fighting shape, and if they need a hormonal treatment, that's very inexpensive. There's many other soldiers that have other conditions that cost a lot more, and there's no amendment here to remove that funding, which is why I consider this somewhat disingenuous. It's clearly targeted after a particular group. There are other soldiers that have other conditions that are more costly. and yet they're not left out of this. So I don't consider this a cost measure. I think we need to support our troops. This is good for morale. It's good to support the military. There is, as you know, a study going on that this would apparently short circuit or circumvent. I think that's one of the reasons that this was previously defeated on the floor, is many members of this body want to see what the military themselves has to say, which we will see, I think, in the next few months, if I'm not mistaken. We'll get that report back. So I don't know how many times we have to keep debating this, but I think it just embarrasses, unfortunately, the majority every time to be talking about, people's private parts instead of trying to have the best fighting force we can in the country. So I hope that we don't put ourselves through this again. I mean, if you make us, we'll do it, and there'll be another vote, but how many times do you want to be talking about this stuff on the floor? It's just inappropriate for politicians to be talking about.
Is that rhetorical, or may I answer?
Oh,
I will bring this up as many times. The gentleman's probably not aware, but I represented many transgender individuals when I was in the United States Army at Fort Benning, Georgia. I knew their innermost personal thoughts. I did everything I could to help them, and I'm telling you that it is not good for the good order and discipline. It wasn't good for them. It was not good for the good order and discipline. The purpose of the military is not to be social experimentation. It is to put together the meanest, toughest, disciplined fighting force.
Yeah, reclaiming my time. You're seeking to do a social experiment in the military. You're trying to take something that's a medical condition and saying, I have this other idea. You're entitled to have that, by the way, as an individual. As an elected official, you're saying, I know better than the doctors. I know better than medicine. I'm going to do a social experiment in the military that frankly will tear apart. Look, I'm not expecting. I appreciate that you'll be willing to meet with some transgender veterans.
Does the gentleman have a more thorough study than the Swedish study over 30 years?
Well, listen, as you know, transgender individuals are being attacked by politicians, present company accepted. They're frequently prevented from marrying in some states, from getting driver's licenses. There's issues about people trying to say they can't even go to the bathroom. So if somebody was doing that to you, you'd probably be pretty depressed too. So I don't know, I haven't seen that study. But again,
aware 80% of transgender confused young people, children, resolve without ever having any counseling whatsoever.
We're not even talking about children here.
Well.
With again,
I direct you to Johns Hopkins University Hospital.
We're talking about the military, and I oppose you doing some sort of social experiment that you're trying to do on the military. We're not talking about minors here at all, just to be clear. That's a different topic. Happy to debate that with you. I'll meet with your folks, you meet with my folks. We'll both try to educate ourselves. I hope the House Republicans don't put them through this again. I hope we end it, and I yield back.
Thank you very much. Someone yields back his time. I look at it, I know we can all look at it different ways. I look at it as elective surgery. That sometimes the military should and should not become engaged in things, but certainly if it was not caused as a result of their military service whereby they were injured, I oppose spending the money for elective surgery. Mr. Cole? No questions. No questions. Dr. Burgess?
And I appreciate your passion on this, and I know that this is driven by the best personal instincts and principles. This amendment did fail. Is that right? This is the same.
Yes, and we had several people that weren't there to vote. We had one who said he made a terrible mistake and voted no.
So your expectation is there would be a different result?
I think it would, yes. I really do.
Well, it's important to bear that in mind, because if it loses twice, it becomes more difficult to manage anything from an agency perspective.
Sure.
Have you discussed with the defense appropriators the possibility of narrowing the scope of the amendment to just include surgeries and not medical therapies?
No. No, because I anticipate it would pass if it's made in order again.
Well, again, I appreciate the passion the gentleman brings to this. I voted for it when Ms. Hartzler brought it up. I will vote for it when the gentleman from Texas brings it up.
If I could just volunteer one more piece of information that I didn't have before the vote last time. Gentleman who has been through the sex change surgery, is transgender, and openly acknowledges, when asked, do you think this would, that the military would begin to draw people who want sex change surgery, because you're not just getting all of the surgery paid for, all the hormonal treatment, but you're also getting housing allowance like an E4, I think around $1,300 a month, plus full pay allowances. He said, I can imagine it would catch on, and you could end up having 90% of those seeking surgery with no way to pay it heading for the military. You got to do 180 days active duty before you could submit the request, but that's also something to be considered. Thank you.
Well, again, I thank the gentleman for his passion on this and his adherence to principle. Mr. Chairman, I yield back.
Gentleman yields back his time. Is there any other member that seek time? Judge, I want to thank you for taking time to be with us. Thank you. Please make sure you leave whatever you brought in writing for the awesome
Just add the amendment. Thank you.
That'd be great. That will be fine. Mr. Lamborn, I'm delighted that you're here. Gentleman has been here a long, long time. Gentlemen, if you'll grab that microphone that's right there, make sure that green light's on, it is. Gentleman's recognized.
Well, thank you for taking this request for an amendment. So, Mr. Chairman, members of the committee, I request your consideration of amendment number 29. It would prevent the divestment or transfer of 2 C-21 aircraft from Peterson Air Force Base. The Air Force currently plans to divest these 2 aircraft, which would shut down the 200th Airlift Squadron. This 200th Airlift Squadron is the only C-21 unit in the Air National Guard, but most of all, it would result in the loss of 20 pilots. I'll explain more about that in a minute. And we do have a current pilot shortage in the Air Force of about 1,500 pilots. So I don't understand why this action would be taken that would result in the loss of 20. The unit has a continuing and valid mission that supports national defense. This includes transport for senior government leaders, important sensitive cargo, and direct support to NORAD. And my understanding is that the needs of the mission would go on. It would just be given out to private contractors. The Air Force claims that this would save about $450,000. But when you look at the cost of training a single pilot, estimates are as high as $10 million per pilot. This is a penny-wise and pound-foolish decision by the Air Force. So I live in a very military-intensive district, one of the 5 most intensive districts in the country. 5 major installations are there. People are coming and going constantly. And in 11 years, I've never come before you or sought to change a decision. But this is such a bad decision. I'm before you today opposing it. It just does not make sense. Losing 20 pilots. I suppose one of these pilots could go to another state and get trained to be on a different type of aircraft and wouldn't be lost. But most of these 20 would probably go into the airlines or something else, or just retire. So for those reasons, Mr. Chairman, I ask that you would make this amendment in order, and I'm happy to answer any questions. And I'd like to offer 2 things for the record. The first is a letter from the most of the Colorado delegation to the Secretary asking why this is being done. 6 of the 7 members of the delegation, the 2 senators, and the governor. And then this is dated today, the International Association of Machinists and Aerospace Workers supporting the amendment. I'd like to offer this to the committee.
Good. Without objection, we'll do that to the record. Gentleman yields back his time. Gentleman from Colorado.
Do you know where as the new head of the Colorado National Guard or the governor's office expressed an opinion on this?
Well, the governor signed the letter questioning why this was happening.
Mm-hmm.
The National Guard, this is the only such unit in the country, so they're not happy about this.
Can I see the letter real quickly there, for the record? I just had one more question on it. Oops, no, the one from, yeah. Let's see. Yeah, and so what I wanted to confirm is that, while I wanted to be clear, so I signed the letter. I think that's the fair action, asking the reasons. A funding prohibition, I think, is not a fair action. It is subverting their judgment. I think they owe it to us to give the reasons why. I appreciate you leading this letter. I signed the letter. I look forward to the response. They owe us a response. But I don't think we should circumvent the process legislatively by inserting very restrictive appropriations language in there. So I just want to be clear that everybody who asked why, and I don't know where the other members are who signed the letter on the amendment, but not everybody who wants to them to explain themselves would also say, therefore, we should subvert them and legislatively prohibit those from being moved. So I just want to be clear; those are two different things. That's all I wanted to point out. So I'll yield back.
Point taken.
Thank you very much. Any other questions from our gentleman, Dr. Burgess?
Mr. Chairman, I apologize. I guess I didn't hear what type of aircraft we're talking about.
Okay, C-21s, they're not cargo planes. They're personnel planes, like a modified Learjet almost.
Are they like a C-39?
I can't answer that.
C-39 is what I used to know them as. They're like Learjets.
Okay, they are jets.
Well, what happens is the needs of Cheyenne Mountain there, they bring a lot of people in and out for sensitive things. And so they use this small fleet. Once again, 20 pilots is not a lot. But they
the gentleman from Georgia provided me a picture, so I'll yield back, Chairman.
Okay. All right.
And Mr. Chairman, if I could follow up on that, my understanding is that the Air Force likes the C-21. They're all going to be upgraded. There's not a lot of them, maybe 20 or so. They're going to have the avionics upgraded. But my thought is rather than do them all at once, do it in kind of a sequence where you don't lose experienced pilots. Space it out over 2 or 3 years instead of calling them all to one base at one time. And then you have to start paying contractors to do what your pilots, Air National Guard pilots, were doing.
Yes, sir. Thank you very much. We appreciate you taking time, Mr. Lamborn, and thank you for your service from Colorado Springs.
Thank you,
We
committee.
appreciate you very
Thank you.
much. Yes, sir. Mr. Barr, welcome to the Rules Committee.
Chairman, members of the committee, thank you for the opportunity to present my amendment to Division C of Rules, Committee Print 115-30. This is an amendment to increase funding to the General Operating Expenses Veterans Benefit Administration by a simple $5 million for the express purpose to increase funding for the Department of Veterans Affairs Adaptive Sports Grant Program. This grant program provides needed resources to evidence-based equine-assisted psychotherapy programs, which helps treat veterans suffering from unseen psychological wounds, such as post-traumatic stress disorder, military sexual trauma, and traumatic brain injury, just to name a few. As this committee knows, many veterans are vulnerable to becoming isolated and withdrawn as they try to manage their trauma experience. After repeated exposure to danger, veterans often develop excessive levels of stress, which frequently alters the normal stress response in the brain and produces a lifetime of functional impairment and difficulty managing intrusive thoughts, memories, and emotions. In addition, veterans who experience these types of treatments often withdraw from family, friends, and their environment to manage their distress. As a result of this, roughly 20 veterans a day commit suicide nationwide, according to data from the Department of Veterans Affairs. Risk of suicide for veterans is 21% higher than civilian adults. But there is successful therapy and treatment available. According to the American Hippotherapy Association, and by the way, hippotherapy is a physical, occupational, or speech and language therapy treatment strategy that utilizes equine movement. According to that association, the Professional Association of Therapeutic Horsemanship International, PATH, formerly known as the North American Riding for the Handicapped Association, Equine Assisted Psychotherapy, and the Equine Assisted Growth Learning Association, and a number of other certified therapists in the 6th Congressional District of Kentucky, whom I represent, Equine-assisted psychotherapy offers measurable outcomes in treating numerous mental health disorders. This is evidence-based. The equine psychotherapy has been evaluated, has been assessed by scientists, and has been studied. And the results of studies suggest that equine therapy is a promising treatment for PTSD and PTSD symptoms in veterans, and that equine therapy may be effective for other mental health problems such as depression and anxiety, improving social functioning and enhancing quality of life. The results of this study would need to be replicated and examined further, but the Journal of Traumatic Stress has also come to this conclusion. We found evidence that equine partnering naturally approach to equine-assisted therapy may be an effective treatment for anxiety and post-traumatic stress symptoms. According to the Department of Veterans Affairs, the current mental health numbers reported by the VA reveal an agency under siege. There are over 100,000 veterans currently seeking help for mental health issues. 52,000 veterans are seeking treatment for post-traumatic stress disorder alone. What I've observed personally, Mr. Chairman, is that in my district, veterans who are suffering from post-traumatic stress have been out to the Kentucky Horse Park, have experienced therapy from Central Kentucky Riding for Hope. In New York and in South Carolina, an organization called the Saratoga Warhorse has successfully treated many veterans. And what the veterans who have gone through this therapy have told me is that they sense peace in these animals. It creates a deep emotional connection that opens them up, that allows them to reconnect with others. It creates a bond between the warrior and the horse, and it has results. And anything that we can do, especially something that doesn't cost a lot of money, that can help these veterans avoid suicidal behavior, that's what we need to be investing in. So it's a simple amendment. It's a small thing we can do, but as the co-chairman of the Congressional Horse Caucus, someone who cares very deeply about our veterans, I think that increasing just in a minor way grant funding opportunities for this evidence-based equine-assisted psychotherapy will greatly improve the needed mental health treatment resources for our veterans. And with that, I yield back and be happy to take any questions.
Mr. Parr, thank you very much. Back in Dallas, Texas, actually in Rowlett, Texas, we have eQuest, which does essentially the same functions that you've talked about, including hiring a full-time former military sergeant, I believe, who actually brings these veterans in, finds not only great results, but long-term their success to keep them away from some of the frailties that happen with these difficulties of necessary head injuries and other things that come from their service to this country. Thank you very much. Ms. Polis?
I strongly support the amendment. Just, two ideas for you to look into since you're working on this issue. One is to make sure that if horses are retired from equine therapy, that they're adopted out and they're dealt with humanely. And second one is we have a surplus of wild horses in the West, and we have a lot of issues around the humane treatment of those. There's been threats that some might be killed that are currently detained. So I think if there's a way where we can link up, and I know it might be more difficult to have an older horse become a therapy horse, but at least some of the foals or young horses from our wild herds as part of our herd management, maybe we can get those assigned into the equine-assisted therapy program, providing for free horses as well. So I'm hoping that you can work on those two. I'm happy to work with you, and I support the amendment allowing it, and I will support it as well. Would you? I yield to the gentleman.
Well, I appreciate the gentleman's comment because, in fact, ESPN has done a little vignette on this, has reported on this, and one of the takeaways from ESPN's reporting on this is that, in fact, the gentleman is absolutely right, that many of these retired thoroughbreds and other horses are themselves in jeopardy.
Good.
And the emotional connection between those retired horses and these wounded warriors is in many cases therapy for both parties. Mm-hmm. So I think there is opportunity. I'd be happy to work with the gentleman on that.
Thank you, and I do appreciate also, as you indicated, some retired racehorses, others that this is a very humane way for them to live out the rest of their time, and as it would be for some of the wild horses as well. So I strongly support the amendment, and I yield back.
Gentleman yields back his time. Is there any other member of the committee that would seek time? Gentleman from Louisville,
Chairman,
Texas.
just an observation that on a previous NDAA with TRICARE, we did a similar amendment, and as I recall, it was successful. So, and like the chairman, I have several providers in my district as well. So thanks, Mr. Chairman. Thanks for considering it, and I'll yield back.
Mr. Newhouse?
Thank you, Mr. Chairman. I would just like to thank the gentleman for bringing this idea to us. The 20-plus suicides a day in the veteran community, that's too many. And anything we can do to lower that number, eliminate that number, is something we should consider. So I support the gentleman's amendment and thank him very much.
Thank you, sir. Mr. Barr, thank you for taking time. I know that you approached me on the floor with an indication that you'd try and be here around 9 o'clock. It's now 11:22, so the gentleman almost qualified for extra pay today.
Thank you, Mr. Chairman.
If you'll please tell your wife I'm sorry that we intervened in the call home tonight.
Will do, Mr. Chairman. Thank you.
Tell her you were busy.
Will do. Thank you.
Great. Mr. Perry, thank you for joining us. Gentleman's recognized.
Thank you again, Mr. Chairman. I have several amendments because this is the security bus, so there are several components, and I have amendments in each section, which I'd like to discuss, and I'll go through as rapidly as I can. None of us want to be, and I don't need the extra paycheck for staying over, Mr. Chairman, as Mr. Barr may.
He might ask for it, but he won't get it.
I appreciate that. 105 prohibits the use of funds to establish a Space Corps. And not that I'm necessarily opposed, it's just simply a circumstance where I feel like members, including myself, aren't completely informed, and I'm concerned in hearing from the administration, although we're a separate branch, as we should be making separate decisions based on the information that we have, but the administration and the Air Force in particular is not in favor of this, and I'm concerned that this is more a management issue than anything else, and pardon me, but having served for over 35 years in uniform, I find this to be a big deal that we're just creating a new branch in the military with very little fanfare and from at least this representative part, little information and little discussion. Moving on, 106 prohibits the use of funds for medical treatment related to gender transition, and I listened acutely to the conversation previously, and I just want to bring up some points in this regard. This amendment is slightly different than Ms. Hartzler's previous amendment, but it's along the same lines. And I just want everybody to consider a few things. We are blessed in our country by a whole host of people from all kinds of different backgrounds that want to serve their nation in uniform and potentially go into harm's way and give their life if necessary. And that indeed is a blessing, and it's an all-volunteer force. With that, many people are excluded from serving for a variety of reasons, from flat feet, from not being able to see well enough. There are psychological issues, there are physical issues, et cetera, et cetera. And we got to make sure that we maintain a standard here. The military has never been, at least in the United States in my time, and I think before my time, about the individual. We all have individual needs or wants. We might want to grow our hair longer. We might want to show up at 9 o'clock as opposed to 6 o'clock. The point I always made to my service members and soldiers is it's not about you. It's about this mission. It's about this team. And we're all doing it. We're all wearing the same hat. We're all wearing the same boots. We're marching the same way. We're eating the same food. And we're focused in the same direction. While some folks might want to join when they have these earbuds in that expand their earlobes, we say, God bless you. Please join, but that's your job to get that fixed before you join. And you can't do that after you join and be in uniform. If you have a neck tattoo that comes up above your neckline and comes up the side of your face and you want to join and fight your nation's wars, God bless you. We want you to come. But you got to get that fixed. You have to get that fixed. That's not the American taxpayer's responsibility. That's your responsibility. That's what we're talking about, ladies and gentlemen, is just establishing and maintaining a standard. There's a lot of reasons for it. Cost is one. Order and discipline is one. Capabilities are one. I will tell you, if you are a commissioned officer that has come to the end of your time as a commissioned officer, I'm an aviator by trade, and we have a lot of commissioned officers that are aviators that come to the end of their commissioned service. Maybe they can't stay because there's not a slot available for them or a myriad of reasons, but still want to serve. and they say, well, can I revert to warrant officer, which is a specialist in their field? You're going to be an aviator only. I'm not going to command troops. I'm not going to administer anything. And the command may say yes and may say no. But generally speaking, you will not serve in the same unit that you served in before because there's an order and discipline problem. There are a lot of reasons to consider this, and I would just contend that we don't know enough about this right now, and there are problems. It's not about the individual. God bless them if they want to serve. Mr. Gomez said $3.7 billion over the 10 years. I can think of troops that didn't have body armor. I served with guys that up-armored their own Humvees to try and stay safe. I'm sure Mr. Davidson could tell you some stories. I know right now I look at all these commercials for the Wounded Warrior Project and Paralyzed Veterans of America and all these different organizations trying to take care of our veterans. And I'm thinking, isn't that the job of the United States government to bear the burden of those who shall have borne the battle? That's our burden. And if we don't have enough money to pay for that, then why am I paying for somebody to fix their earlobes or their tattoo? Oh, I'm not. But I'm going to pay for this. We're going to force the taxpayers to pay for this. Ladies and gentlemen, it's about maintaining a standard. It's not about the individual. It has never been about the individual. It is about the mission. It is about the team. It is about doing the hard work of securing this nation and doing it quickly to minimize the loss of life and destruction for everybody involved. And I would just beseech you to consider this amendment and the fact that we were close. I understand your concerns, Doc, but there are members that did not get to vote on it, and they should have an opportunity to. So I'm just going to say that's enough said about that. 107 prohibits the use of funds to conduct or compile any report on climate. And this climate change, and this again was an amendment that we considered. I think there's more information, and I've talked to some more folks about it, and I just want to reiterate that I'm not here to adjudicate or debate climate change, whether it's real, whether it's not, who's causing it, how much, what's the fix is, are the seas rising, is the land subsiding? But I know a couple things. I know that Pennsylvania, one half of Pennsylvania, for 100,000 years sat underneath the Wisconsin ice sheet, for 100,000 years. So somehow we figured in the last couple hundred years, we've determined that the temperature needs to be this right now. And okay, let's even accept that. The question I have is why is it the job of the military? We've got NOAA, we've got NASA, we've got 100 agencies with instruments and scientists and studies and satellites that are looking at this. And to me, the military, the Department of Defense, whether you're in the Air Force, whether you're in the Army, the Navy, the Coast Guard, the Marines, or in the Space Corps, you need to be focused on defeating the enemy. The enemy, as far as I can tell, doesn't have a recycling program, doesn't care about an alternative fuels program, doesn't care about anything but defeating us. And it takes everything that service members have to maintain their focus on their mission. It's why you must have a family care plan before you leave, because you cannot focus on the fight if you're worried about your family, your wife or your husband and your children and your home and your water heater and your lawnmower back home. You must be focused on the fight because the enemy is focused on you. And anything that detracts from that. Ladies and gentlemen, you must know right now that officers every day are filling out forms that spend most of their time evaluating officers on their adherence to resiliency, which is suicide prevention, to don't ask, don't tell, to a whole host of things, EO, and what we call SHARP, or sexual harassment prevention. I filled out an evaluation on an officer who's a combat arms officer who's focused on destroying the enemy, and most of my evaluation is that. I'm left with a couple sentences about their primary duty, which might be artillery, it might be a ranger, it might be an aviator, but whatever it is, it's about defeating and vanquishing the enemy, and I'm spending all my time talking all this other stuff, and it's mandated that I do it. This is another mandate, folks. This is where this is going. So I would just ask you to consider that. All right. Division B, the Ledge Branch 21 abolishes the budget analysis division of the CBO and transfers the duties of the agency to facilitate and administer scoring data compiled by the Heritage Foundation, the American Enterprise Institute, the Brookings Institution, and the Urban Institute to get a full spectrum of the political views of this country. And I would just hearken back to the conversation we had with Mr. Griffith, Representative Griffith. we're getting bad information. We keep doing the same thing. We're spending $40 million a year to do it. This uses aggregators. It's another approach. I understand that this amendment probably won't be found in order, but I think we need to start having a discussion about how we make decisions around here in the information we rely on, and this attempts to provide another alternative. Number 24 prohibits the use of funds to pay the salary of any IT employee who has not undergone a background check by the U.S. Capitol Police. We have folks working that have worked. Well, we have folks that are working now on IT that haven't had a background check. And let's understand, this might not be classified information that they have access to, but it is sensitive information. We don't know the outcome of a current investigation, but I can assure you, ladies and gentlemen, it's not going to be good. It's not going to be good, so let's not wait. Let's not wait until it's right in front of us. There's a problem right now. It's been identified for us. We might have not identified it, but it's been identified for us, and I would beseech you to consider this amendment. Number 26 reduces the appropriation to the Congressional Budget Office, and I picked 50.4% because that is the number that they were out of line by when they estimated the membership in the ACA in 2010 as of 2016. We got to have some metric. They got metrics. That's a metric. 50%. I know when I fail at 50% of my job, every time, and maybe it won't happen in Congress, and I'm sure that there will be members of my constituency that would agree that I have failed at that level, but every other job that I've held, including running my own business, when I failed that much, I'm out. Something's got to change there, and if somebody says, why 50.4%, because that's how much they missed the mark by, and to double down on it, they just missed the mark by nearly the same amount when they evaluated our bill. Moving on, Division C, military construction, the VA prohibits, number 41, prohibits the use of funds to implement, administer, or enforce the Davis-Bacon Act, which was enacted in 1931, modified in 1935. I'm asking for a change in the threshold to require it. It is currently, since 1935, $2,000. So if your federal job requires $2,000 or more to complete it, it requires Davis-Bacon wages. I have earned them. I have paid them. People always say, well, why are you against the working man? I'm not against the working man. I've been the working man. I still own Red Wing boots and dirty clothes because I've worked with my hands down in a ditch. But I'm for the taxpayer. And if I can wiggle the sticks on a backhoe making $18 an hour on the weekend, I don't know why I should be paid $56 an hour because I'm out working on the highway. But folks, that's what we're doing. You want to stretch your VA dollars? That's a place to look. Moving on, energy and water. Number 76 prohibits the use of funds to implement or enforce the final rule published by the Secretary of Energy entitled Energy Conservation Program Test Procedures for Central Air Conditioners and Heat Pumps. Let me be real clear here. I've got a constituency in the district I represent in the city of York that is looking for people to come and build their businesses. This is a manufacturing operation. They build air conditioners and heaters for high-rise buildings in New York City and Chicago. These are retrofit outfits where you got to get into a closet or something like that, right? The old original one is gone and it's never coming back. The federal government requires them to have a test on every single model they make. Every single one is custom made. They're putting these people out of business. This is manufacturing in the heart of an urban center in the district I represent. You're going to put 125 people out of work, and a good company is trying to produce things for our, and this is good. This is good for to modernize the buildings around the country, the high-rises that are trying to modernize their heating and air conditioning, but we're going to put them out of business if we don't do something about this rule. Number 80 increases funding for EERE by $15 million and decreases funding for the Department of Energy, Departmental Administration by the same amount. And it's just to let you know that hydropower is available in every region of the country. It accounts for 67% of domestic renewable generation, 7% of the total electricity generation, and will create 1.4 million new jobs by 2025. I don't understand why hydropower isn't sexy. I know wind and solar is, but I know hydropower is baseload energy. The wind doesn't have to blow, the sun doesn't have to shine. It just sits there and runs all day long, 24 hours a day, 7 days a week, and we snub it. We turn our noses up at it. I will let you know that there are 80,000 non-powered dams in the United States. 600 have immediate capability to produce energy right now. Pennsylvania alone has 678 megawatts of untapped hydropower. If we want to do something for renewables, think about hydropower. You don't have to get rid of the solar panel and figure out all the heavy metals and all that stuff in it. You don't have to erect all these wind towers and hope the wind blows. The fish swim through it, by the way, because people are concerned about the fish. And I said to the people that make these things, well, how do you get the fish through? They said, well, it used to be the turbines spin fast, right? And the fish couldn't make it through. Now the turbines are big and they move slow, and the fish swim through, and they might get bumped by the blade, but they just swim through. Folks, we're missing a great opportunity here, and I just want to advocate for one of the original energy sources on the planet. We have perfected it. We should be embracing it. It should be as sexy as these other things. Chairman, I appreciate your indulgence in this late evening. I tried to talk fast so I could get through this. I entertain any and all of your questions, and I yield.
We stayed up late to hear from you. I enjoyed it. Mr. Polis.
Mr. Perry, you've been very prolific in your amendment writing. I have questions about several of them. On the Space Corps one, it's my understanding that this is a legislative proposal that Mike Rogers and Jim Cooper have been working on, and that this is not something that anybody is afraid somehow the president would create without our approval. I mean, is your fear somehow the president would somehow do this without legislative approval?
No, and I thank you for the question. I don't really have a fear. I have concerns. I know it's my job to learn about this. It's come pretty quickly from a person who's not on the committee. I am going to talk to Mr. Rogers about it, to Representative Rogers, Chairman Rogers about it. I hope to do that tomorrow. My concern is that we haven't explored all the options, and for a person who has seen, quite honestly, at the upper echelons and management in the military, a fair amount of mismanagement, it seems to me, from what I've seen, that there are facilities and structures in place to focus on this, and I'm not sure creating a new corps. Just think about a new corps. Everybody's got to have new uniforms. We got to have a new building. It's going to be competing for resources and so on and so forth. When we already probably have the assets available to deal with the issue at hand, and I acknowledge the issue at hand needs attention. I will acknowledge.
Yeah, and to be clear, I have no opinion on this either. It's something I would want to learn about. It's a legislative proposal. Like many legislative proposals, it has an uphill battle, and you will be part of that debate about it, whether it would pass. But a funding prohibition about something that hasn't been authorized is kind of putting the cart before the horse there.
This is my opportunity. I get that so the NDAA is working its way through, but by the time that happens, this will have been passed. So now is my opportunity. I appreciate that. Yeah. I had trouble even naming the amendment because the Space Corps doesn't exist. Yes, yet it does in the NDAA, which has preceded this.
Yeah, and this is a long way. There is a long way from a Space Corps existing, is the point, and I think it needs to be duly deliberated by Congress. You know, a funding prohibition, a blanket funding prohibition against one that doesn't yet exist would be a little bit premature. But I understand your concern with the Space Corps formation. I don't have an opinion one way or the other, to be clear. I encourage you to meet with Mr. Rogers and Mr. Cooper and to voice that. I do want to move on to your other amendment with Mr. Gomer. I want to extend the same invitation to you that I issued to Mr. Gomer. I want to see if you'd be willing to meet with some transgender veterans.
I will.
I
had
Thank you.
Served, just to let you know, probably 25 or 30 years ago with a DOD civilian who previously served, who was transgender back then. Yeah. The question is it the taxpayer's responsibility? When should that happen? Prior to entering service or after?
And do you have a source for your dollar figure you threw out there? I believe you said $3.4 billion. Okay, just so you know, there's been only one study that I'm aware of about the cost of transgender health care, and it was done by the RAND Corporation, and it said $2.4 million to $8.4 million. So there's several zeros less than your figure. Would appreciate, any information on the provenance of your figure. And just so you know, the American Medical Association, the Psychiatric Association, the American Psychological Association all agree that transition-related care is medically necessary, not elective or optional. So, I mean, again, when you're talking, it's not like a tattoo, or I think you compared it to an earlobe. Obviously, this is your gender, my gender. I assume you're a man. I'm a man. That's a pretty simple concept. It's not analogous to being flat-footed, which is obviously a disability, or to a tattoo or an elective procedure. Again, that's not my judgment, and this is the American Medical Association, Psychiatric Association saying it is elective, not optional. So, I mean, again, I think we need to avoid these kinds of social engineering where we're saying, sorry, you know, medical professionals and associations, we politicians know better.
But
we're going to
with all
impose
due
it on you.
respect,
Happy to yield. Yes.
This is our job. The one great thing, one of the many great things about America is we're not run by the military. The civilians run the military, right? We're in this uniform, not that other uniform, and I respect that as a person who has been privileged to wear both. So these are our decisions, and I would just, and again, once again, it's not about the individual, it's about the cost, it's about efficacy, and it's about when. I had a young gentleman just came to my office within the last month who's desperate to join the military, and you can picture this 18-year-old young man, strapping, strong. He's the guy you want to carry the squad automatic weapon, for those who know what that heavy thing is to carry around, right? He cannot join because he has a slight peanut allergy. He's barred from enlistment, and there's nothing I can do about that.
Yeah, again, one's gender is not analogous to a peanut allergy. I mean, they're different things. Everybody has a gender. You have a gender, I have a gender, we all have genders. Peanut allergies, the military...
The question is when you change and who pays for it.
Yeah, well, look, I mean, in this case, inclusion of transgender individuals in the military is not a special accommodation. It actually is an implementation of the merit-based policy. It's simply applying one set of rules to everybody, and that is a reasonable thing to do. It would improve morale, and we should not we should not try to circumvent the judgment of the medical professionals.
Can I just add one thing? As a person who has had the training, I've had the level 2 and the level 3 training. I've taken that within the last 2 months. When you talk about morale, as a person who wears the uniform currently, I can tell you that it is a morale issue. I have witnessed it personally during the training as a firsthand observer. So I'm not sure where your metrics are coming from and how you gauge morale, but I can tell you as a firsthand witness, it has created morale issues, and I suspect it will continue to.
Yeah, and I just want to, share for my colleagues that most of our foreign allies, 18 foreign militaries, allow transgender troops to serve and support them. None have reported any compromises to readiness. Transgender troops have served under American command in many theaters, and the American Medical Association, joined by 4 former U.S. Surgeons General under both Republicans and Democrats, said there is no medically valid reason to exclude transgender individuals from service in the U.S. military. And of course, the hormonal.
We're not talking about them not serving.
Well, you are, because the hormonal treatment is medically required.
But you might also be medically required to have treatment or have treatment available if you're allergic to bee sting. Right?
And I don't know what the military's done with respect to bee stings, but again, whether people who have bee allergies can serve or not is not material. Every single member of the military has a gender. We're just saying treat everybody equally. It should be merit-based. Whatever gender you used to be is not relevant. You can serve. You're the gender. If you need hormonal treatment, you get it just like... But by the way, there's a whole subset. We hear me when I talk to Mr. Gomer.
Yes.
There are many more costly conditions that are not being singled out here, that nobody is debating that the military should, of course, be able to support members of the military that have. So this is clearly being singled out for some reason. It has been defeated on the floor. I hope we can defeat it again. We'll share our cost figures with you. You can share yours with us. We're happy to set up a meeting for you as well, and we'll see what happens. I did want to get to one of your CBO scoring ones if I have a moment as well. If it's my understanding that clearly you don't like the CBO, I get that.
It's not about not liking it. I just wish it were accurate so we could depend upon it.
I think one of your proposals was to outsource it to several other groups that you named.
Yes, absolutely.
So they would submit scores?
Yes.
And would there also be a score from our own group?
Could be, absolutely.
Yeah. Well, I mean, outside groups are already allowed to submit scores. I mean, they can tell us it costs this or that. I just cited the RAND Corporation's estimate of the costs, and I look forward to your citation for whatever you thought the costs were with regards to the medical treatment of transgender troops. But the one thing that's good about having a Congressional Budget Office, love it or hate it, Democrats or Republicans, is that at least we have one set of facts or figures to go off of. And their methodology is such that they're supposed to, and I think they probably do, go with, they have a broad band, and then they circle down and sort of, this is the likely range. And so they can provide that information to us. We don't have to listen to it. You can, if you don't like what they say, you can say, I disagree, I think it'll cost less, therefore I'm voting for it. It factors into, in this committee, our budget and our rules, but we can, and we do, waive things routinely. So, I mean, I think it's a value, so that's why I oppose these efforts to kind of eliminate it. I don't want to say you seek to eliminate it altogether, but clearly cutting their budget in half and outsourcing part of it would all but eliminate it. I mean, maybe they'd be able to score a few things, but not very many. Frankly, as an individual member, I have trouble getting scores on any of my bills. I wish they were able to score my bills more. I know they score leadership bills. So I don't know if that's the right answer. I think it would be good to get under the hood. If there's a problem we have with their methodology, let's send them some directives to fix it. Be good, rather than pointing out one prediction in isolation that was off, I think you said by 51%, we should look at 100 of their predictions on bills that we actually passed and see how they did. I mean, one doesn't mean much. If they might have been over 50 on one, under 50 on one. If they were exactly on the other 98, they're pretty darn good. I don't think that's the case. But I think that we should look at the bell curve of where they were. It's not of particular relevance to cite, one case where they may have been off. But I would look forward to an evaluation. And if there was it would take a very small amount of funding to do that. So I would encourage you to kind of move in that direction and say, why don't we take a look at whether they're right or wrong in the last 100 things that they scored that became law. Maybe we could even work with your office to request that absent anything that we put into the budget. But I think that would be the best way to go about figuring this out, as opposed to just this kind of big blow.
Appreciate your perspective. I'm not going to belabor the point.
Go back.
Gentleman from Alabama.
Yes, sir. Mr. Perry, I really appreciate your hard work on all of this, and I supported your amendment a couple weeks ago, and hope this one's made in order so I can vote for it again. I want to talk to you about Space Corps.
Yeah.
I know you're going to talk to Chairman Rogers. I strongly encourage you to do that. Let me encourage you to do a couple of other things. We had a classified briefing last week on where our adversaries stand in space.
I'm well aware.
If you haven't had that, please, you can go get it yourself. They'll do it for you individually. Given your background, you will come to a very quick conclusion about the level and extent of the threat to the United States and where we stand.
And I don't dispute it at all. I agree wholeheartedly.
The second thing that was an eye-opener to me last week, this was not classified, we had a meeting with folks from GAO, and they went through the history. I knew a little bit of this, but I didn't know the whole of it. They gave us a history of how long this topic has been around about how we should manage space from within DOD. And you'll find that the idea of a Space Corps is not new. It's been around for 15 years. It's been discussed, and there have been hearings on it inside our subcommittee, the Strategic Forces Subcommittee, for a long time. Now, I'm new to that subcommittee. This is my first year, but long before I got there were hearings. This didn't just pop out of Jim Cooper's mind or Mike Rogers' mind. This is something that's been going on for a long time. I heard a former chairman of the Joint Chiefs of Staff say something that startled me, but after I heard this a few years ago, I've taken it to heart. He said, sometimes you have to make us do what we ought to do. Sometimes a civilian, you just said that earlier, has to make the uniformed people do what they ought to do. If you look at that threat that you'll see in the classified briefing, and you go through that GAO report, or even get the GAO people to sit down with you and walk you through how long this has been going on, I think you see that we're past time for needing to do this. And I understand Air Force has a different view about it. Quite frankly, this may be one of those times when we need to make the Air Force do what it should have done long ago. And I think you'll come to the conclusion.
I look forward to informing myself.
This should have been done a long ago.
And I appreciate that. And I would just say that if someone like me is misinformed about this, while the committee may have gone over it for a long time, and maybe it's 15 years in the making, the fact that general membership in Congress is somewhat ill-informed concerns me. And this is my one opportunity. Just like Mr. Polis said, it's kind of the cart before the horse, but the horse is already, in my opinion, to a certain extent out of the barn.
This is the way Congress works. We have committees. There's a lot that comes through these various committees that I don't know anything about till they get here. Frankly, I get whipped on things that I didn't know about 24 hours before the whip. And then I got to go become an expert on it in a short period of time. We're all required to do that here. Okay? It worries me sometimes that we get things on that basis, but that's how it works. So it puts a burden on us to do our homework, and I get you. When you drop into these things cold, it's hard. I know a lot more about health care than I did at the beginning of the year, trust me, a lot more. So I would ask you to do that with your background, because I think once you apply your background to that information, you're going to see that this is something that we should have done a long time ago. And I yield back, Mr. Chairman.
Gentleman yields back. It's time to enter the member, Dr. Michael Burgess.
Yes, Chairman, I certainly want to thank the gentleman for his work on all of these amendments and his very thoughtful presentation. You've heard some of my concerns earlier.
Yes, sir.
I still have those, but, Mr. Chairman, I think we ought to make all of the gentleman's amendments in order, even the ones that I disagree with. I have disliked EERE for a long time, but I would even be willing to go with your thoughtful presentation of the energy efficiency and renewable energy portion of the Department of Energy. Maybe you've got some thoughts there that had not occurred to me before. So I encourage the committee to take up Mr. Perry's amendments, and I appreciate him bringing them tonight.
Big fans up here.
Thank you, sir.
Appreciate your time. If you'll please make sure you leave your whatever you brought in writing for the oral stenographer to enable her to decipher that. Thank you very much.
Yes,
hope you have a good evening. See you tomorrow morning. Mr. Hurd, gentleman's recognized.
Thank you, Mr. Chairman.
Require the Secretary of Homeland Security to submit a comprehensive border security strategy to Congress before any appropriated funds are used to plan, develop, and construct physical barriers along the United States-Mexico border. I know I don't have to remind y'all, I have more border than any Congress, 120 miles.
I spent half my adult life chasing bad guys around the country, around the world, excuse me, and having a one-size-fits-all solution to border security just doesn't make sense. If you're going to spend $24.5 million a mile on a third-century solution to a 21st century problem, it makes no sense. With existing technology, radar, LiDAR, sensor, cameras, long-range sensors, we can deploy a suite of technology along the border that detects a threat, tracks a threat, until we can use our most important resource, our human capital, men and women in Border Patrol, to interdict that threat. You can do that for under $500,000 a mile. So let's play this out. 2,000 miles of the border, 650 miles. Sorry, I know it's late. I'm doing a little bit of math. 650 miles of existing fencing, that's 1,350 miles. If you you multiply that by 24.5 million, that's $33 billion. If you use a technology solution, $500,000 a mile, that's $675 million. I know, I'm sure Chairman Cole on the Appropriations Committee could find something good to do with $32 billion. One of the problems we've had with border security is we have a problem in San Diego. We address it there. The problem moves to Tucson. We address it there. Then it moves to RGV. We address it there. The two layers of fencing we built in San Diego, people are tunneling under it. So you got to put more money into anti-tunneling. Bad guys are going to respond to what we do. We can't have a one-size-fits-all solution. And that's all I have, Mr. Chairman, barring any of y'all's questions.
Thank you for taking time to be with us. Mr. Polis.
Yeah, thank you, Mr. Hurd, for your thoughtful approach. You know, we had our colleague, Mr. Carter, was in here earlier, and he had a specific kind of wall that he wanted, and it was only in a few places, and it was very, very expensive. It was, $1.6 billion. I think, having a comprehensive border strategy makes all the sense in the world. And I think what you're telling us is we can do more with less. Is that kind of the bottom line? You think we can do more with less?
100%.
Yeah, I mean, that's a win-win.
Border security matters. Mm-hmm. It's 2017. We should have already gotten operational control of our border. We are not using high technology the way we should, and we're not deploying our men and women in Border Patrol the way we should.
Yeah, no, I mean, if another country was paying for it, we'd say let's charge them a lot and build a real expensive wall. But is it your understanding that any other country is going to pay for this wall, or will it be American taxpayers?
We will be paying for it.
Yeah, and so I think we ought to try to do more with less, and I interpret the mandate that way. I think that, again, is a reasonable interpretation of the mandate, given that if another country is paying for it, we'd all want a big fancy thing that put a lot of Americans to work, and we could just keep building it, and it'd be great. You'd put a lot of jobs in there, but we are paying for it, and so I think that's important. And there's technology, you know, and what Mr. Carter was describing to me in my mind, I was picturing something from the 1950s or 60s. Like that's like the wall. I mean, it was like piping and there was like concrete. And I mean, that's the kind of wall that, you know, existed, for a century. So look, you know, times are new. We can do more with less. I support the amendment. I think it's great. It's a great approach. It's bipartisan, makes sense, fulfills the mandate of the people, and I support it, and I yield back.
Gentleman yields back. Further questions from the committee?
Yeah.
Oh, quickly, Mr. Cole, I thought we were pointing.
No.
It's late.
It is late.
I thought I'd forgotten something.
I want to be very brief, but there's frankly nobody I respect more on this than the gentleman from Texas, and because he says he knows it, he lives it, and he's got a security background. So he's a lot more competent to comment on this than most of us. So I'm going to ask you just three quick questions. One, looking back, and I'm not trying to do this in a partisan sense, but you know, I had the impression that, well, I want your opinion as to how seriously the last administration took this issue. Did they make progress on this issue? Were they doing the right things? Or was, because this has become so politicized, it's just very difficult to have a logical discussion about it. It gets caught up in other issues. So I'm curious about how they did. Second, I want your opinion. I have a very high opinion of General Kelly, so I'm curious as to what you think. And then last point would be, in some ways, if we got this out of the political arena, because I really do believe Democrats and Republicans all want secure borders. I don't see that as a partisan issue. The immigration issue does get partisan. We have different points of view, but secure border, secure border. We want a secure border. So would you trust General Kelly? And look, I understand he works in an administration, but you know, I would like to get a group of like really super competent people on this issue, almost, and if there was a way to do it in a bipartisan way, I don't mean a study, but I mean people that we could, okay, come back to us with a plan that can create some political consensus here. You know, I can see the whole appropriations process, $1 trillion+, the funding for the military, getting caught up on this border wall issue in the next 6 weeks. And it's going to be highly charged politically, and we're not going to care a damn about the rest of the government. It's going to be a fight over $1.9 billion over an objective that we agree on, i.e. securing the border, holding up funding and jeopardizing funding for defense, for National Institutes of Health. So what's the political way or the thoughtful way to create consensus instead of division? Because what we've got now is division and rhetoric.
I'll start with the last question first. Listen to the men and women on the ground. They know every mile is different. And so let them determine what tool they can use in order to do their job. In some places where there's urban to urban contact, having a physical barrier is important. When Border Patrol bases their response time in seconds to minutes in highly urban areas, a physical barrier is actually a barrier. When your response time in some areas is measured in minutes to hours, a little more problematic. And then in remote areas, Border Patrol measures their response time in hours to days. When you're measuring response time in hours to days, a wall is not a physical barrier. So listen to the men and women in each sector and let them come up with the tools that they need and the design on how to defend that part of their border. Your second question, General Kelly does understand this. He understands the importance of intelligence. We should be increasing the amount of intelligence on the kingpin human smugglers, the narco-trafficantes, before they're coming in. The Coast Guard's a perfect example. Coast Guard is only able to action 30% of the known intelligence on drugs coming into our country. They're only able to action 30% of known traffic because they don't have enough cutters, they don't have enough people. That's a much better use of money when we're already targeting known intelligence. And so Secretary Kelly understands this. Secretary Kelly understands that the Santa Elena Canyon and Big Bend National Park is already a physical barrier. Lake Amistan, which is a 21-mile lake, is already a physical barrier. He understands this. If we allow the practitioners of border security to do their job, we'll be much better instead of taking political dictates. In the last 8 years has been problematic because the last administration was using a one-size-fits-all solution to border security. We can't just change the solution and believe that's going to fit across all 2,000 miles. We have to change the strategy on how we look at the border, and we have to look at the entire border at the same time, and we have to have a plan. Is $1.5 billion a down payment on a $33 billion project? Nobody knows. All right, so we should have this conversation in advance. And there has already been many of the men and women in Border Patrol that have talked about each sector and what they need. For example, El Paso, 300 miles, only has 60 miles of persistent technology cameras out of 300. And that technology is 20 years old. That's just outrageous. So I think I hit your three points.
Very helpful, and just closing observation. I think, rightly or wrongly, and again, I don't sit on the committees of jurisdiction here, but I think the sense of failure in the last 8 years, well, let's go back, the last 2 administrations, let's be bipartisan in this, is what drives stuff like the wall. It's just the frustration that government has not gotten the job done. And, for whatever reason, we have border crossings down. We have invested in the supplemental, I think, in broadly wise things, more personnel, things like that. But the gentleman brings a thoughtful approach. But I think we're going to need that, because I can just see the political fight coming, and it's not going to be one that generates much light, but it's sure going to generate a lot of heat, and it's going to jeopardize the entire budget of the United States. Each side's gearing up on this. It's clear. They need to sit down and talk to one another. Listen to my friend. Yield back.
Thank you. Gentleman yields back. Any other members seek time? Gentleman from the state of Washington. Mr. Newhouse.
Thank you, Mr. Chairman. Mr. Hood, I appreciate your thoughtful approach to this. I think it makes a lot of sense and something we should do more of. But just wanted to clarify, I think I heard Judge Carter say that the 3 areas where these new barriers will be constructed were recommendations from the CBP, that they did actually tell us that there are areas that need the kind of improvement that are being prescribed for these areas. So could you comment on what you know about that?
Being told how would you build a wall is a very different question of what do you need to secure the border. 14 miles of border in San Diego. It's already double fencing, excuse me. And this is where the prototype wall is being built. There's 28 miles of levee wall in Rio Grande that adds an additional environmental protection, and then there's 32 additional miles within new miles within the RGV sector, Rio Grande Valley sector. There's a discrepancy of where those miles can be built versus previous assessments that gave men and women in Border Patrol to say, hey, what do you need in your sector? So previous assessments have said maybe there was a need for about 18 additional new miles. If you look across the 2,000 miles of the border that doesn't have existing fencing, there's about 47 miles that men and women in Border Patrol at the various sectors have said some additional type of physical barrier would be valuable. Okay. And the point on, we should be talking about a smart wall. We can put sensor technology that differentiates a bunny rabbit from a human. We can deploy a handheld drone to detect that threat. We can track that threat until we're able to deploy our Border Patrol. 75% of that process can be done using computer vision, artificial intelligence, and machine learning, which allows us to have our men and women in Border Patrol focus on only the thing they can do, interdict. And that's the smart wall that I think we should all be talking about, and it's a fraction of the cost of building a 30-foot-high concrete structure that takes 4 hours to penetrate.
Thanks for your thoughtful approach on this. I appreciate it. Thank you, Mr. Chairman.
Mr. Hurd, as you know, I've lived on the border a good number of years of my life, been down the border a good number of times. I think I have a pretty good handle on not the current day-to-day operations, but rather what has been in our history. I think what they're proposing is well short of the entire matter that the President spoke of. I think the amount of money that they're talking about for then getting a plan together is appropriate. But I agree with the RGV portion because of the heavy population. And I've been down there, and I think what they're trying to do is take feedback from the officers to where there will be gaps. And they can put their officers there and intersperse them throughout. But, you know, if you go down there, I mean, the river's right there. It's deep. They're jumping in the river. They're doing dangerous work to pull people out, to keep families from drowning. It really is, in my opinion, the right thing to put a high fence up to where people say, I can't get there from here.
Then, Mr. Chairman, let's
I
get
don't
rid
know
of the
that it's
carrizo.
entirely a bad idea.
Let's get rid of the carrizo cane in RGV. That would aid in Border Patrol being able to see where the threat is coming from.
You and I agree with
let's
that.
increase the amount of intelligence that we're collecting on the narco-trafficantes that are operating over there.
I don't.
We also need to
I think
improve.
we should do that also. All I'm
Right.
saying is I have been on that other side and looked at our side, and that is, it looks attractive. And it does not always look difficult, but it's treacherous in certain parts of those Resaca's down there. All I'm saying is I was not unpleased to see it be a piece that the president said I could go for that. And I think we're getting through a difficult thing, billions of dollars short of just agreeing to the whole thing without knowing what we're doing. So I want to thank you for taking time. I think that the day we are not listening to somebody that understands protecting this country, we're going to be in trouble. And it's my hope that you continue coming, not only coming up here, but lending your voice to support, to do the right thing. I want to thank the gentleman very much. If you please make sure you leave anything.
Thank you, Chairman.
I appreciate your help. Thank you very much. Did you bring your son up with you?
I did, Mr. Chairman.
You want to introduce him real quick to the committee?
Committee, this is my son, Zach Davidson. He's a senior in high school. This might be the longest he's sat still in perhaps his lifetime.
Good, good. The gentleman's recognized. Glad he's here.
Mr. Chairman, thank you. And committee, I thank you for your work. It's nice to see so much of it in this block. My amendment, Amendment 104, is critical for ensuring that Congress reclaims its war-making powers by prohibiting funding for U.S. military operations in Yemen that have not been authorized yet by Congress. You'll recall that I had a similar amendment to this year's NDAA, adopted in block package, which tied the use of funds in Yemen to the 2001 AUMF. I am, however, concerned about any U.S. operations in Yemen that are outside the mission of defeating al-Qaeda, as already authorized. Yemen's Houthi forces are Shia and are diametrically opposed to the Sunni al-Qaeda forces in Yemen, otherwise known as AQAP, al-Qaeda in the Arabian Peninsula. The primary enemy for which force was authorized under the broad 2001 AUMF is al-Qaeda, not Iranian-backed Houthi forces. The U.S. military does not have the legal authorization from Congress for involvement in this proxy war between Saudi Arabia and Iran. My amendment is very simple. It requires that any use of U.S. armed forces in Yemen be consistent with the War Powers Resolution, including its consultation and reporting requirements. This amendment will ensure that our military does not engage in unauthorized wars or conduct operations for which a clear mission and national security interest has not been articulated. Thank you for the opportunity to testify, and I ask that my amendment be made in order.
Thank you very much. Mr. Davidson, questions? No comments. Questions or comments from the committee, gentleman from Alabama?
I appreciate you doing this. I think you're right on, and I hope that we make it in order. Yield back.
Thank you.
Well, that one vote out of the group's pretty good.
Maybe two.
Oh, maybe two, maybe two.
Well, I enjoyed your long dialogue with Mrs. Lee. I think it's ripe for discussion. I have spoken with now Secretary Mattis about the topic, and I do look forward to seeing the National Command Authority come forward requesting the authorizations that they need to ensure that we are able to defend our country. The War Powers Resolution does provide for that. It provides for immediate responses to vital threats to national security. We did, in fact, face vital threats to our national security before 9/11, and we dealt with them sometimes constitutionally and sometimes unconstitutionally. General Wesley Clark made an issue of that in the 2000 presidential debate when he attempted unsuccessfully to defeat Albert Gore in the 2000 Democrat primary. It's a long-standing issue, and it's well past due that Congress do its clear duty under Article 1 of the Constitution.
Thank you very much. I will just add, because I've probably been around here as long as anybody else, I was worried about our battle in Yugoslavia, the things that we did there. But you know, once again, I think we look back, we still have problems. But
we're still there too, and that's another unfortunate thing.
Lots of battles there, and it was very difficult. I want to thank you for taking time. I hope your son enjoyed this. Being up till late is sometimes fun, but the Rules Committee is always great, I'm sure.
I'm sure he did, Mr. Chairman. Thank you all
We're
very
even
much.
good at 2 in the morning. So you beat the clock. Thank you very much.
Thank you.
Neil, delighted that you're here. Gentleman's recognized.
Thank you very much, Chairman Sessions, and all the members of the very obviously hardworking committee.
Sir, why don't you move over here, and that way you can see us all, and we'll give you a forward-facing seat. That way you can see Ms. Cheney and make sure she's doing the bidding for you. And if you'll grab that microphone, thank you.
It's a more comfortable chair, too. Thank you. I would like to jump right in. Amendment number 135, Division A, which is co-sponsored by my colleagues from Florida, Matt Gates and Francis Rooney, calls for accelerated deployment of instrumentation to collect data from training exercises on 5th and 6th generation weapon systems in the Joint Gulf Range Complex. Currently, lack of instrumentation limits some of the training exercises on advanced weapon systems to only the northernmost portion of the training range. And as you can imagine, this limitation causes congestion in the northern portion of the range from time to time. We have obstructed at least 80 different training missions in the last year, according to a study by the 96th Test Wing of Eglin Air Force Base. Amendment 135 allows the military to utilize far more of the range, which will increase the mission readiness and ensure the Joint Range Complex can meet current and future testing and training needs. Amendment 14 prohibits bonuses for senior executive service employees at the Department of Veterans Affairs. Today, the House debated legislation requiring the VA to submit an annual report on performance awards or bonuses presented to employees of the senior executive service. Without restating all those points that my colleagues made on the floor, it's quite clear that greater oversight, accountability, and transparency are needed throughout the Veterans Administration to ensure that poorly performing or underperforming senior executive service managers are not receiving awards. My amendment would put those bonuses on hold while Congress continues its work to improve the management oversight at the VA. My final amendment is number 19 to Division D. It prohibits funds to implement the U.S. Army Corps' Water Control Manual for the Apalachicola, Chattahoochee, Flint River Basin, which were published on March 30th, 2017. On February 14th, the U.S. Supreme Court appointed a special master in ongoing litigation over allocation of the water in the ACF River Basin, and he found that Florida has been harmed by reduced fresh water flows into the Apalachicola River and Bay. The reduced flow, according to the special master, led to the unprecedented collapse of the Apalachicola Bay oyster fishery in 2012. Further, the special master found that the Army Corps of Engineers operations are a significant and perhaps primary factor influencing stream flow in the system. Currently, the U.S. Supreme Court is weighing options to address the harm identified by the special master, and a decision is expected in the next term of the Supreme Court. Implementation of the revised operations manual, which further reduces freshwater flows into the Apalachicola River and Bay while this case is still ongoing, is, in my humble opinion, irresponsible. This amendment would ensure that implementation is put on hold while the Supreme Court decides the case and provides the Corps with the opportunity to reevaluate its operations based on those decisions. Mr. Chairman, I appreciate the opportunity to share with you the importance of these amendments to the residents of the 2nd Congressional District of Florida And again, thank all the committee members for considering these amendments to be in order. Thank you.
Thank you very much. You've spent a good bit of your evening with us, and you're really to be congratulated. The members that show up here know and understand that they will also learn a lot. And as a new member, I hope that this has been instructive to you to see part of the importance of our members that show up that have fervency to them and ideas, and you've presented yourself very well this evening, and I'm very proud of you.
Thank you very much, Mr.
Questions
Chairman.
from the committee? Gentleman from Colorado?
No, I've just been notified that there's other members planning to testify, and I wanted to make sure that we are holding over the hearing until tomorrow as opposed to closing it. Is that correct, Mr. Chair?
In fact, you're getting ready to find out that we will be here at 2 o'clock.
For hearing.
Be ready for service.
I will be there. Thank you for joining us. I think that we've often given extra special treatment to those who stay the longest, and that's the chair's prerogative. It's up to him, not me. But if it was up to me, I absolutely would applaud your patience, and I yield back.
Thank you very much. Is there any other member of the committee, the gentleman from Georgia?
Yeah, I appreciate the gentleman. I appreciate his willingness to come. Many of his amendments, find no problem with. I do have one amendment, of course, that he knows I have a problem with, and that is number 19. This is a current litigation item, has been for many years. This is a place that Congress has no business in and has not had any business in for years. I appreciate the gentleman and understand why he has to bring this amendment. It is important to him. But it's also, there is some disagreement on concerning what the special master did find and what the special master did not find. This is a tri-state water wars that has been going on for many years, and this is current litigation, it's pending litigation. The states involved, and especially Florida and others, have lost consistently in the courts on this issue. It is still in the courts. And the last thing we need to do is, again, continuing this process of holding up a manual that actually does try to balance the needs of all three. And I understand the gentleman's concern. This isn't, anything except I understand completely what he is trying to do. But I also understand the bigger picture here. And on that amendment would take great disagreement with and would ask them not be a part of this. And I think there's reasons, that not only from what is happening in these three states, it would have effects in western states and other places as well if Congress was to continually involve itself in something that has been litigated to the tune of millions of dollars in these three states. So I would say this is something that needs to be left in the courts, left to the states. In fact, if anything, the three governors of these three states need to find themselves somewhere in a room for a while, lock the door, finish it, be done, and go home. Instead of us continually doing this. But I have nothing but the greatest amount of respect for my friend from Florida, but this has no place in the halls of Congress. Thank you, and I yield back.
I thank the gentleman from Georgia for his words, and as we all know, they're well considered, and I appreciate that thought very much. And by the way, I'd like to add to Mr. Davidson's comments, this is indeed an educational experience.
Okay, I want to thank you for taking time to join us. If you'll please remember that anything you brought in writing for all some stenographers, it would help them out as they complete the record of the transcript today, and I want to thank you. For the opportunity for us to understand that tomorrow we're going to come in at 2 o'clock, all members would be well advised to please come early and come often if that's what they choose to do, but we're going to open up, be ready for business tomorrow at 2 o'clock at the Rules Committee. And then we would expect to complete our work at that time. This completes our work for the evening. Thank you very much.